Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Good morning, everyone.
What's going on, YouTube? Welcome. Today's a special treat for everybody.
Rich Buddy says, bro, it's 5:45 a.m.
You ain't telling me nothing.
All right, everybody. Well, Anthony gets a few things straightened out for us today. We are here with you live. We have a lot going on. The Mitch Westerman hearing starts at 9 a.m. Eastern Time. And the Supreme Court hearing starts at 11. So we're going to be here with you the majority of the day, talking this out.
And figuring
it out. Yes. So what we are going to do is we are going to start out with the Mitch Westerman information. We all know that this case started 7 years ago. It's been an uphill battle ever since the beginning. Not a lot of information has come out. Then we had the Richard Allen arrest. He got 2 defense attorneys, Baldwin and Rozzi. There's been some leaked information with those 2. Not once.
3 separate occasions, right?
Not twice, yep, but 3 separate occasions. That brings us to Mitch Westerman. How is he involved? Well,
he's the third one.
Yeah. How is he involved? Well, he's friends with Baldwin. Andrew Baldwin. Worked for him in the past. Went to visit him one day at his office and decided to go into the conference room where there were crime scene photos laid out on a table. Took it upon himself to take pictures of those photos and then shared them with a friend. Now, was it supposed to stop there? We don't know, but it didn't stop there, did it?
No.
Because it was shared with other people, and then it was shared with podcasters, YouTubers.
And then other people in public.
And then other people in the public, yes.
Mm-hmm.
So that is what brings us to the first part of today. Mitch Westerman was arrested. What is his charge, Anthony?
Conversion.
Yeah,
charged with conversion.
So right now, today, in a few minutes, they are going to have their first hearing. It's going to be just a basic formality of getting ready to decide whether he's going to go to trial or not. No testimony is going to happen, nothing like that. It's just a formality, and that's why they're not allowing cameras in the courtroom. Nothing big is happening.
Exactly. And I did put the request for the cameras in the courtroom. They denied myself and WTHR. So there's nothing, there's nothing substantive that's going to happen on that day. today.
And after reading through that denial last night, we understand why they denied it. And we have hope for the future that when things do start happening, they're going to allow cameras in the courtroom.
Yeah, jury trial. If he takes it to jury trial, I think today we're going to find out if he goes to jury trial or not. That's what they're going to schedule.
Yep.
Man, I'm stoked about this. I'm just like, hey, look, super chats are already coming in.
Renee Days, thank you so much for the super chat. We appreciate it.
Very much so. You know, super chats are always appreciated, and that's how we run these channels, and it's a good way to highlight your comment and get us to answer your comment first. We take priority on those, so thank you.
Exactly. True Crime Beat is in the house. Good morning, Shannon. How are you? She's been putting out some great content lately. Check it out.
It's good to see she's still going.
Yes. She's been doing really good.
Yeah, I've seen that.
Miss Persevere's here. D. Berlin. Yay, you're awake. Yep.
Yeah.
I messaged Anthony and then I called him and he's like, shh, people are still sleeping in this house.
Boy, come here. I didn't sleep. No, I slept.
So, Rich Buddy goes, bro, it's 5:45 a.m. Yeah, it's an early day, everyone. It's an early day. Miranda, what time does it start? So, once again, Mitch Westerman's hearing starts at 9 a.m. Eastern. Devin is going to be there to try to get us footage. So, crossing fingers.
Yeah, he's on his way there, or he should be there. I'm assuming by now. You know, it's I keep looking at the time difference and thinking he ain't gonna be there for a few more hours, but
yeah, no. Miranda says it's 8:46 there, so we got people from every time zone. YouTube user 1:45 p.m. UK, perfect time. Oh my goodness, welcome and thanks for joining us.
Okay, so wow, they're just in the afternoon for the UK.
Yeah, Mark, you made it. Mark and Indy, good morning. Hey, Melissa, how are you doing?
Mark's right down the road.
Is he?
Well, Mark's right down the road from he's in Johnson County, remember?
This says, oh, coffee and crime kind of morning. Yes, it is.
So I just got a message from Becky that they will be attending hearings today.
Good.
I don't know if they're both, but the families will be attending, I believe, the Supreme Court hearing. Maybe Mitch Westerman.
I would believe so too.
Yeah, but
I would believe so too.
I would think they'd like to go see Mitch Westerman in person.
Oh, I would think so too.
I would definitely think Mike would like to have a talk with him.
If you don't have any sound, back out and come back in. I had a glitch yesterday with YouTube where I didn't have sound, and I had to do that a couple times. Good morning, Jinx.
You're up early.
Everybody's up early. Willow Rain. Yes, listening while working. I know what that's like. That's normally me. Labrado is here, so rescue all dogs. You are there at the Supreme Court?
Yes.
Wow.
Labrado's there. William Labrado is there, and he's not even, they don't have anything to do with it.
Well, I'm sure they're chomping at the bit to find out what's going to happen.
And they're friends with Judge Gull.
Yes. CJK, how you doing?
Dude, wouldn't it be crazy if there was just a fight that broke out? Like between the defense attorneys, like the two new ones versus the two old ones. Like I could see that happening today.
Crazy. YouTube user, sound is fine here. Okay. Good to know.
Okay, so I am...
Love to hunt. Good morning. Window replacement on a cold Indiana morning. Oh my goodness, I hope you get it fixed really quick.
Oh man, yeah, I don't want cold windows.
No.
Sorry, everybody. I'm just looking. I'm trying to text.
Oh, good. Kayla got it fixed, so that's good. Jen Cruz, I wonder how pissed Gull is with him. Well, yeah, because in that motion, he kind of went after her. Good morning, Andrea. How are you?
Wow, I don't see anything on Dude today.
Good morning. I'm going.
Who is
I'm
it?
just saying good morning to everybody.
Okay, good morning, everybody.
Nerdy Cat. Good morning, everyone. Following this case since the beginning. 5:56 a.m. here in BC, Canada. Oh my goodness. It's going to be one of those days. We're all going to need like a 3 p.m. nap.
That's right near me.
Yeah.
It's just above me, BC, Canada. Canada is just above me.
Yes, it is.
We're in the same time zone, everybody. Or Nerdy Cat.
All right, so I am just doing one quick thing here.
You do your thing. Mitch Westerman's in court. He's not being talked to at the moment, but I'm hearing that he's there.
I'm making someone a moderator on my channel. So Jen Cruz says I had coffee at 3 a.m. this morning.
I think I should have some here soon.
Last time I tried to make coffee in my Keurig, it wouldn't work. I kept getting an air. Yes. That's when my heat was out and I was so cold I wanted some coffee. And I kept getting an air. I was like, this sucks. Good morning, Mother of Dragons.
So I'm looking for anything and anybody that's covering this today. And it's
all
here.
Right.
So far, no one is covering Mitch Westerman. Correct.
No
right now.
one?
Not that I see any news agencies are live on it. There's no updates from any news agencies when you type his name in.
That's crazy.
And I figured WTHR would be there. They still may. Yeah, I'm not getting anything.
I think they're all at the Supreme Court, to be honest with you, because it's just a hearing.
There it is. There is one. Fox 59 just posted it.
All right, Fox 59, way to go.
Fox 59 just posted it. I'm gonna pull it over. I'm gonna download it and pull it over to our screen for us. That way we can take a look at what they're doing here.
Oh, cheap shit. We understand. You have your granddaughter. Take care of her.
Not a problem, man.
But we appreciate everybody's thoughts and saying, hey, next time there's a trial, if I'm available, we'll go get you guys footage. That would be great.
That is actually a really cool thing that people do for us.
Yes. It is awesome that you guys are willing to do that since we're so far away and we can't be there.
Yeah. A long way. We're a long way away, everybody. Let me see.
Well, you're Seattle and I'm Wisconsin, so.
Wisconsin.
My husband was like, you took a day off and you're up at your regular time? I'm like, yep. Gotta go do YouTube, honey.
It's Delphi time.
I would love to go to CrimeCon.
It's coming to Delphi is what I heard.
Oh, that would be awesome.
You missed it, didn't you? You didn't realize I was talking about. Huh?
I did. It went over my head. It's a little early in the morning. Sorry, honey.
It's all right. Let's see here. I am just looking for a download.
This is kind of weird for me, Greeno. Normally, I've been typing for an hour and listening to YouTube videos, and instead I'm on YouTube. So,
yeah, it's different.
It is.
All right, so I've got that news article that's pulling up in our little video thing on the side here. I'm gonna play it
Here you go, Jinx.
Second. Yeah, there's the email, Jinx. It's just down the street from me in True Crime Investigates.
And I can confirm that a certain individual has been sending me all kinds of information this morning, bright and early.
I do see it. Yep. I see the same things. Okay. Let me pull up this news article real quick. I'm going to play it on the screen, everybody.
Man accused of leaking evidence in the Delphi murders case, the one that really started all of this, is going to be in court now in less than an hour.
This will be a pre-trial conference where they will take a closer look at the case.
Cameron Riddle is in Franklin now at the Johnson County Courthouse with more. Cameron.
Well, that man is 41-year-old Mitchell Westerman. He is being charged with a count of conversion, which is a misdemeanor crime. In the next hour, he's expected to be in the Johnson County Court North Annex here, as he is the friend and former co-worker of attorney Andrew Baldwin, who, as Sierra just mentioned, was part of Richard Allen's original defense team. According to court documents, Westerman admitted to using his phone to take photographs of evidence in the Delphi case without permission while at Baldwin's office one day last October. The evidence included highly sensitive crime scene photos. The court documents say Westerman shared the photos he took with a Fisher's man, who then sent the leaked evidence to someone in Texas, who then forwarded it to all of the different YouTube and podcast creators. The evidence leak has caused a number of problems in this highly publicized murder case, including a judge's decision to remove attorneys Andrew Baldwin from Allen's original defense team. Now, Westerman, again, is due in the Johnson County Courthouse here in the next hour after 9 a.m. Live this morning in Johnson County, I'm Cameron Riddle, Fox 59 News.
Cameron.
Oh, that's interesting.
Right.
So they're live at the courthouse now. They're there. And he's there. And he's sitting in the courtroom now. He's there.
Wow.
So people are saying that they're blown away by the guards and Odinism. Here's the thing, everybody. I can tell you that these guards aren't just Odinist.
No.
All of the white supremacist gangs in prison wear those. They have those triangles. They have those patches tattooed on them and on their clothes if they can. Okay. So it's not just Odinist. It's Aryan Brotherhood. Those different types of gangs they use those same similar type patches. And so it's easy to say they're Odinist when they use the same information and same patches. Some.
Interesting.
So there you go, everybody. So yeah, so check it out. So Beyond the Evidence, people that are on my channel, if you're on Beyond the Evidence channel, that's the link to Facebook, to the page on Facebook.
Yep. So we have a Facebook page and we have a Facebook group.
And you can find the documents on the Facebook group Beyond the Evidence.
Yeah, and I'll give you that link here.
Yeah. Let's see, went and followed. Let's see. How are they permitted to display them, though? I'm not sure what you mean by that. Display what? Nerdy Cat. Hey, thank you very much for the super chat. Greatly appreciate you. Yeah, greatly appreciated.
Greeno is not talking very loud because he's got sleeping people in his house. So it's hard to hear him, that's why.
Do I need to be closer to the microphone?
Yeah.
Okay. 114 people here to see what's going to happen with Mitch Westerman, ladies and gentlemen. I've got the video update for Mitch. If you want to play it, do you mind if I play it real quick?
Yeah, go ahead.
Okay, here's an update on Mitch Westerman, and then there's a little more of an update after that we went over last night. We'll just kind of recap it real fast after this, but here's what's going on with Mitch Westerman. Here's who he is, and this is what's happening.
A Westfield man faces charges in Johnson County for allegedly leaking crime scene photos related to the Delphi murders case. Mitchell Thomas Westerman, a 41-year-old, was charged in Johnson County Superior Court 3 with conversion, a Class A misdemeanor. Bartholomew County Prosecutor Lindsay Holden Kay will prosecute the case in Johnson County. Westerman used to work for Andrew Baldwin, a public defender previously assigned to Delphi suspect Richard Allen, who is charged with murdering 2 teenage girls in Delphi, Indiana in 2017. State police were told of the evidence leak on October 5th. Sensitive crime scene photos were allegedly given to various true crime podcasters and YouTubers. Attorney Brad Rozzi and Andrew Baldwin were removed as counsel from the case by Special Judge Fran Gull after the evidence leak. At least that's what they claim. However, court documents from an in-chambers hearing show that Baldwin and Rozzi both willingly withdrew themselves from the case to avoid being publicly scrutinized for being grossly negligent. Rozzi and Baldwin have since filed briefs with the Indiana Supreme Court asking for Gull to be removed from the case and for them to be reinstated. It now lies within the Indiana Supreme Court to make a decision on the attorneys and the judge. Westerman was arrested on November 27, 2023 and posted bond in the amount of $250 cash, which will be reimbursed at the final disposition of this case, minus any court fees or cost that may be incurred. An initial hearing for Westerman was set on December 7, 2023, but was canceled after his attorneys filed a flurry of motions. Among these motions, attorneys moved to waive the initial hearing, filed a request for discovery, and Evidence Rule 404B disclosure. The attorneys also filed a motion requesting a jury trial for Westerman. On November 29, 2023, a media agency filed a request to have cameras in the courtroom. That motion was denied on December 5th by Judge Douglas Cummins. The judge granted the waiver of initial hearing and set this cause for a pretrial hearing on January 18th, 2024 at 9 o'clock in the morning, at which time Westerman is ordered to appear. True Crime Investigates has submitted a request with the court, moving the court to allow video, audio, and or still photography or social media updates during the hearing. At this time, the court has not ruled on our motion. And as if this case can't get any more bizarre, Westerman hired an attorney by the name of Michael J. Kyle, who in a stunning coincidence also worked for Andrew Baldwin, which is now revealed in this document. Could this be a conflict of interest between the parties? Is Westerman taking the fall for Baldwin acting grossly negligent? Is this a ruse to distract those following the Delphi murders? These are all things that we have discovered over the past week, and we will continue to bring you updates as they become available. Anthony Greeno, reporting live, True Crime Investigates.
Anthony, how is it that one of Baldwin's attorneys can represent him?
I don't understand how that works, because I think that Michael J. Kyle worked under him during the time at the crime, which would make him a victim of that.
And yeah, and why would one of Baldwin's attorneys represent him when this is against Baldwin?
It almost seems like he's a fall guy. Like, hey, man, will you just take a slap on the wrist? We'll all give you the $250 to bond out. You won't spend any time. You'll get a slap on the wrist, some probation. It'll go off your record with a plea diversion since you've never been in trouble. And you can kind of help me get back into the Delphi case with Richard Allen by, taking this fall and saying I didn't have anything to do with it. Then I'm not grossly negligent. I'm a victim of a crime.
So does that mean Baldwin was really in on the leaking of these photos? Was this all part of a big plan to help with their 136-page Frank's document?
I seem to think
backfired on him.
I seem to think that it is a good possibility. There are other experts and attorneys that seem to think the opposite of that. And I'm glad that you asked that question. I have a question for you now, and I also have a video of 2 little interview clips of 2 different people, FBI agent and an attorney that we all know them both, giving their opinion on exactly that.
Oh, good, because a lot of people have been asking me this, and I'm like, it's just too bizarre. It's too intertwined. You know what I mean?
It's too intertwined. And I had the ability to ask the former FBI special agent and the head of the mass shooter program for the White House, Catherine Schweit, what leaking crime scene photos can do to either the defense or the prosecution, what can that do to a case? And also, Bob Mata was asked the same question, and we have responses from both of them. Bob Mata's a defense attorney. She was a Chicago prosecutor. Two different people. Okay, so listen to what they had to say regarding this real quick.
Yeah.
Nobody on the prosecution side has ever leaked to us discovery materials that was protected by an order from a judge.
Yeah.
Dude's dead, man. Dude's dead, man.
Does that make sense to you?
Dude's dead, man.
The prosecution's never leaked anything to us. But he didn't say the defense or the prosecution has never leaked anything to us. The defense team leaked it to them. I bet that they were maybe asking, I bet they're all friends, and they were asking what he thought because he's an attorney. And Kevin saw the photographs, and he had the photographs. That's my thought.
Yeah. And that's not the first time. Sometimes you'll have news media who calls and says, we've been given this. We know that we're not allowed to have it. It's illegal for us to have it, or it's going to like ruin a trial. The thing is, if something, especially on a trial, gets released that are very discriminatory in the case, it can literally have a case dismissed. It can impact a case. It can have a count of a charge against somebody dismissed. Who is giving you this information and why? What is their motive, right? Is it helping them to maybe pollute a prosecution, or even just to confuse the jury? Yeah.
Yes, it's incredibly disturbing that anyone would come in and take photographs of graphic crime scene photos of two beautiful young girls for any reason, let alone to start distributing for reasons unknown. Frankly, that's one thing that still is a mystery, why this guy would have done that. Anybody who's practiced criminal law and tried cases knows that that's absurd. No criminal defense attorney would ever want crime scene photos out to the public, because what it does is it incites the public against their client. So the thought of, or the mention of Baldwin doing it intentionally was obscene to me. And I've heard it mentioned multiple times. And you know, as far as whether or not his rights to a fair trial have been potentially injured by this leak, I'm just not seeing it, because the photographs never made it out.
I disagree with Bob Mata.
Okay, so for him, here's what I disagree with Bob. The photographs made it out. I mean, if I have them, if I got them, they made it out.
Right.
Thousands of people have seen these, if not millions, I bet you.
Well, and like Jen says, problem is stuff was out there before this even happened.
And it continued to happen. And it's only, as we've seen what Kevin said from Murder Sheet, that no one on the prosecution has ever leaked information to them that was protected. They never said that the defense never leaked anything that wasn't protected, or that was protected. You know what I mean? They specifically said that the defense has, but the prosecution has never done it. So if they willingly said that on the media, that the prosecution is the only ones that have never leaked sensitive information that wasn't supposed to be out, the defense did.
Right.
So they obviously did that for a reason. And I find it very ironic that they interviewed Mitch Westerman way before all this. Isn't that interesting? It's just, I wonder if they knew then. I wonder if he shared the photos with them then and said, I've got these photographs if you guys want to see them. And eventually it just made its way to another creator that publicized it. And that's kind of what led us to where we're at today. And I feel so involved with this. I just feel so involved because I got them, and then I called and I talked to the police, and then we had all these updates, and then all of a sudden these attorneys are off the case.
Right.
And people were like, well, it's not even that big of a deal, right? I know that people like Julie and stuff like that, they came on and they were like, well, it's not even that big of a deal. I don't know why he's so concerned about it. The reason I was concerned about it is because look where we're at.
Yeah.
It can jeopardize the case. It's a big deal. And I think that Mitch Westerman's case can severely impact Richard Allen's case.
Yes. Well, and here's my thing too, okay? I'm a mother. If it were my child, I would want to see those.
Would you?
I would. because, like Carrie said, the not knowing makes your mind go to places that you've never been. Right?
Yeah, but then that's something you can never look away from.
Right. But then being a true crime YouTuber like we are and being so protective over the families, at the same time, I don't want them to see them because I don't want that to be their last memory of their child, of their grandchild, of their sister, you know? So
Yes.
when I was told that these photos were given to certain family members, originally I was like, oh my God, what were these people thinking? You know, just trying to protect them and everything. But then I started thinking like mom and knowing and talking to Carrie the way that we did at the March for Justice, and her saying that not knowing was so much worse. I can see why they would want to see these pictures. But not have anybody else see them.
Yes. And do it privately and by their own time where they can grieve. Because this is a chapter that's not closed. This is not closed. This may be a lot of people who follow true crime and things like that. The chapter sometimes closes for them when there's an arrest. Oh, the mystery's over. Peace.
It doesn't.
And it doesn't. It doesn't stop. I mean, this is a wound that just never heals. I feel it in my heart.
Well,
you know, it's always there.
If you think about it, Anthony, okay, the worst day of their lives was the moment that they were told that the girls were gone.
Yeah.
That was the worst day of their lives at that point. But when you finally get an arrest, they start reliving that all over. And then it gets worse because then details start coming out. And when you get into a trial, it's 3, 5 times, 10 times worse because then you have to see pictures and you have to hear all of the little details of what happened to their loved ones. So it almost just begins when an arrest happens and then the trial goes through, because that's really where their nightmare continues and moves on until there's a final verdict.
Exactly. And, you know, it goes through, there are different types of situations. For example, if we talk about our friend Zav, right? She was under public scrutiny last year over autopsy photos posted on Patreon. And she wasn't selling them. That's not what there are people out there that say she was that it's not what she was doing. She made a video that couldn't air on YouTube and you had to air it on a different site. It just had autopsy photos in there that they showed in court. But there's two sides of this. Sometimes there are family members, like family members of Gannon Stock, who didn't go to court on that day specifically to not see that information because they never wanted to see it. And now they're worried that it's out there. Right. And that someone will just inadvertently, or they'll just look up something online and bam, it'll be right there. You know, that's what their worry is. And that's what my worry is with the Delphi case, is that it'll just be there, you know? And here's where I could see them getting some closure by seeing the photographs. But then again, I think they'll have the same problem as me. When they look at those photographs, they're going to be like, what happened? And if he never confesses to that, then they're just going to have a speculation and all these thoughts in their head. And I don't think the dude is ever going to confess. I think he's that smart, and he's that much of a guy. He's willing to remain silent and not say anything versus, you know, come out and just, here's what happened that day.
Yeah.
I don't know.
And I do agree with Jen. I do think that there's a lot that's already happened before this trial that lawyers may be able to appeal on. I'm expecting appeals after this trial is over with Richard Allen? Absolutely.
Guaranteed.
Whether they're going to go through or not, that's another question. But there's definitely going to be appeals. Now, that's only if he's found guilty. If he's found innocent, we're not going to hear anything.
Yeah, there's no appeals. There's no appeals for that.
Yep.
Which just doesn't make any sense. Only mistrial. I see this case hitting a mistrial. I see us going to a mistrial in this case. I see them.
Do?
Oh, yeah, because the crime scene photos, the jury was tainted. You know, I mean, just all these different things. Emails.
Yeah.
It's just, there's too much. There's too much fighting going on between the attorneys.
Jackie says, I recently lost my daughter. It's crushing. I can't imagine having to go through all of this in addition to the heartbreaking pain. Bless them. We're so sorry, Jackie, for your loss.
Yes. Yeah, we are.
So sorry for your loss.
So I'm trying to keep updated. So sorry, everybody. I'm trying to pay attention to what's going on Mitch Westerman's case.
So you're not the only one that thinks that there may be a mistrial. Jen says, Anthony, something we can agree on.
If we don't always agree on things, I'm glad we can today.
Yeah. So right now, the Mitch Westerman hearing is going on. It's taking place right now. If it's not
Right
even
now.
already over, because it's not going to last that long.
It's not going to last long. It's just going to be a few minutes.
So, yes, you're right. This trial has been so fractured so far. It's not going to be a cut and dry trial. Absolutely not. Absolutely not.
Let's see. Okay, so
trial, but never. Yeah, it's never over for the families.
It's never over for the families. No, man, I am just on top of this morning. Let's see here, Westfield man. So
are you getting any other reports?
Nope, just I think they're in court because I'm not getting any responses at this time. So
I figured a half an hour.
He can't have his phone on, so they make you turn it off when you go in there. He said.
Yeah, Cheech, the Superior Court does, but right now the Mitch Westerman hearing is going on.
Mm-hmm.
Shane says it's time the case sped up. It's been glacial. I have a feeling it might. Oh, it's been. Look at the past 7 years, you guys. We got barely anything, and then the last year and 2-3 months, this case has blown up big time. We now know details that we never thought we would know before the trial.
Yeah, and I don't know if I should have known some of the details or should have heard all this before now. But then again, if I would have heard all this Odinism theory in trial, I would have just been blown away. I wouldn't have known what to think. I think nobody would have known what to think. People would have been like, but it would have all happened within his trial.
Yeah, but not really, because if you think about it, this is not the first time that we've heard of the Odinist theory.
You're right. It came up in the very beginning.
It came up in the beginning. It came up years later. It's coming up again. It just keeps coming up.
It does.
Just like all the other rumors,
And you know what? Like we were talking about last night, there is, in all of these rumors that I've heard from day one till now from social media, okay?
Nuggets of truth.
Nuggets of truth in the rumors by public, like me,
yes,
family members, searchers, law enforcement. There's crazy speculation and stuff like that, but it turns out maybe it's not so crazy sometimes, right?
Right.
Because some of it does hold a little bit of truth to it. So if you take pieces of all these different things that have come up over the last 7 years, you can piece together some actual truth out of it. And it took me seeing the crime scene photos to understand what the Erskine screenshots are all about. And there is truth to those.
Yeah.
You know what I mean? There is truth.
And I don't know if I've told you that. I don't think I've told you this, but I did see the photos.
Okay. And
I was sent them in a weird, bizarre way. It's like somebody snipped them and put them in a Word document and sent them to me that way. And it's all anonymous. So I was like, okay.
That's it, but they're interested. So what is your take on that? I'm going to ask you a question. Okay. Amy, case by case. If you're feeling better, Amy, you're welcome to join us. And you guys are welcome to call in later on whenever Marv wants the call-ins and stuff. You guys are welcome to call in, give your take. What do you think is going to happen in Mitch Westerman? What do you think is going to happen in the Supreme Court? We got a lot of documents to go over regarding Richard Allen's case, but we're trying to get an update on Westerman. My friend Devin's there. He's in the courtroom. He had to turn his phone off to get in the courtroom.
So he actually made it inside. All right, Devin.
Yeah, it's powered down. So he's there. And he said that the dude was there. He didn't say his name. I don't even know if he remembers the dude's name, to be honest. He's like, who's this dude? And I'm like, here, man, watch these videos. And he's like, okay. And he understands the case in full. He didn't know about Delphi until I told him about it. So he's a good dude. But yeah, you guys are welcome to join. Oh, so man, what the hell was I going to ask? I was going to ask a question.
Were you going to ask me something about the photos?
The photos, yes. After seeing those photographs, your take on true crime design, crime scene photograph. Let me see. I'm gonna.
I can tell you that Abby did not have horns.
Okay.
In those photos.
It's fabrication, isn't it?
Yeah. And I can tell you that I do not believe that the sticks were arranged in trying to do some kind of rune, because most of if it was going to be a realistic rune, they would have had separate sticks. These sticks were actually together in different directions. And yeah, after the finished result, it could have maybe looked like they were but I don't think so. I think they were just putting them on there to hold the girls down and kind of disguise them. I did not see I didn't see it at all.
Me neither.
And like I said, there was absolutely no horns on Abby at all.
At all, in any way, shape, or form. Nothing. And I've got the rendition. So people out there who have seen this photograph, it's out there. It's an animated cartoon, or it's an animated version of the crime scene. This photograph here is very accurate, except a few things. There are no horns on her head, and the stick on the very left side that goes up and down is kind of shaped like a Y is not even there. It's actually just a little stick that's in front of the camera. It's not even there. So just eliminate that stick from your mind. It makes nothing. The horns are not there. She's just laying on leaves and little tiny twigs and sticks, but they're all over the place. It's not just limited to her head. It's all around everywhere in the woods. You can see them all over. This right here is a very accurate depiction of what they look like in the crime scene photos. Very. But that's not the way the crime scene photos were taken. They weren't taken as an overview like that. It was different angles. And there's more crime scene photos that we've not seen. You know what I mean? Because even Westerman said that he took photographs of some of them.
Right.
And the defense memorandum that we're going to listen to discusses other things about the crime scene that we haven't seen. So we don't know. We know there's nuggets of truth in this stuff that we haven't seen, but we don't know which pieces are true and which pieces aren't true. Okay,
Shane
so here,
says, thanks, answered my question. Yeah.
thanks. Answer my question. Okay. Do you think that the Supreme Court could say, you know what? We're going to wait and see if Westerman's convicted before we make a decision on this, because we can't determine if Andrew Baldwin acted grossly negligent or if he is a victim of a crime until Westerman's convicted, because he's innocent until proven guilty.
God, I hope not.
I could see it.
I hope not.
You know what I mean? Because he's saying he's a victim of a crime. Well, they're going to have to prove it first.
But that's what I don't get. He's a victim of a crime, so his whole firm is a victim of a crime. So how can one of his attorneys be the representation for Westerman?
I don't even know if they thought anybody would catch it.
How could they not think anybody would catch it the way that the internet sleuths are? The internet sleuths catch everything.
It didn't take me long. You know what I mean? I was like, man, look at this, dude. Someone sent me a document, and I'm like, man, look at this. Look at the name on this.
Yeah.
You know, like, look at the names. He worked for him. People. Conflict of interest. Good morning, Misty. You're late this time. I made it on time. Everybody, I made it.
Anthony did make it on time. I can vouch for him.
Westerman, man, I'm so anxious to find out what's happening here.
I know. Do you think he'll take a plea?
Yeah. No. Yes.
Okay, so here's my thing. Listen carefully. When it comes to Westerman, he came out, he made this voluntary statement, had it notarized and everything, right? But did he truly think through his actions?
No. I didn't think that he'd get arrested.
By doing this, does this affect his military benefits? Could it affect his military benefits? That's important to a man that served all that time. Could those benefits get taken away? Does anybody know? You know,
conviction of a crime can result in military status change. You know, is he still active in the military, or is he retired? What is his status? Do you know?
I don't know. And Jen was asking, is the other attorney classified? Is he a partner or junior partner? I don't know. Anthony, do you know?
Let me share a screen. I'm gonna have to share a video file because I can't pause the other one. I've got the document, and I'll show you guys what it looks like. Of Mitch Westerman. Here we go. Where are we at? Mitch Westerman.
Okay, yeah, so Emily says yes, he can lose his retirement benefits.
He can. Okay.
But then Rebecca says no, it doesn't affect him.
I don't know. We have two different opinions here, so I don't know.
Yeah. Anyway. Well, you and I were kind of hashing this out last night too, you know.
Yeah, here it is. So this is what it is, everybody. So if you see this document on the left side, location of the business, Better Business Bureau, file opened in 2018. The business is incorporated in 2005. The business management goes as follows. Mr. Andrew J. Baldwin is the president. He's the boss man. And Michael J. Kyle, Westerman's attorney, works under him. So he's a victim.
You would think, yeah.
Yeah. If I didn't, I don't want to get too involved with the case, but I would tell them that.
Emily says if a military person is charged and goes to jail, you lose benefits.
Yeah, and I see a lot of people that have been in there that have lost.
But then, like people are saying, this is a misdemeanor. So is it, if it's a felony, do they lose it, or does it matter what degree the charge is?
I'm pretty sure felony would definitely constitute. Not sure. Misdemeanors are kind of, you know what I mean? I mean, technically, a traffic violation, some of them are considered misdemeanors.
So if he gets incarcerated, then
you're not allowed to receive military pay while you're incarcerated.
Yeah.
Not allowed. They'll cut it off. Most people kind of screw over the system and do it anyway and just don't tell them. You know, if they don't know, it doesn't hurt, is what they look at it as.
Okay, so they're saying, a lot of the military people in the chat are saying it's not going to affect him because it's such petty. It's a misdemeanor, basically.
Yeah, it's a petty crime.
Now, if he was charged with a felony, then it would.
Mm-hmm. But it is important to know that this is a man who's never been arrested.
Right.
Richard Allen is a man who's never been arrested. All these people that are in this Delphi ball game, Keegan, Kline,
never been arrested.
None of these people were arrested prior to the charges that they have or have been convicted of or are on trial for right now. None of them. Right. And they were all involved in some shady stuff. Keegan, Kline especially. Okay. Richard Allen, who knows what he's into? You know, Mitch Westerman, secretly sharing photos, and I don't know. None of these people, all these people just got criminal records because of the Delphi case. Every single one of them.
Right.
And there's been a lot more that have gotten criminal records because of the Delphi case. You know what I mean? It's such an odd thing. I was watching videos last night of people going to Delphi, you know, different drone footage and stuff like that. I was looking at, and I'm like, man, some of this is really good stuff. And I come across videos of Jonathan Lee Riches, JLR Investigates, who was in Delphi, you know, and I sat back and I thought where he was in the video was at the Freedom Bridge Plaza where I met you.
Yes.
And I was watching that, you know, I was watching him, and I've got those memorial videos, by the way.
Awesome.
Yeah. Thanks to a good friend. But I was watching it, and I sit there and I thought, man, dude, it was only 6 years ago, a little bit, actually 6, maybe 5 years ago still, when there was only a few of us covering Delphi. And I remember people coming there and seeing the trail and being there with them. And now everything has changed. The bridge has changed. The trail has changed. The outlook has changed. There's cameras there now. There's kiosk. None of this was there. It was straight wilderness. You know what I mean? At the time of the crime. So what you see now does not fairly and accurately depict what it looked like at the time of the crime at all. It's totally different.
Absolutely not.
Yeah. It's way different. And there's a lot of, it's interesting to see all these people, because when I watch videos like that and I sit back and I watch other people do their investigations or walk across the creek or cross that bridge or go down the hill, I see myself 7 years ago.
Yeah.
You know what I mean? When I first got into this, like, man, I got to see this. I got to do this. I got to walk here. I got to look in the woods. I got to dig. I got to go look around at the crime scene myself and see if I can find anything, because I just had that curiosity in my head to search. I mean, dude, I even consulted a psychic and listened to what they had to. I did.
You did?
Yeah, his name's Jimmy.
Oh, and my.
Yep. He's a psychic, and he was put on to me by other people that said I should have done it. And I did. And I listened to him, and I went out and I found a glove and I submitted it to the police, but it was nothing. But it was just the fact that it could have been something, you know, and I was right there in the area where they were found. just walking around looking for things. And I met another lady who happened to be at the trail that day. And I walked down to the bridge and I walked away, and she says, "Can I ask you a question?" And I said, "Sure." She said, "Do you know anything about the two little girls? The thing that happened here?" I said, "Yeah, I do. Could you show me around a little bit?" And then she proceeded to tell me that she came from Los Angeles, California.
Oh, wow.
To Delphi to see this area, to find or touch a piece of clothing related to the victims, if she could speak to a family member, and just so she could get an idea, she said, of what happened that day, and maybe she could offer her help. And I pointed her in the right direction on who to speak with, which family member, and she went about it. But I'll never forget that lady. She came from California, Los Angeles, California, a huge town, to a small little blimp on the cornfield.
Well, do you guys remember the first time I came there? They're like, "Who's got the Wisconsin license plate on their car?" And I'm like, "That would be me."
It's in
You drove all that way? Oh, yeah.
And that was that's something that all northern people say,
Yeah,
So I am anticipating a response any second from
And let me tell you guys, okay, I have no problem with those that don't believe in psychics, those that do. I have a family history of things happening in my family that I believe. Okay. Not saying that I believe every psychic out there either, but I do listen to the information that they give to see how things may or may not be accurate. And if there are things that are accurate, that's what piques my interest. Oh my God, they're talking about that. We know that actually happened, but okay, what are they saying in conjunction with that? That's how I keep my mind open to the possibilities of what actually could have happened.
Yeah.
So
exactly. And to answer your questions, yes, everything was fine in that area.
Yeah.
That you could visibly see.
Now we all know that everybody that I talk to says I'm what's called an empath. Okay. I get feelings, You've seen me react at the site.
Mm-hmm. Yeah, we've
at the
been there
walks
together.
and stuff, when we're there together, and when I'm feeling things, you've seen that. Other people have seen it. And it's just something that I don't have the thing where I hear them or I see them or anything. I just feel them, So I can tell you that is the one thing that has not changed at that location. The feeling you get when you're there.
You know what?
Even though everything around you has changed, that has not changed.
That has not changed.
Mm-hmm.
You know what? When you said that, I'm going to look for something here, because that reminded me of something that I did earlier, like last year, in my first trip to the bridge after being gone for a while. I felt different about it all. I felt like I went there for a peaceful place, even though a crime happened there. It was a place where you could go and not see anybody for days or hours.
Yeah.
Hours. All day. I could sit there all day on that bridge and just see no one.
Exactly.
And just think and look around and just sit on the bridge and, believe it or not, everybody, watch the fish.
Yeah.
You can see them.
Well, okay, the only time I saw a fish was when that kayaker went by and had that big fish
Oh my gosh,
alongside
it's
the
in
kayak.
that
Remember
video.
that?
Yes, it was in that video. That fish was like 6 foot
That thing
long.
was huge. I've never seen a fish like that. I'm like, holy crap, out of this little creek. Yeah.
It was huge. Okay, I found it. So I'm going to share this video. This was my trip to the bridge, and this is what I felt like this last year, okay?
What's up, YouTube? I'm Anthony Greeno here at the Monon High Bridge Trail, and this is the first time I've been out here since they actually redid a portion of the bridge. And as you can see, it's different over here than it is on this side. And for those of you that come out here and want to experience what it was like during the crime, you're not going to get that anymore. This is not the same place. It doesn't feel the same. It doesn't look the same. Even though they rebuilt the bridge, it's missing the element of the creepiness that comes with the deteriorated condition of the bridge. So it's not someplace that it's lost its value to me as far as interest in the case. That was the main thing. I think most people were drawn to this case because you had a mysterious guy on a mysterious bridge in the middle of nowhere. And now you don't have that mysterious bridge, and the mysterious guy is now known. So it almost seems like the interest in the case is dying down. I remember there was one point in time I could post a video and just type in Delphi. Thousands and thousands of hits overnight. Now there's 20,000 people covering Delphi and about 500 hits a night. And that goes for most people. So why did you lose interest? Did you lose interest because the mystery no longer remains? That's my biggest question, I think. But this is my first time here since he's been arrested. And I can say that I thought I would feel a sense of more peace than I do now. But I don't. I just feel that there's more questions that I have that have gone unanswered. You know, for 6 years, I sat there and studied this guy and tried to determine where he lived, where he parked, where he worked, who is he? And I always said that he's probably someone that I know, and I just don't realize it because he's just right under the radar. And he was not someone I knew personally, but someone I knew through being in town, through the store. I missed it just like everybody else. And I guess that goes to show that even though you can be close on your investigation, that one tiny little link can change it all. So I'm just happy that he is in jail and that we're hopefully going to get a conviction. One thing that puzzles me is that I talked to the individuals at CBS and they are saying that he's a great guy and they never would have suspected anything. He would walk you to your car every night. A good man. I talked to a neighbor. She didn't want to give a comment of his. Knocked on the door to see if anybody was home. No answer. But this secrecy stuff is going to stop because we're going to get some answers one way or the next. I don't care if there's a gag order. So,
yeah, I mean, this is prior to, this is in April.
Well, you weren't there. You weren't there the weekend that he was arrested. Man, I drove down there so fast it wasn't even funny. You know.
Do you know where I was?
Yeah.
I was about 10 foot away from him while he was being booked in.
I know. But it was the first time, Anthony, that we saw people on the trail.
Oh, yeah. Explain to them.
All those years, nobody on that trail. No one. And that weekend, the people of Delphi took back that trail. There was kids riding up and down it. There was families walking down it. It was the most bizarre but wonderful thing in the world, seeing that. And it all had to do with that arrest.
Because people felt safer.
Yes.
It changed this community. It changed me. It changed everybody. We didn't used to feel that way. I mean, you could, like people always say, why would you let two kids go in the middle of the woods by themselves? People, we don't have crimes like that happen here. I mean, look, we still ride horses and buggies, and we still, like there's people that don't even have power and stuff in this area. that
Yeah.
intentionally, okay, it's old school. But it, like Kathy said, Marv said, it changed our community.
Yeah.
And it's good to see that sense of people back out there.
Yes.
So Westerman is in court right now. He's not even done from what I'm hearing or what I'm guessing. I don't think so. There's multiple people having a hearing at the same time.
Oh,
they schedule them
he's
all
got to
for
wait
now.
his turn.
Yes.
Type thing. Okay.
So I'm not sure if he may still be in there. He may not be. He had to turn the phone off in the courtroom, so we're not sure what's going on.
Can you handle things while I run to the ladies' room
Sure.
and get a refill?
I'm here. Yep.
All right. Thank you.
Gotcha. Yep. No problem. All right, everybody. So I will pull her out and I'll jump in. There we are. All right. So what I'm doing right now, ladies and gentlemen, is just editing this screen. If you guys want to call in and give your opinion on things, you guys are welcome to do so. Just let me know if you guys want. Is this just a hearing for Westerman today to set up a trial date? Westerman's hearing is to set up a trial date. The Indiana Supreme Court will have a live hearing here in about an hour that we're going to cover. And here in a minute, when Marv gets back, I'm going to try to give you guys a Delphi update, let you guys know what's going on with Mitch Westerman, and go over those documents. So if you guys didn't see the documents that I filed last night, let's take a look at them right here. There's the documents, or there's the information that's being provided to you today. And the first thing that we're doing right now at 9 o'clock is Mitch Westerman's case, and then we're followed by Richard Allen at 11 o'clock in the Supreme Court showdown. So I saw on another channel that there are 12 convicted sex offenders within a 5-mile radius of Richard Allen's house. Yeah, there's a whole bunch around the area and stuff like that. Hey, Jan. And if you guys want to make PayPal contributions or Cash Apps, you guys can do so in the links in the description below on this channel. We'll be broadcasting the Supreme Court hearing live at 11 o'clock. First, we're waiting on an update about Mitch Westerman, finding out what's going on with him. There are cameras there outside of the courthouse from Fox 59. I think WTHR is on it too, and Wish TV 8 out of Indianapolis. So that's all the documentation that's showing up on the screen about Mitch Westerman right now. And what I'm going to show you guys in just a second is some video clips of some really cool, just some interesting stuff that I had the opportunity to go do in this case and like give you guys a better outlook on this case. So let me show you guys something that you might find interesting. Where are we at here? Let me see. I am looking for videos that I have at Richard Allen's house. So I'm pulling this up right now. So let me actually just go through here and see if I can pull up these videos and show you guys what it looks like at Richard Allen's house. There's one. Let me grab another one. I'm just looking for them, everybody. There's one at Richard Allen's house. I got so many videos, everybody. There's another one. And it looks like I'm going to look up one more while you guys are looking through those documents that are showing up right there. I'm looking for another video, if I can find it, of me at Richard Allen's house knocking on his door. So let's see if I got it. And there's another one. All right, so I'm going to try to pull these up and share them with you guys. But that's what you're looking at right now. So that's the order on my motion for cameras in the courtroom was denied. Check this out. Nobody's home. That's his house, ladies and gentlemen. That is Richard Allen's house, and I've been there a few different times. You know, I've been there a few different times trying to get someone to answer, and now it's been sold, so he doesn't live there anymore, and none of them do. Let me see here. I think I got another video here that shows a different angle. We're going to take a look at it and see if it shows anything new. When did I go to his house? Last year. Yeah, I went to his house last year when I had two fans, Barbara Spicer and Joe, her husband, showed up, and we all went together. Let's take a look at it.
Bossy says it was sold to Marv Allen, so somebody in the family bought it.
These names of people in these days. You got Marv, okay, like you, Marv Allen, okay, and then you.
I know.
And you got Gray Hughes, and you got Shay Hughes.
I know. It's funny.
It is funny. There's too many coincidences in this case.
You know, I was showing you all the documents that I had, and I have stuff in so many files. I really need to get my videos that I took of Delphi and put them on my channel so that everybody can see them.
Yes, you should. I'm going to back out and try to make a phone call.
Okay.
I'll be right back.
So everybody, we are just waiting for information on what's happening in the Westerman hearing. We know that it's going on right now. Like in all other court cases or court sessions, he's not the only one there today. They set a time, and then multiple people go through and have their hearings. So we are just waiting for an update from our individual who's in the courtroom right now watching. So as soon as we get that, we will let you know. As we said, this is the first part of today in the Delphi case. It's a major part of the Delphi case because this is the reason the case is at a standstill right now. You know, things happened so fast over the past year. Things were coming out, and then all of a sudden, standstill. All because these crime scene photos were released and because of his arrest. And that is what led up to Baldwin and Rozzi getting withdrawn. That's exactly what they did, is they withdrew from the case, even though they want to get back on it. So the second part of today is going to be the Supreme Court hearing. Bossy, yes, I will be coming back to Indiana this year. I will be making probably a couple trips to Indiana this year. So I do that. I'm hoping that I can coordinate with Randy better this year to almost make a couple walks in a weekend, maybe a floor walk and a Delphi walk in one weekend. I don't know. It's just so it can be to both. And then we're talking about doing a memorial walk for Tabitha also, getting that going. So besides the annual vigil that we do for her, so it's a work in progress. We want Randy to continue to be the face of the walks. He started them. And so we just got to see what we can do here. So I'm getting some messages, so I'm just checking those out. Sorry about that. If my attention isn't fully on you guys, I'll stop looking at that. Yeah, absolutely. I'm up for that. Once we get a decision by the Supreme Court, be prepared, because things are going to start popping off in this case again. You're going to get motions and you're going to get hearings from whoever is Alan's attorneys at that time. You know, if Baldwin and Rozzi get back on the case, we could have a trial this year. So, it's just a matter of what this decision is. It's going to be interesting, that's for sure. And then what happens if Gull gets taken off the case? Well, that's not a big deal, because any judge can walk into a case and take it over. Lynn says a motion was just filed. Huh. I will have to look at that. So yeah, a motion was just filed not too long ago, I know, by his attorneys, his new attorneys, Labrato and Screamin', and that was because of the visit that they had with him. And I have to say, hearing them describe their visit and him, Richard Allen, being in a jail cell in the kitchen, and the way that they had to interact with their client doesn't make things better in this case. So
I'm back with an update. So good news, bad news. Okay. Good news is he's done. Bad news is Devin could not get a video of him because he couldn't get the phone to turn on in time on the way out of the courthouse. He's like, he went first, he went after him, and because they didn't want people coming in and out.
Right.
And he wanted to go out first and wait for him to come out of the room, but they didn't let him. They wanted him to go first. I think to protect him, they wanted him to go first, and then they let everybody else go. So he wasn't.
Well, and you got to remember, he's on bail, so he's not going to jail. He's for safety reasons. I'm sure that they did do that.
Yeah. So they didn't let anybody near him. You could have, but they were kind of, I guess they were kind of strict with their rules. But he did say that there was news out there filming. So he says,
so we should have it.
He said, apologize, but yes, Westerman's case is set for jury trial. It's going to be updated later on. He couldn't remember the date, but it's set for, I think, a month or two out is what he said. There's two more hearings. I think they're going to ask, they said they were going to ask for depositions.
And then there will be a pre-trial.
And this is a pre-trial. There will be a final pre-trial hearing that'll be coming up after this, and then he'll be set for jury trial. So we should, at some point, from a media outlet, have some information coming in. And I reached out to a reporter that was there already.
Cool.
Through him. I said, who was there? He said, I actually asked who they were. So I reached out to that person on Twitter just now and asked them to give me an update as soon as they got one, or a video footage if they got it. As soon as I get that, I got some people to forward it to. But we will have it here if we can get it as fast as we can. We should go over that memorandum because we've only got an hour.
Let's just say, because a couple people just came back in. So Mitch Westerman is bound over for a jury trial. We know that. It's going to happen in a month or two. They're going to have a couple hearings before that.
Yeah. Oh, man, I'm so stoked. So he's not going to plead guilty right now. Why?
I'm telling you, he did not think this through. Even though he confessed and had a notarized statement and everything done, he did not think this through as to how this was going to affect him. And because of that, now he's going to plead not guilty and take it to a jury trial.
But he's hit. I mean, they have a smoking gun. He notarized a document.
I know.
What's he going to say? He did it under duress?
Well, that's what's going to come. You know, what is his defense going to come up with? You know, what is their theory and everything going to be?
Wouldn't it be funny if his defense attorney said he was under duress, pressured to do this by Andrew Baldwin? And Andrew Baldwin saying the same thing about the judge.
If that happens, oh my God, this case will really blow up.
Yeah. Be like, no, man, I was forced to do that to protect him.
And you might be right then. The Supreme Court may wait to put their decision out based off of this trial.
Yeah, because they can't prove if he's a victim of a crime or intentionally, grossly, negligently released crime scene photos.
Right.
He's trying to distance himself from being responsible for that. Take responsibility. I get told that all the time.
Mm-hmm.
Okay, by defense attorneys and judges and prosecutors and friends and family and you on YouTube. Take responsibility. He left the crime scene photos unattended in a room that was unlocked and someone got access and shared them. There's got to be some accountability and responsibility for having that happen.
Right.
At your home or at your office. So needs to be some responsibility.
Well, and the fact that this isn't the first leak because of them is huge.
It's third.
So the first leak was with Woodhouse. Yes, that may have been a true accident. Absolutely. But the information still got out into another individual's hands who shared it with other people. So it's still a leak. And then you have the gag order on the case. It's been there all this time. They knew this, and yet they put the 136-page Frank motion out there to the public when the judge said it should have been sealed.
Exactly. And then they released it. And the third one we all know about. That's what he's on trial for.
Right.
You know? Hey, how you doing? Hey, bossy. See you soon. Yeah, so we'll be here. Take responsibility. A man committed an X-ing over this.
And that's the sad part over this.
Yeah. Which one was he?
About that.
Is this Fortson or Cohen?
Fortson.
He's the one in Texas?
No.
Yes. You know what? We've got the documentation right there on the thing too. I've got it too. I can't remember. Shared him with Cohen, and Cohen shared him with Fortson, who was in Texas. Someone.
Westerman shared him with Fortson. Fortson is the one that shared him with Cohen.
And Fortson is the one that did this.
Fortson is the one that unalived himself.
Gosh, this is nuts. All over this crimes. There's more to this.
There's a lot more to it. I'm telling you. There's a lot more to it.
Yeah. You know what? Those 126 pages and exhibits that we haven't seen, going to be our answers.
Yes.
It's going to be our answers.
Yep.
I'm anxious about this. Let's pull up that. Do you have those document, the memorandum? I need to pull it back up.
Let me get my file out.
Okay, you got millions of files. So what we're going to take a look at, ladies and gentlemen, is we're going to take a look at what led us here, and as fast as we possibly can. It's a lot, but we're going to take a look at this stuff because we want to show you guys what led us here today and what they're going to be arguing about. And we're going to take a look at the defense theory on what they claim happened. This is graphic information. Some of this information is true. Some of it is unconfirmed at this time. And some of it's just straight made up. So,
yeah.
I mean, there is that. So for the people that think that these documents are 100% the truth, they're not. Some of this stuff is made up, but there is truth in it. There is. We discussed that.
Which document do you want?
The memorandum, the one that we were looking at with all that stuff in it. We were like, go to page 32.
Oh, that one.
Oh man, that one. It's got a lot of stuff in it.
Now, as we're talking about this, remember, Anthony and I are going to have to be creative in how we tell you this information because of the new YouTube guidelines.
Yeah, I'm going to say X'd.
We can't just come out and say certain things anymore, or we could get striked.
Yeah, so, for example, we'll use terms like bodily fluids and things like that. Xing. Yeah. Yeah.
Pew-pews, stabs.
Yeah.
Things like that.
Different things. Yeah. So we all know that they were X'd with a sharp object. You can obviously tell what that is. If you've seen the photographs, you would know. But it's easily described. What's a sharp object? You use it all the time in the kitchen. So
yeah,
that's what happened. I'm in Washington. Oh, Misty is in Indiana, I believe. If you guys are asking that, I think she said she was in Indiana. All right, let me see here. Where's it at? Okay. All right. Do we have, where's that document at? Let me see. Share. Sorry, everybody. I'm trying to pull up this document. I don't know where it's at. I had it in here somewhere.
I got it.
Not sure. You got it? Okay.
Yeah.
Alabama. There you go, everybody. Yeah, where is everybody watching from? I'm kind of curious.
Me too.
What state, country, province, where do you live? Where are you from? Where are you watching from? And why are you interested in this? Comment below, let us know.
Yeah.
And if you're not subscribed to Beyond the Evidence, Marv and I are streaming at the same channel. Or on dual channels. So if you guys, aren't subscribed to her, go subscribe to her. If you're on her channel, come subscribe to me. Mark's in Greenwood. Nova Scotia, man. That's the East Coast, the Scotia Banks.
Ingalls, Indiana.
Greenwood. Good old South Carolina.
Tennessee.
Fort Wayne.
Australia.
Wow.
Kansas.
Guatemala.
Wow.
Wow.
Kentucky. Northern Minnesota. Lafayette, California.
Lafayette, Indiana. Yeah. Wow, look at that.
Belgium.
Hey, Tatiana. Montana. Wow, man.
Yeah.
It's a lot of people.
All over. It's awesome.
I'm going to actually write that down.
Well, we appreciate. Oh, we got Florida too. Florida's represented. BC, Canada, Texas, Virginia, Florida, all over the world. We are connected by this case. Faroe Islands.
Where's
wow.
that?
Sarah, we miss him too. Definitely miss Kat on days like this. Maine. Wow. Indiana. Norway.
And I've counted 8 countries.
Yeah. All different time zones. All across the world. I love it.
This is so interesting. This is very interesting. Thank you, everybody, for your viewership all over the world.
Yes.
That is amazing. And all over the United States. I mean, we got people from Florida to Maine to California to Washington to Texas and everywhere in between watching. It's so cool. We appreciate you, Bloomington, Indiana. We appreciate you viewing and at least learning about the story of Abby and Libby.
Okay, so I'm going to present New York City. Wow.
New York City. There we go. That's awesome. Come on, man. I want this video. Give me the video. Charges explored. I'm sending a message to a reporter right now. Oh, there we are. So let's go through. You want to go down to where we were yesterday or the other day on that and kind of talk about a little bit of that stuff?
In order to watch court, you have to be on at 10 o'clock our time, Ferris. So 10 o'clock our time is 11 o'clock their time.
Which is 8 o'clock my time.
All right. So this first part is just basically my case.
My case. A month ago.
So I'm gonna scroll down here.
Okay.
That's the verified request for medical records. That's the order, but we wanted to go down more. Oh, yes, all this stuff. So much of it we can't see.
I know. Channel 8 and...
All right. So what we're looking at is basically the Franks motion. And we're not going to go through all of it, but we are going to go through some parts of it where we say there's nuggets of truth in it.
Yes. And what we mean by that is that everything that's written in this isn't all truthful. This is a defense theory. The defense is not going to say anything in their theory that implicates Richard Allen as the person. So keep that in mind, that this is a one-sided, biased defense from him, his attorneys, not necessarily the truth. Everyone says they didn't do it.
And this whole first part, so many pages, is all about the oldness theory and that the police didn't put this in the PCA. Well, you know what? They don't have to put this information in the PCA. That's what we've learned. The PCA is just a very broad, could be 3 sentences that links the person to the case, and they're asking for a search warrant or for an arrest affidavit.
Hey, Marv, I'm going to send you something to put in our thing.
Okay.
Okay. Just got photograph. Baldwin and Rozzi are there.
Are they?
They are there. I have a photograph for everyone to see. I sent it to you on Messenger if you want to put that in our little files folder. Baldwin and Rozzi are on scene at the Supreme Court hearing, looks like.
Here we go. Wow.
There they are. There they are, ladies and gentlemen.
Look at all the folders I have, you guys. And then you wonder why I can't keep.
I'll let her look for those while I do this.
I'm just saving that real quick.
No, you're good. Okay. So now we're back.
That way I can put it in the file in the Facebook group.
Okay.
So
I don't know how to do this.
Over.
Who's your here? My ex went to school with the girls. My ex's daughter. Okay. You're welcome, brother. For the person that messaged me asking me about Westerman. So I am just, looks like Labrado and Scrimmin are there. Barney McDonald is on scene.
At Supreme Court?
Mm-hmm.
I'm sure they're all going to be there. They're all invested in this. They want to know what's going to happen.
Wow. Here's another. I got another one.
You got another picture?
I do have another picture.
Awesome.
Yeah, I'm gonna be. Hang on. I'm getting information sent to me as we speak right now.
As we speak.
Yep. Let me go ahead and share some stuff with you guys if I can find it. Wow.
So while he's doing that, before we get into the document, I put together a little information, and here goes. So the Delphi homicides are an infamous unsolved case of 2 teenage girls who were slain while hiking on a trail in Delphi, Indiana on February 13, 2017. The victims were Abigail Williams, 13, and Liberty German, 14, who were best friends and in the 8th grade. The case has received vast media coverage across the world by main media and YouTubers. The reason this case received so much attention is due to the video and audio recordings released by law enforcement. This video and audio came from Libby German's smartphone. The video and audio recordings captured an individual believed to be the killer. The recording shows a man walking on a bridge near where the girls were slain and a voice saying down the hill. The police have not released the manner of death or what the motive was. The main suspect, Richard Allen, is a 50-year-old man who was born and raised in Indiana. He has lived in Mexico, Indiana before moving to Delphi. He and his wife reside in a home they own, which is a half-mile from the school the victims attended. His house is 2.5 miles from the Monon High Bridge Trail, where the girls were slain. He is a licensed pharmacy technician who worked at the Delphi CVS location. He has no criminal record, only minor traffic violations. He was arrested and charged on October 26, 2022, with 2 counts of murder. Allen was interviewed by the police several times since 2017. Through documents that have come out in the case, evidence against Richard Allen consists of the following. Allen admitted to being on the trail and the bridge where the girls were slain on the day of the crime. A .40 caliber unspent round was found near the bodies that matched his gun. Allen confessed to his wife and mother in jailhouse phone calls that he kidnapped and slain the girls. Allen owned similar clothing to the suspect seen in the video, as shown on the video taken by one of the victims. Law enforcement has confiscated knives, guns, and many other items from Allen's home. Allen stated he saw 3 juveniles who have come forward as witnesses on the trail east of the Freedom Bridge, and that he went to the Monon High Bridge to watch fish. This is the area where the girls were taken from the bridge. Allen has pled not guilty and denies any involvement in the slaying of the girls. Bradley Rozzi and Andrew Baldwin were appointed by the court in November of 2022 to represent Richard Allen. The defense team has filed several motions. Some of those motions include a motion to suppress the search warrant that led to Allen's arrest, stating that it was based on insufficient probable cause and violated Allen's constitutional rights. A motion to move Allen to a different prison facility, stating that he was not treated fairly as a pretrial detainee and that his current location hampered his access to counsel. A motion to continue their representation of Allen, alleging that the judge coerced them to withdraw from the case or face public shaming. A motion to recuse the judge from the case, accusing her of bias and prejudice against Allen and his defense team. On September 18, 2023, the defense filed a 136-page memorandum detailing that Odinism was involved in the slaying of Abby and Libby. The defense claimed the girls were ritually sacrificed by members of a pagan Norse religion called Odinism. The memorandum argued that the search warrant was based on faulty probable cause and that law enforcement had lied to obtain the search warrant and violates Allen's constitutional rights. The memorandum also gave details of the girls' slaying that had not been previously released. There have been a few times the defense has released information regarding the crime when they have been under a gag order. Rozzi and Baldwin withdrew from the case in October of 2023 after leaked photos of the crime scene were allegedly taken from Baldwin's office by an associate. These photos were distributed to YouTubers and podcasters. So far, the crime scene pictures have not made it to the World Wide Web, and YouTubers continue to protect these photos and make sure they are no longer distributed. In January of 2024, Robert Scraman and William Librato were appointed by Judge Gull to represent Allen and have filed a motion to move him to a different prison. Now, this is after he was already moved from one prison to his current one, claiming that he's being mistreated and shackled. The attorneys state that the condition of the prison is presenting them for preparing for his trial. The judge has not ruled on this motion. At this time, we're preparing for the Supreme Court of Indiana's hearing on January 18th, 2024. That is today. The hearing is to hear arguments regarding Richard Allen's request to reinstate his original attorneys, Rozzi and Baldwin, and remove Special Judge Francis Gull. Allen's case has been marked with controversy and delays. Individuals in the world believe that Allen should not be housed in a prison since he has not been convicted. Individuals are going by what the defense has leaked and think he's not guilty and should be released, while others think Allen is guilty. The issue with this is that as of right now, everyone should presume Allen as not guilty, as no actual evidence has been provided by the prosecutor or the defense. Until a trial has been completed and all the prosecution's evidence and the defense's rebuttal evidence has been provided, Allen is not guilty. Only a peer of his jurors can either find him guilty or innocent. The Delphi homicide have shocked and saddened the community, the families and friends of the victims, as they patiently have waited for closure and justice for almost 7 years.
That was pretty good. Did you write that or did AI write that?
AI helped me write that. So I got a bunch of information from AI and I put it together.
Okay.
So no, those were my words, but off of facts that they provided to me.
Okay.
Which was very nice. It didn't take long at all.
Exactly. And so I got a video that's just playing over here for you guys to see. This right here, what you're looking at is based on the probable cause reenactment, or based on the probable cause affidavit. This is just a map version of what they described in the probable cause, so you guys can kind of see what's going on. But it just plays Delphi clips and stuff like that as we're waiting on the Indiana Supreme Court hearing to start. All the big players are there right now. We got Rozzi and Baldwin are there in the courtroom. We've got the photographs and stuff that I was pulling up on the screen while Marv was talking. They're there. I mean, they're there. It's the Indiana Supreme Court, everybody. And right there they are, and there's appears to be a lot of people there. Look at this. They're already interviewing people, and there's reporters. I recognize some of them. I don't know who they're interviewing right there.
Fox 55.
Yeah, it looks like they're interviewing probably Rozzi and Baldwin right outside of that thing, or I don't know, or the attorneys or someone. I don't know who they're interviewing, but they got their cameras pointed at somebody.
Mm-hmm.
Everybody's looking. Man, I should be there right now. Gosh. There they are. Looking all slick and stuff. Hair combed. I wonder if Kevin Greenlee's hair with his hair combed. Oh man, I'm excited about this. So, okay, I wanted to talk about, I need to go grab some coffee. I'll be right back. But I wanted to touch base on some of those things that we were talking about as far as the crime scene.
Okay, we can do that when you get back.
Okay. And you can share it. Yeah, I just got that video playing, but you can switch over to the other thing whenever you want.
Yeah, no, that's all right. I'll wait till you come back for that.
Okay.
I'm going to kind of just go through the comments here.
Okay, and I'm going to.
Cynthia says, I've been waiting and praying on justice for Abby and Libby going on 7 years. Absolutely.
7 years.
7 years.
Same here. All right, I'll be right back.
Okay. Robin says, I think it's very telling that his new attorneys agree with the old ones. Remember, they've seen the evidence. We haven't. Well, we don't know how much evidence that the new attorneys have seen yet. Yes, prosecution has to get discovery and all the evidence to them, but it's thousands and thousands and thousands of pages. So what exactly have they gone through? Yvonne says, Marv and Anthony deserve more likes, people. Yes, please hit the like button, share, subscribe to both channels. Let's see here. Oh, you guys got to remember, we haven't heard anything from the prosecution. There's going to be a lot of information that comes out. A lot. Lots of good mornings. Deb says the judge don't ring honest to me. Deb says, I think they were lured there. I just want to touch on this. I'm proud of the members of the crime community for not leaking the photos. I think Westerman underestimated the community's fever to protect our girls. You are absolutely right. Camaro lover, send us an email. We'll be happy to go over it with you. Let's see. No, Richard Allen is not going to be in court. We already know that from a previous clip from a news agency. Jennifer, thank you so much for the donation. She says, thanks, Marvin Anthony. You're so welcome. Oh, T-Bell, you and me both. I want to know what the prosecution has. My email address is right here on the screen.
Beyond the evidence one at gmail.com.
Agreed. Protecting the girls. Absolutely.
gmail.com. Okay, so got my coffee. We're good. We are.
My husband brought me breakfast. He's so nice.
Where's mine, dude? Okay, so that's
there we go.
Right there.
Our beautiful girls.
Yeah, I mean, and there's Carrie. She's such a wonderful woman.
She is.
She really is. So in these documents, ladies and gentlemen, that we were discussing, it describes how they said Richard Allen, or not Richard Allen, somebody committed this crime. And it explains, like, how he would have to lift a shoulder and do this and do that. And the way they described everything is not entirely accurate from that stuff. I will say that
I'm going to let you do this, and I'm going to jet off outside just for like 3 minutes.
Gotcha. Not a problem. I will be right here.
Okay.
All right, everybody. So I will take control of this for just a second, and I'm going to talk about the crime scene. The crime scene in the Delphi case is horrific looking for one victim, Libby. For Abby, you can't even tell what happened. It's sad. And the way that the defense describes the crime scene is accurate, but not entirely accurate. They stretch the truth and add things that are not true, at all. And it's upsetting. For example, when I see people comment and they're like, well, Abby was dressed in Libby's clothes. Well, she wasn't. She wasn't dressed in Libby's clothes. She had Libby's hoodie on. Okay. For example, how many of you girls do it more than guys, how many of you girls have been cold and said, and your friend or someone else, your boyfriend or your husband, whoever, has said, here you go. You can have my sweatshirt. And you put it on. I'm going to tell you this. No, she did not have Libby's bra on. She didn't have Libby's bra on. How it describes that crime scene is on her skin, her bare skin, where women usually wear bras, she had one. Then she had on a white t-shirt, like a white undershirt or something like that underneath that, or some kind of undershirt. And then another one on top of it. Okay? In my personal, honest opinion, I remember they went there under the impression they were meeting Anthony Schatz, a cute young guy who showed interest in them. They thought they were going there to meet him, which turns out to be Keegan Kline, who says he never showed up. There's no evidence that he showed up that we know of. She had on 2 bras is what it's describing. I have not seen those crime scene photographs. Can we assume, is it safe to speculate and say the reason she had on 2 bras was maybe because she was trying to make herself look a little bigger in that area for this cute boy? That's a girl thing. I don't know much about that. I do know that girls do that sometimes and stuff like that. I mean, I've seen that in school and you hear about it and stuff like that. Her clothes, Abby's hair is not wet and shows no sign of ever being wet in those photographs. Libby's hair looks and appears to be as if she was submerged in water. Okay. Abby was not undressed and redressed. Her shoes were still on. They were still tied. Her clothing was all on. She was not wearing Libby's pants. Her pants were unbuttoned. But she's wearing exactly what you see in the photograph on the bridge. Exactly that. Just with the hoodie on. The shoes never come off. Nothing come off. But 2 bras? Okay. Here's where I don't find that odd. Yesterday, I had on my boxers, a pair of sweatpants, a pair of jeans, a pair of sweatpants, a coat, a t-shirt, a hoodie, a t-shirt, a hoodie on top of that t-shirt and a hoodie just to go outside. And it wasn't even that cold. That's me. Right? So that's the thing, Deb. And you guys are welcome to call in and let us know what you guys think after this hearing comes up here in about 15 minutes. We're going to get to it. Okay, so Marv's back.
I'm back. Thank you.
No problem. So we got
about 15, 16 minutes before this starts.
Exactly. And I think that we're going to have it on there for a case by case. Thank you, Amy.
Thank you.
Yes. And you know what? I'll drop that link if you wanted to join us, Amy, because I know that you were scheduled to be on here. If you're feeling okay and up to it, you're welcome to join on here. And you guys can join on here too and talk to us. But we want to watch this hearing first. Okay.
Are you going to bring up the hearing screen, please?
You know I can. Let me
just so we have it up.
Yep. You sent me that link on Facebook. Am I correct?
Yes.
Okay, I got it. Yes. So people are asking me, I've only heard that a jury trial is being scheduled for a month or 2 from now. Yes, that's true. That is true. I don't have the exact dates, but we're going to get those. And while I was gone on my break, I called Lindsay Holden Kay's office, the prosecutor. And you know, they didn't have an update. She's not back in the office at this time yet, but I'm hoping that she will be. Okay. But from what I saw in the crime scene photographs, what is that noise? I don't know what that is. I heard something. There's a noise going on. But I know it hurts, but let's see. You're still doing it. Yeah, to understanding the crime scene. So the things that they described, to me, it does not appear that she was disrobed in any way, shape, or form.
She looks like she's sleeping.
She does. It does not look like a crime scene at all when you look at her.
Mm-hmm.
Oh, I'm going to glitch up. I won't be able to share it.
Okay, I'll share it.
All right, I'll be right back.
I'm eating a biscuit, guys. That's why I have my camera off. Let me get up this site so that we are prepared and ready to go. And it says the video player will be available 2 minutes before the argument is scheduled to begin. So I'm going to share my screen, make sure the volume is on, and have it all ready to go so that when things start off, we can listen to it.
Okay. Hey, Dr. Feelgood, you're just in time for the Supreme Court hearing. The broadcast is not available at this time, but you do have it pulled up, right?
Yes.
So individuals had to get a ticket in order to go in there. So yes, it looks like she's sleeping with sticks on her. Yeah,
yes,
it does. I mean, literally, exactly what you said. She looks, she just laying there with just like this, with the arms in the sleeves, like this.
And the only thing that you can see is that her pants are unbuttoned.
Her shoes are on, pants are unbuttoned, and there's sticks laying across her, but not all sticks that are represented and being put out there in the public are even there. Yes, I've seen the pictures. Yes. And I've recreated them, and True Crime Design recreated them. Based on what we were looking at earlier, the True Crime Design thing is fairly accurate when it comes to the layout of the bodies. However, that stick on the left is not there, but it looks exactly like this. Okay. But the photograph's not taken from that angle. They've put these together, but there are no horns on Abby's head, and there is no stick on the left side of Abby. Other than that, everything else looks entirely accurate. 100% spot on. 100%. Except there's more wounds that you can see visibly. But that's why we're doing this today. That's why we want to talk about this, because there's people, if you don't understand it to the fullest and you haven't seen it, you are prone to maybe either think that that some of this stuff is true when it's not necessarily the truth. We want you to know that.
Right. And you got to remember that what the defense put out is a theory. With nuggets of truth inside of it.
Right. Nuggets of truth. And explain what you mean by nuggets of truth. Like, is there an example that specifically comes up to you about something where it's like, this is a situation, but these are the pieces of the truth. These aren't. Is there anything that you can think of?
Pieces maybe of the truth is that Abby was laying there, but they're saying that she was wearing Libby's pants. She had horns on her head. Not the horns and the pants I don't see as being true.
No, none of it. I don't see her being disrobed in any way, shape, or form, and put the shoes back on, tie them, and all that. He didn't do that. He did not do that. he tied her shoes and then placed them in the positions that they were at. That didn't happen, everybody. Her shirt was described as being clean. The pink undershirt was being described as being clean without dirt or debris on it.
The only thing I saw that had dirt and debris on it were her pant legs.
Her pant legs, because she had to climb up that bank.
Yep.
And it's obvious what happened, you know, and they were not X'd in that spot. They were taken and left there, probably to conceal, is my guess.
Right.
Majority of the big sticks are on the one side of both girls. So that leads me to believe that that would have been the side that people could see from. And so you put something there to try to cover up that side to try to block them. You know what I mean?
Their view.
Block their view. That's my opinion on that. That's just what I think, you know. There are some people that think multiple people did this. Even the prosecution said that.
I've said it.
Yeah. I think that there's someone else involved, but I don't think anybody else was there at the crime scene that day. That's what I think. 8 more minutes. Are you guys scared?
Oh my God. I hope this doesn't crash.
I know. I'm so excited. I'm so excited. So we've got Mitch Westerman's case going to be set for jury trial. I don't know the date on that yet, but we're going to have the information on that soon.
And once we get done with the U.S. Supreme Court, there's all kinds of pictures on Twitter that we can share with you guys from the Supreme Court and from other things. So I'll get on Twitter and we can share it with you.
Cool. There we are. Look at that, everybody.
I keep refreshing.
I know. It's going to be available 2 minutes before the hearing. So, oh wow, this is going to be really cool. So what we do is, how do you want to do it when we do this? I'm going to pull it up on whenever we do that. I'm going to add it to the stage and let it take the main screen. That way, if we ever need to go back, I don't have to crop. It'll just be on the screen. So you guys won't be able to see us.
Are you going to try to screen record it?
I don't think I can, because I was sitting here thinking for me to do that, I would have to log into the other account. Does that make sense?
Yes.
I'm not sure if I can. I'm going to try, but I don't know how long it's going to be. I'm going to try. Let me pull up my screen recorder right now. Because I want this. We want this document, or we want this hearing.
Yep. I have 9:53 here.
Okay, 9:53.
And I keep refreshing. So, Deb, don't worry. We'll fill you in. She says, I'm so lost. Don't worry. We'll fill you in.
Yeah.
Let's just get through the hearing. And we're going to be here for a long time with you guys today, talking this through.
Right. Here's the thing is Deb and everybody else, the people are confused because of the way the crime scene is described and what happened is described by the defense team. And, when you got people that come on here, Deb, it's not your fault. And this is why we're doing this, to trying to educate people a little bit more on what they don't know if they haven't seen.
Everybody just saw the 136-page Frank's document and thought all of it was true.
Yes.
That's not the case.
No, and we're here to tell you that. And people say, why would attorneys lie about that? Because they have to defend their client. There are different types of defenses. There are defense by insanity plea. There are defense by Alford plea, which is admitting they have enough evidence to convict you, but you're still not saying you're guilty. There's also defenses by means of a third party, which is what they're shooting for here. They're trying to say he couldn't have committed the crime because these other people could have committed the crime, and you have to prove that they're cleared. If you can't prove where these, and I watched a case in Oklahoma, and it's the trial. You can actually watch it on Law and Crime, but I watched it on a show called Accused, where a lady basically pointed the finger at someone else, the attorney did, and said, no, this guy couldn't have done it because they never cleared these people who said these rumors around town that said they were going to rob a place, the same place. Someone ended up getting X'd, and the son ended up getting arrested for the crime. And he's like, I didn't do it, dude, because he's the one that found his mother there, right? They proved that theory. The jury found him not guilty because they said, you know what? The cop even said they're not able to say where those other people were that day. So they can't say that they didn't commit the crime. That's a reasonable doubt right there. It can work. But then what happens to Brad Holder and all those people that are associated with that if people think that that's true and accurate?
Right. All right. Refreshing.
Are we there yet? Come on now. We're excited, everybody.
Good point, Ryan. If the crime scene photos don't fully support defense theory, I don't think defense would be behind leaking them. And that's what some of the attorneys have said too, that have mentioned this case, talked about this case. I keep hitting that refresh button, everybody. And that's the thing is, Peter, all the defense has to do is have one person believe in their theory. One person. Oh, come on.
Okay, so Judge Gull is not there at the hearing today. From what I'm hearing, I'm getting information from another individual. Apparently, she's presiding over a case in Fort Wayne, Allen County right now.
Here we go.
Here we go.
Oh my God, y'all, it's happening.
It's happening. Here we go, y'all. So as soon as we get some video footage right there, I'm going to throw it up on the main screen. For you guys, it'll be like this, right? So you guys can see it. Until then, we're going to be sitting here waiting on it and seeing what's going to happen. So we got it down here at the bottom. I'm
I actually got a picture of the tickets that they had to have to get in.
Okay. Turn it up. Well, we can't turn it up.
You got to wait for them to start, and I'll turn the volume up as high as I can.
I'll be right back. I'm screen recording it, by the way. So whenever it starts,
awesome.
Make it on the big screen. You know what I mean? Like this. Okay. It's the one down at the bottom underneath of us.
Yeah.
Underneath of us. No, not those. Underneath those. The 3 videos that are down there. The box in the top left corner of the video.
Got
there
it.
You go. All right, I'll be right back. I'll be back in like 3 to 4 minutes, but I got the screen recorder going. Okay, I'm just testing it.
Okay. Awesome.
All right. Okay, screen recorder's on, everybody.
Yeah, everybody, I will turn the volume all the way up.
All right.
Here we go.
Good morning and welcome. We're here this morning to argue in the case of State ex-rel Richard Allen Relator versus Carroll Circuit Court and the Honorable Fran M. Gull respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus in a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnecke. Good morning, Ms. Winnecke, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, at council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and council. Council, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impined the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly place a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record that had preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. we had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial was.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it for they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor, they had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rozzi and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rozzi on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judges. I'm aware of that. I know what's happened. I'm ready to ride or die with these lawyers. I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it. I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
yes, Judge.
That's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rozzi, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge. I'm going to go out there and I'm going to say these things. And Mr. Rozzi presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
because you're saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think I don't think those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth Amendment
my concern is getting
requires.
this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
A lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer is not being a lawyer at that point. They're not
filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who are represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think that our rules is that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, and other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that just. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
well, counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge, or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did,
no, sorry, the reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation, so if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on, and she pulls them in and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rozzi developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent that from happening?
I think if there's a concern, say for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge can have a hearing, provide proof, or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant does not want, that there is built into that record
structural error,
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed, because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rozzi back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, through the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that two different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance of counsel.
But I'm really struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So you're so why you think that counsel's Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations of the right to select counsel are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
and just
violation.
So I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in 2 ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done. There's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rozzi got together with their client and drafted a letter. On the 12th, Mr. Rozzi filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rozzi said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed. So, which means.
Well, we won't know what would have happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rozzi. Mr. Rozzi himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of making?
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with lots of different people playing, I mean, in the Wheat case. I don't see Wheat as tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur, very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But where can you point to me saying, with regard to saying somebody is incompetent or negligent, that's like, we have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold conditions precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, you know, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you, Mr. Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will believe.
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is, in fact, the person who was making that choice, that he was, in fact, competent to make it. There's been many consistent allegations about his mental state throughout the case. And then, of course, that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in
But for these reasons, it could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with a larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular things cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's a writ. There's no order. There's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? We don't know. All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gull, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rozzi, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rozzi the potential impact that the distribution of these documents could have on my defense. Attorney Rozzi has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rozzi to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rozzi and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rozzi and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rozzi for doing what our ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exist. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana, for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as WEAK's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Massa and Justice Gull, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rozzi and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being relating to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice prong. So, but yes, if these things could ever arise to ineffective assistance of counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
All right. Ladies and gentlemen, this courtroom will be exited in the orderly fashion. We will start with the first 3 rows on my left side of the courtroom.
You're muted. You're unmuted. Now you're muted. Now you're unmuted.
Said, all right, everybody, that was interesting.
Oh my goodness.
I told you it was going to get heated.
I am blown away at what we've just seen. I'm totally just in shock. Thank you, Zav Girl, for the super chat donation of $20. Thank you very much.
Yeah, and I want to kind of go through, we've gotten some other ones, and I just want to highlight those. Tabitha the Witch says, thank you. God bless. Justice for Abby and Libby. Absolutely. Thank you so much.
Yes.
Case by Case earlier donated. Jennifer, thanks. Marv and Anthony, thank you so much.
Thank you.
Nerdy Cat gave
you.
a super sticker, and Renee Days. We appreciate it. This is how we fund our channels and how we get documents and send people to locations on our behalf. We can't do that without these individuals not being in the state there.
Exactly.
So
Exactly.
we appreciate it.
Yeah. And so Devin got paid to go to the court hearing today for Mitch Westerman, and went and sat down inside the courtroom, had to turn off his phone, and there was a bunch of other people apparently in court with Mitch Westerman earlier. And what happened was they had a hearing, they set the case out. I think there's 2 more hearings is what he said that I know of. A final pretrial and a jury trial is set for a couple months from now. But he wasn't able to get video footage of Westerman because they had Westerman leave the courtroom first. They wouldn't let people walk in and out of the courtroom. And he couldn't get his phone turned on in time to be able to catch him before he got out of there. But the news was there. So I think the news should have some video footage of it. He said that some of the guys were filming. So we'll see when we get that footage. I'm going to be looking for it right now on Westerman.
So I just have to say, I have to apologize if you hear any noise. It could be them. They're working downstairs on the furnace, just putting in a couple last minute things. So just ignore any rumbling that you might hear.
Okay. Yes, Zav, Mitch Westerman's hearing did happen this morning. So he went to court at 9 o'clock in the morning Eastern time. And we were live during that hearing, right before the hearing, during the hearing. I mean, but there was nothing, you couldn't go in the courtroom and film or record or anything like that. So we were kind of just in wait until we got word from what was going on. And while we were waiting on that, we started getting photos and documentation and information about the lawyers at the Supreme Court, when they arrived, what they were doing. There was interviews and stuff like that going on. And right now, what I'm doing is looking for Mitch Westerman on any news updates and seeing if we got anything. So 4 hours ago still is the latest thing, any news. So they may have it on like the 6 o'clock news or something like that tonight, probably is my guess.
So on the screen right now, and let me see if I
can do
it. Okay. So this is the tickets that they were giving out earlier for seating at the Supreme Court hearing. So it would be neat to have one of these and have it as a memento of this. So this is what those tickets looked like.
Yeah, you know what? If anybody went there and has one of those, I would like to have that. Or at least a photograph of it.
A photograph of it would be awesome.
Yeah, I would like to have one myself, just one of them, just to have it. You know what I mean?
Yeah.
I mean, I have a piece of the bridge,
Well, thank you, Jinx, for sending me that photo.
Yeah, that's pretty cool. Thanks, Jinx. You rock. So,
and then I know we want to break this all down because this was big, you guys. I mean, okay, just so you can see, I mean, X is all over this, Twitter. You've got a picture of the one judge here already,
Yeah, I put them up there too. I was putting pictures up too. Here, let me make it on the
this one. So
it's mine. That's from me.
Oh, is it?
That's from this stream right here.
Oh, okay.
Yeah.
You've got Barbara McDonald, who put out Baldwin and Rozzi are there. I mean, if you go through the feed, I'm sure.
Oh man, there's a lot.
Protest breakout outside Indiana House chamber among opponents of each. Okay, that has nothing to do with us. But if I go up here and I do a search,
The Unraveling says, ladies and gentlemen, on Twitter. I'm seeing it right now. Mark Lehman. Fire. That's what they put. Ladies and gentlemen, Mark Lehman. And I'm like, it's like a boxing match, dude. You got people on two sides. You know what I mean?
Yeah.
Like,
I mean, here's another picture. That's kind of a neat picture with all of them.
Yeah, with all of them. So
Yeah.
let's see who we can see here. We see anybody we recognize? And I see the reporters. I recognize all the reporters. I see Russ McQuaid right there with the gray hair. This guy in the white shirt, I recognize him.
Yep.
I recognize a few of those people right there. There's Stephen Fabian from Inside Edition right in front of the camera.
This one?
Yep.
Okay. I mean,
Yep.
you've got all kinds of press and everything there.
Wow, man. This is crazy. This is nuts, dude. This is worldwide. I cannot believe this. This is streaming. We are streaming. We confirmed earlier, ladies and gentlemen, we're streaming in at least 8 countries right now. And all over the United States and Canada, South America. It's so crazy. You know what I mean? Australia. Cynthia says, I'm officially concerned of a mistrial. You guys can call in and voice your opinions. To us, call in, let us know what you guys think. You don't have to be on camera if you don't want.
Look at that.
But we have
That's a
room for 10 people.
picture.
That's a cool picture of the State House. Wow, that's a really good picture.
A beautiful picture.
Yeah, that's a really cool picture.
I'll go capture some of these and put them in. Oh, here we go.
Yep.
Interesting.
Rozzi and Baldwin right there. The judge is working today in Allen County, so she was presiding over a case, which is why she wasn't there, but her attorney was there for her. Gootwine. And I think, I mean, okay, so let's break this down a little bit. You guys should call in. Zav, you should call in. Oh, yeah.
But I'll collect these pictures and I'll put them on the Facebook group.
I need to
I mean, there's some awesome snapshots. So, ever want to know? Go to X. X has got it all.
X, formerly known as Twitter.
Yep.
Yep, there it is, ladies and gentlemen. That's really cool.
And this is what it's all about, ladies and gentlemen.
All right. So, all right, Zav, I'm going to take you off of my moderator thing.
Okay, so let's break this down, Anthony.
What?
Oh.
All right. So, okay.
The judges. Okay, so first of all, now all of you have seen the format of a Supreme Court hearing. It is nothing like a regular trial or hearing. You have a panel of Supreme Court justices. You have an attorney for Allen, Rozzi, and Baldwin. Then you have an attorney for Gull. Okay?
Yeah.
As you can see in there.
And those attorneys have attorneys.
Yes. So, as you can see in there, it did not take long for the justices to jump in and ask questions.
Within a minute.
That's the big difference between this type of hearing and a normal one.
Yeah. This one was really good. This was intense, man. I was glued. I was just
I told you it was going to get heated, and you didn't believe me.
No, I mean, I didn't think, okay. I thought it'd be a lot more boring than that. But you know what? Here's what it is. I'm so emotionally invested into this. I can't help but listen to every single word meticulously and pay attention to both sides. Understand that even though I agree with the judge, in my opinion, based on what I know, these guys are the experts, and they can they can change my opinion, right? They could change my opinion. I could end up being like, you know what, dude, I totally agree with the defense team on this now. I'm not to that point yet, but hearing this gives me a lot to think about and analyze today, you know, because it's like, it's something I'm going to be thinking about for the next month.
So, okay, did you hear them with, what if we take everybody and put them back at the court and we make them do it right? Have a hearing, disallow the attorneys. You know, that was thrown in there several times. The fact of allowing Gull to stay on there and Baldwin and Rozzi to come back as pro bono. That was quite asked a couple times. I mean, there's so many scenarios that could happen right now.
And I love it. I love the mystery behind all this. This is so interesting. This has me I'm glued to it because there are all those possibilities. You know what I mean? And
I know
we may get a little bit of each one of them that they decide on, is my guess here. You know, that's my hope. We may get a little bit of each one. This is so exciting.
Okay, Jinx, I will get a hold of you after this and we'll hammer out tomorrow, I promise. Yeah,
Yes.
oh my God.
Yeah.
So many different scenarios that could happen.
What?
It's unbelievable.
Okay, so let's start off with the it is unbelievable. Let's start off with the first person, Mark Lehman. Hold on a second.
Okay. There were things in there that I don't understand how he can conclude that.
I was just checking the screen recording things.
Okay.
Conclude what?
Okay, so like he was saying that this has no effect on the trial. He was saying they are effective trial lawyers, and the fact that this leak had come out didn't make them ineffectual trial lawyers. Well, how is that?
Mm-hmm.
It doesn't matter if they're in the trial or they're doing things on behalf of the defendant before the trial starts. To me, it all matters. And he was saying it doesn't matter. And I'm like, what?
What the hell is going on here? Oh, I got something going on.
So, I was in the chat going, what? Yes, it does matter. You know,
it's does.
Like he was trying to downplay all of that so much when it truly does matter.
I agree. It does matter. And that's where my issue lies within all this, is the crime scene photo leak specifically.
Yes.
That specific one made this case go to this point where we're at with the Supreme Court. We wouldn't be there if that didn't happen. And so the publication and people being public about it, and, you know, Rick, if you're watching, I'm sorry, but it's true. When Rick Snee went public and said, I have crime scene photos and the murder sheet, and I will not discuss, he opened up the first question. How did the murder sheet give them to him? Because if he sent them, the murder sheet refuses, they make a post and say they have them. I get them on a live stream, call the police. They're saying nobody's been reported this yet. And I'm like blown away, you know, and then next thing you know, the judge is, because I emailed the court too and said, man, this concerns me, because if someone does have crime scene photos, it could be the killer. You know what I mean? Like, or it could be someone that knows what's happening. And so I was concerned.
If nothing had been said about those crime scene photos, I do not believe we would be here where we are today.
Correct. If it just kept confidential between the people.
All of us would have kept it under wraps. Those who originally got the pictures would have protected the information, kept it under wraps, and we wouldn't be here today. A man wouldn't have unalived himself because of it today.
Correct. Yeah, and that's sad that happened. You know what I mean?
There's been enough death and loss in this case.
A whole bunch. There's been a whole bunch. There's been a lot of good that's happened in this case, but there's a lot of bad too. And there's a lot of stuff that just doesn't make any sense. It's confusing and it's disturbing, because people don't know what to believe anymore. You know what I mean? When you
Exactly.
got the defense team sitting around saying the cops are straight lying, which is believable because they have been caught with that. Okay. It
Yeah.
is believable. It's like, I don't doubt that at all, that they could have lied to fabricate something or did something. They do it a lot. We see it with Brandon Woodhouse over the crime, over the leak. Brandon Wood, here's a perfect example. Andrew Baldwin also represented Brandon Woodhouse. We all know who Brandon Woodhouse is on this channel. If you don't know who he is, he had a series of videos. He's a known drug addict in Carroll County. He's been to prison. He was involved in kind of that white supremacist type gang stuff in prison and stuff like that. He got emailed from Baldwin discovery material on Richard Allen's case. Baldwin called him and said, delete this. And he said, okay. A year later, he decided, since he didn't delete it, that he was going to air it out to the public on YouTube. And he went live saying that. The next day, the prosecutor filed for a search warrant for his house, and they arrested him. And he's facing 30 years. He's in jail right now in Carroll County. All over Baldwin leaking information to Brandon Woodhouse concerning Richard Allen. Tell me how that's not grossly negligent.
And it's all because of the wrong strokes on the keyboard.
Exactly.
The email was supposed to go to Bradley Rozzi.
Yes, and it went and it went to Brandon.
And it went to Woodhouse.
I can see that BR, and then you just hit enter or clicked on it on accident. I can see there was an accident there. But the fact of the matter is, it does say in emails, and I watched Mark Lopez's video where he said in that emails that attorneys and prosecutors and judges, everybody sends, it says if this email wasn't intended for you, you're ordered to delete it and not speak about it, blah, 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 blah. But people don't really care about that. They're not going to read through all that stuff at the bottom that says, oh, don't, this isn't for you, then delete. And they don't care. You know?
To me, it sounded like the high justices were trying to differentiate between insubordinate and ineffectual counsel. That was definitely a theme of this hearing.
Yes, I agree. It was interesting to hear when they said, I mean, he should have his counsel of choice, right? Now, what was the motive behind that is, well, what capacity do you want them in? Because right now, by law, in Indiana law, the law states that a person who is practiced as a public defender on a defendant's case cannot represent them in a private fashion by law in the same cause number. It would have to be a different case. Correct. I just went through this with the Indiana Court of Appeals myself in the Supreme Court with an attorney out of Lafayette. And he told me that's exactly what the law is, you know? So when you can't hire them because they were a public defender on your case at one time, I don't know if the Indiana Supreme Court will overturn that part of the decision. I think they would keep them on there as public defenders, not let them do it privately based on that.
Well, and that's what they're fighting for, is because they want them to get paid. That guy said that, the first attorney.
Correct.
Why would we want them to come back as pro bono when they could come back as
and get paid for it
and get paid for it?
Exactly. And I think that the Supreme Court could take this case lighter than we all think at this time. We're expecting them to come in there, and I think that people are hoping, and even I'm maybe hoping, that they just kick one out or kick the other out or throw them out and get new ones. I don't think it's going to work like that. I think they're going to be reasonable. I think it's going to be a fair and decision between the justices. Loretta Rush is closest to the area. She's from Tippecanoe County. That was the lady there, Chief Justice Loretta Rush. She was promoted to the Supreme Court not very long ago. I've met her. She goes to dinners in Lafayette and stuff like that. She's a wonderful, wonderful lady and a great judge. She was a great judge in Tippecanoe County. She's very close to Delphi. So it would make sense that she has more of a personable feel to Delphi because she's from the general area, you know. So I think that she may be in it a little more with her heart, you know, than the other ones, because they're just not from the area unless they follow it, you know.
Do you have the screen recording?
You know what? I was actually just trying to pull something up on here.
Okay. The one justice kept saying, and I can't remember what he called it, the Stafford or something, it started with an S. What he was talking about is, okay, if this comes about and we let his attorneys back on and he gets found guilty, basically, are they waiving some right? Is the defendant going to waive the right to appeal on ineffectual counsel or something like that? But he had a term for it and I can't remember what it was, and I was going to look it up.
Interlocutory appeal?
Is that what it was?
Is that what you were, or was it a post-conviction relief, PCR?
No, it started with a S, I swear.
Shepherd? They were talking about Shepherd.
Yes.
Okay.
So what is the Shepherd what?
So we want to go to Indiana case law, and it'd be Shepherd's law. So Shepherd's law is something that you deal with when you start reading rules of trial court procedures and things like that. You have to, it's a law, it's Shepherd's law. And what it does is it details certain things that you have to do in the rules of court, how it proceeds, what you can and can't do. And it cites case law in there as well. So let me see if I can search for it on the Shepherd's. Okay, so it'd be Shepherd versus State, Jimmy Shepherd.
Yep.
And Daryl Shepherd was the appellant. So, and they did say that this is a memorandum decision, not for publication. Let me see here. Let me go through it and tell you guys exactly what's going on here. In the conclusion of that case, the state presented sufficient evidence to rebut Shepherd's claim of self-defense on the charge that he unlawfully possessed a firearm. They further hold that the trial court did not abuse its discretion when it sentenced Shepherd, and his sentence is not appropriate. But it goes into his conviction, and you go and you read a case law. So I'm looking at different case laws at Shepherd. There's another one. I don't think that one has anything to do with it. I'm looking at it that more. Appellant appeals his conviction. Basically, I think what they were talking about is the fact that Richard Allen could not appeal based on ineffective assistance of counsel.
Right.
Because he understands that if leaking those crime scene photos ruins his trial, there is no grounds to appeal on that.
Right.
He understands that. It's just a risk he has to take. Moving forward with the new defense, he wouldn't have that risk. But then again, he would lose all the work. Well, not necessarily. It depends what they wanted to hand over. Right.
That's what I was getting at. They were hammering on that one big time.
Him?
No, hammering on that point of,
yes,
does your client then state that he will not file an appeal based on this?
Yeah, exactly.
If we let him have his lawyers.
Yeah, let's hear what this is.
It's not a question of court's jurisdiction being exceeded, is it?
No, Judge. I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these
Okay,
circumstances.
but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of the bar, if there's a
Oops. I think it's
Buffering.
glitching. Yeah, it's glitching up. I will just back out and come back in.
All right. I thought for sure that I was going to be able to tell which way the Supreme Court was going to go based on their questions. And I'm here to tell you, no way. I can't tell. I cannot tell which way they're going to go. You know, I was just saying, I thought for sure based on the questions that the Supreme Court was asking, I could kind of lean which way tell which way they were leaning. I can't in this one.
You don't know. They're too.
We're not arguing that this court isn't.
They're too back and forth because they have to be. They have to be. They can't be like, well, what about this, and just grill one person. They have to be optimistic on both sides. Well, what if we did do this?
They grilled this guy and they grilled the woman. So
yeah,
and the other guy for Gull, and I'm glad they did.
I love the way they did it too. So okay, so we grant your motion. Now what? What about this, and this that happens after that? Right?
Yeah.
What happens then? And then they're like, it makes them think. Okay, and that's where they're coming up with the law, is because the Supreme Court is now thinking long term, not now.
Well, and she even said that female judge, how do we get this case back on track? And that's what the most important thing is getting this case back on track so a trial can happen. You know?
Yeah. So a trial can happen.
Free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speed.
There you go. When they signed it, they were outside the time limit. Okay, that's what he's saying.
Speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well,
see what I mean? They're telling them to grant a request for speedy trial, and they never even requested one. You can't come in after the fact and be like, we want a speedy trial, and they're not his attorney officially. You know what I mean?
Right.
Wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it for 2 months.
The judge did not remove them.
They withdrew. There was a quote from her, Loretta Rush, in this video that I posted on X, and I want to read it to you guys because I just thought her quote was epic. When she said it, I typed it in right away. She said, there was an agreement to withdraw between the defense attorneys and the judge right then. There was an agreement to withdraw. I think that's going to play a major part in at least her decision on this whole thing. I'm going to make a poll on my channel. Marv, you should make one too.
I don't know how.
So you go onto YouTube and go to your chat. So go to YouTube and then you click the little plus in your chat and it says engage with your audience, and you do a poll and you ask a question. It gives you options to add answers. What do you think the Supreme Court will rule for? I'm going to put rule in favor for. Okay, everybody. And I mean, it's a combination. I guess I'll just put Rozzi and Baldwin. Judge Gull. Or a combination. Both. I guess you could say both. A little bit of both. Okay. A little bit of both.
Hey, how do I get the...
How do you get what?
Here,
Hello, everybody.
hang on.
Welcome to True Crime Investigates and Beyond the Evidence, where right now we are talking about the Delphi murder Supreme Court hearing that happened just moments ago. And Mitch Westerman's court hearing that happened a couple hours ago. We've been live all day here on True Crime Investigates for the last 4 hours. And thank you for watching from Louisville, Kentucky. Greatly appreciate that.
All right, I did my first poll. Mine was,
all
will
right.
Rozzi and Baldwin get back on the case? Yes or no?
Okay. And so I'll leave that poll up for a minute, and then I want to do another poll, and I want your guys' opinions in the chat as well. Leave a comment below. What do you guys think about this? Was Richard Allen allowed to watch that from prison? Do you think so? Think he was watching that on TV? Think they let him go sit down and pull that up for him and let him watch it? I think they might actually do that. Oh, and before I do anything, before I do something, here in a few minutes, ladies and gentlemen, I'll probably have a guest here in just a second that'll be joining. But first, I wanted to show something real quick. Okay, so I'm going to go update on this Mitch Westerman thing real quick, and we'll be right back. Okay.
Okay.
Man accused of leaking evidence in the Delphi murders case, the one that really started all of this, is going to be in court now in less than an hour.
This will be a pretrial conference where they will take a closer look at the case.
Cameron Riddle is in Franklin now at the Johnson County Courthouse with more. Cameron.
Well, that man is 41-year-old Mitchell Westerman. He is being charged with a count of conversion, which is a misdemeanor crime. In the next hour, he's expected to be in the Johnson County Court North Annex here, as he is the friend and former co-worker of attorney Andrew Baldwin, who, as Sierra just mentioned, was part of Richard Allen's original defense team. According to court documents, Westerman admitted to using his phone to take photographs of evidence in the Delphi case without permission while at Baldwin's office one day last October. The evidence included highly sensitive crime scene photos. The court documents say Westerman shared the photos he took with a Fisher's man, who then sent the leaked evidence to someone in Texas, who then forwarded it to all of the different YouTube and podcast creators. The evidence leak has caused a number of problems in this highly publicized murder case, including a judge's decision to remove attorneys Andrew Baldwin from Allen's original defense team. Now, Westerman again is due in the Johnson County Courthouse here in the next hour after 9 a.m. Live this morning in Johnson County, I'm Cameron Riddle, Fox 59 News.
Cameron.
Okay, so now Marv stepped away for just a second, but guess what, ladies and gentlemen? Guess what? You get what you ask for sometimes, right? Watch this real quick. Well, what's going on, Zab
Nice.
girl?
I haven't used that yet. I just always forget the stuff you make for me. I'm like, oh, I like it. It's not that I don't like it. I just forget to use it. Gosh darn it.
Yeah, you don't like it. It's okay. You just don't want to hurt my
No,
feelings.
it's not even that. I just forget. It's like in my files and I forget. I need to put them like in a special file. So just for your future though, Fox 59, don't use them. They copyright it. Sucks.
You know
But
what?
you can
I always
clip
end
it
up
out.
having to go back and clipping it.
Yeah. I just quit using them anymore. I'm like, it's not worth it. Because you'll be like you're going on how many hours? Almost 4 hours. They'll clip you for a 30-second clip. They'll be like, oh, we're going to copyright your whole thing. It's not fair.
Yeah, it's like, no. How about just take that piece out? Yeah.
Yeah.
Exactly. So you have been out of the loop on Delphi. You were
Yeah,
covering it like
dude.
crazy there for like a month all the time.
I
And-
know. I felt
But
lost
you knew
watching
this,
that.
right? You knew this was happening.
Well, I
You
knew.
that
Here's the
that's where we're
thing:
at.
nothing really big has happened since recently, the new documents and stuff. So, like, usually if there's no updates and you know what I'm saying, I kind of like try to find another case. But yeah, now there's stuff happening. I mean, this and how long do you think it'll take them to make up their mind?
Yeah, man, I think it may take up to a month.
Oh, really? Did they say?
That's
Did
my
they give
guess.
any time
No.
frame? Because I missed some of it. Okay.
No, at the very end, they just said that they were going to take this matter under advisement, and the court will render a decision. So,
I think we want different things, me and you, Anthony, with this case. I feel
what do
like
you want? What do
I
you want
want
to happen?
Judge out.
Why?
And I want Rozzi and Baldwin back.
Why? What is she
I do
done?
not like her in this
Why?
case. She's been
Why?
so unfair.
How?
So unfair, dude. I think she has a bias against Richard Allen's defense.
His defense. Well, it's a lie.
And him, because it's his
Right?
defense, like the whole side, which I understand, if she thinks he's guilty, like what he did, if he is, then he did some horrible things to those girls, but she needs to be fair. She's been doing this her whole life, and I don't know. I just don't think what she did was right. And I mean, I get what you were saying about, wait, what were you just saying before this? I wanted to comment about, shoot, right before you played the Mitch thing, I had a comment about, now I can't remember what it was.
What,
Something
the
about
speedy
what she
trial
said.
thing?
Yeah, what did you say about the speedy trial?
Oh, so we were playing that thing. They were saying that they were out of the time limit, is what they said. Hold on, I got it right here. Let me see if I can pull it up. They were just talked about it. So where are we at? 8:09, 7:47. All right, we'll start it right here.
We're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So,
okay. But I understand their point. Well, they never got a chance to file it, though, right? Because everything happened. I mean, I could see why they wouldn't have. I just think that Richard, he freaking wants his lawyers. Let him have his freaking lawyers. They want to represent him. Like, what? I don't understand. I mean, I know they screwed up and they got punished for it, and like they were trying to talk about the difference between ineffective and subordinate, and I think they did a great job at doing that. Case in point, yeah, they're not ineffective at all. She didn't prove they're ineffective. I'm sorry. So I think they should still represent him. That's all. I really want them for him. I think he's going to get the fairest trial or the fairest representation. Now, seeing some of the new documents, I do see that those lawyers might be going the same route and might look into stuff so that maybe they'll give him a pretty good deal. But if this is what Richard wants, then you know what I'm saying? If they don't give it to him, he could have it. Don't you think he could appeal that if they don't give him his lawyers that he wants? Are you froze, Anthony? I was wondering. I was like, he's standing awful still or he's froze.
It's okay. I'm back.
Marv, okay. What's up?
I had to let the dog outside.
Okay. Aww.
Normally, I've had her run. She's run like twice normally by now. And she's like, Mom, let's go.
Wait, what kind of dog do you have again?
I have a black lab.
Oh, I had a black lab. My Rocky was a black lab mix. I like labs. They're so precious. So yeah, I don't know, Anthony. I know you guys a lot of the people in here think like don't agree with my take on it, but
That's
just how I
okay.
feel.
Everyone
I
has their
know.
opinion. That's what's
think the
fun about
reason-
this.
I think the reason people are hesitant is because they've shown their incompetence by giving the documents to Woodward. They've shown their incompetence by the 136 Franks motion, and especially the crime scene photos. And what happens, it's a pattern. So what happens if they continually do this? Then we're going to be right back where we are now, because if they do it again and it happens again, they are going to get booted.
But what else is left? The trial's about to happen. If they keep him, the trial would have happened, and then bam, everything would have been out. I don't think there's anything left. You know what I'm saying? I think we should just get on with this trial, right?
Well, I agree. I want the trial as much as you do. You know, I don't want to wait another year for the trial.
It would have been this month, dude.
But I want him to have a fair trial so that when the outcome happens, we know that both sides did everything they could and did it the right way so that there's not a mistrial, so that there's not significant reasons to have a new trial. You know what I'm saying?
But don't you think if they don't let him have them, there are? Is that what I don't know what you're I don't know what you're saying. Do you think they should let him have them back, the lawyers, or not? Because if not, I feel like he could definitely get a mistrial or right if they don't let him back.
Well, yeah.
Maybe. No, not after the Supreme Court rules.
See, I missed some of this. Really?
Well, after the Supreme Court rules, that becomes final.
Okay.
If the Supreme Court rules and says, no, they're not coming back, that's the end of it. There's no mistrial. There's no appeal for it.
There's no, he doesn't have any means to appeal, you're saying.
No, because they went to the Supreme Court first. They didn't go through the proper channels.
Well, he would have to waive his right to appeal by understanding that by keeping the attorneys, if for some reason that what they did,
he keeps him, Anthony. But I'm saying if he doesn't keep him, though.
If he doesn't keep them, then they're gone. They got rid of for those actions, so they've been punished. That's been resolved, right?
Yeah, but
it's almost like they went to jail, did their time. No, he wouldn't be able to appeal because, well, I mean, how he would have to waive his right now.
The only way he could appeal with his new lawyers is if they did something wrong.
But wait, didn't he file that? Didn't Richard Allen actually file a document that said, I want these guys as my attorneys and I understand and waive any conflict?
Yes.
Did he say that in the document, though?
I don't know if he said that.
Gardner and Gal brings up a good question. Is that I don't know the answer to that. Can you put that up, Anthony? And what do you know?
This one?
Yeah,
if the lawyers were insubordinate, is there no
what's the punishment? Because should there be another punishment not getting rid of them?
There can be. And actually, Baldwin's attorney is the one that laid that out first and said what punishments could be. He said if the court wishes to issue a sanction, they could order Mr. Baldwin to work for Mr. Allen for free, for pro bono, as a community service type deal for his actions that were against, you know what I mean, the judge's orders. And so that's why I think that they may side with them, because their own attorney said that. You know what I mean?
Yeah.
But what do you think that's so different from me and you? Like, what do you think that I disagree with or don't want?
No, we do. We have different views on this. That's fine, though. I'm not.
No. On which part? Because
on
I'm
all
totally.
Of it.
On all of it?
On like the bigger picture of what we think, of like the bigger picture of what happened. Now the little specifics, maybe not. I don't think it's what I'm doubting it's the narrative they're pushing that Richard came, did it by himself. Like I don't think that's true. I mean, in my opinion, I feel like I'm having trouble believing that. I mean, it might be, but I'm doubting that that's true.
Besides that part, what about this part? The judge versus the attorneys. What do you think?
You want the judge to stay, right? I want her on.
But you think I want the attorneys gone?
I don't know. I thought you did.
I would
Baldwin be okay if they were all gone.
I think Baldwin has acted grossly negligent with the three different things that he's done. I think he deserves to be gone. I think Rozzi could stay back on, at least keep part of his counsel so they at least know what they're doing and talking about when they move forward in another direction, and get rid of the one of the other public defenders, whoever the assistant public defender is. This is what I think should happen. Baldwin gone, judge stay. Okay. Or Baldwin gone, judge stay, Rozzi stay, and Rozzi take the lead point now because he's more familiar with the case, and have the not chief public defender, not William Labrado, Robert Scremin, as his backup man. So I think Rozzi and Scremin should represent Allen, because Scremin is now appointed to him and is familiar with some documents and some new filings, and he's already filed a document. And
I like
Rozzi,
Scremin better than
so I think Rozzi and Scremin should represent him, and the judge should stay, and we move on with this. And
but wait. So you think Rozzi should be appointed and get paid?
Yes.
Okay.
I don't, because I don't think that by law they can't act as a private attorney on a case they were acted as a public defender and then removed
Yeah,
from.
but they were. Why didn't the Supreme
They're
Court say that?
because
They're acting like they're
they may
considering
entertain.
it.
They might, because that's what's going to happen here, Zav, is they're going to set case law. All these case laws they're citing, one day someone's going to look back and watch a court hearing just like we are one day, and they're going to be like, well, hold on, Your Honor, in Richard Allen versus State of Indiana,
that's true.
in the Delphi, you know what I mean? This happened. And that's the cool
So
part about this.
maybe.
This is like, this is freaking history.
Yeah,
But
they
I
probably
think,
will
I don't know.
cite this.
I like the defense attorneys working very hard for him.
Which ones? Wait.
All the Rozzi and Baldwin are they busted their ass to do
I know,
that
so, but you want Baldwin gone.
because of his leak to the crime
But
scene.
I feel like
photos.
Baldwin is the leader in them too. Maybe not. I don't
He
know.
is.
I feel like he's the one like leading them too. Like if you get rid of him, then you get rid of the whole thing. I mean, you'll still have Rosie's probably still good, but I think Baldwin is the one like that's really, got it going
Hammering
on,
out
in my opinion.
the
Yeah.
plans and stuff. Yeah.
Yeah. So I don't know.
Okay.
But,
So
go
in
ahead,
this
Mark.
letter, October 11th, 2023, Dear Judge Gull, please accept this letter as confirmation that I have communicated with my attorney, Bradley A. Rozzi, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rozzi the potential impact that the distribution of these documents could have on my defense. Attorney Rozzi has also communicated to me that the prosecutor has requested that my attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rozzi to continue to represent me until this case is resolved, one way or the other. I believe they are acting in a manner that is in my best interest. I appreciate your time and consideration in this matter.
But okay, but he didn't say he
did
says
not say
that.
that he waived any.
Yes,
any
I don't waive any
future-
conflict of interest for ineffective assistance to counsel.
Right.
So that's what the Supreme Court, could he appeal on that if it happens? On either way, could he ever appeal for ineffective counsel on either side?
That's what I'm wondering.
I don't know. This is they're going to have a tough decision to make on
missed,
that.
I wish I would have seen it all because I missed some of this. So I'd have a little bit more informed. I missed some of the hearing this morning. I wish I would have seen it all, but so.
Well, we can watch some of it. I mean, I've got
No,
it.
it's okay because I'll probably watch it on double speed to get it caught up as quick as possible because I got so much to do today. But I mean, I think I did see like I saw enough, and then you guys are filling me in on some things. But so I like the Supreme Court. I thought they were being fair. Well, at least them like trying to get the information. It seemed like they're going to be fair, but I guess we'll see.
Yeah.
I don't know. This is tough. So you guys don't have any idea what you think that they're going to come to the conclusion?
No.
You know what? I need to watch this thing 2 or 3 more times.
I do too.
And go through it and analyze it and just like and think about what they're asking and where the mind frame is, because I mean, like I said earlier, they can really sway me back and forth on this, because I was listening to some really good points by the attorneys on each side, and I was like, yeah, that's a good point, dude.
Yeah.
Great way to look at it.
I agree.
As vocal as I am about how I feel, I think I'm just more interested. I think my issue is I'm a little biased because I'm from there, and I want justice so bad because it's been on my mind for 7 years. Every day I've talked about it.
But don't you want it to be good justice, though, Anthony?
Yeah,
Think about
I
how
do.
you've been
I do.
unfairly treated. You
Yeah,
don't
I
want
know.
that to happen to somebody else, so you got to take that in consideration, too. You know that they're unfair. Look what they did to you, so don't think they're not going to do it on this huge case. Don't think they're not going to be slimy on this case. They're going to do the same thing, if worse.
The way I look at it is at least he's getting treated the same way I did.
Yeah.
I don't know. I mean, that's how I look at it. Finally, someone else goes through it. Yeah, I know what you're going through there, Ricky, or whatever his name is.
I don't know. Like, a part of me is like, it's him. Then a part of me is like, no, I don't know, though. Maybe it's not, dude. Maybe it's
Okay,
not.
but why would they just? some random dude that's never been arrested before and
But-
just snag him up from CVS. Like, hey man, that dude at
Oh,
CVS
but
kind
I
of
could
looked like.
think of a lot of reasons. We've been through them. There are some reasons, I feel
Then
like.
why, if it was
You
you,
even have brought some reasons. What are
you're
you
right.
talking about, Anthony?
Well, hold on. If you got arrested today for the Delphi case, okay, and they're walking you in court tomorrow morning, and we're standing there, and I got my camera there, and the news is there, and they're filming you, are you gonna say anything? Did you do it, Zav? Did you do it? What would you say?
No,
You would say no?
probably.
He
But I
ain't.
don't
He
understand.
hasn't said shit.
He has never said
He
that.
doesn't even bat an eye. He doesn't smile. He doesn't.
But
I'm
maybe his
not
attorneys
guilty.
told him don't say anything. I don't know.
He
You
didn't
don't
even
know.
have an attorney the first time. You know what I mean? Like he walked in there and looked at the family members and just like, I mean, this dude, I think he's smart, man. He's very smart. He's not a dumbass. I
Everybody's
just think that if you were innocent and you were just some random dude that was picked up, you'd be screaming at the top of your lungs, like, dude, I didn't do this.
It's not
Like,
true though, but we've seen people that are guilty as crap going, I didn't do this, professing their innocence. It's not always that black and white though. That's
I
the
know,
thing.
but an innocent person really would, I think.
Not all the time. You would, but it doesn't mean
Hell
everybody
yeah.
would.
Hell
I'm
yeah, man. 'Cause
serious.
I'd be
I
like, dude,
gotta
I
always
didn't
keep
do.
that in mind. Just because I would do something doesn't mean everybody would. And I don't
You're
know what
right.
I would do. It depends. I think, you sure he didn't get any counsel before he went to court? Anybody giving him advice? Are you
Yeah,
sure about
because
that?
correct, because he told him he was going to hire private counsel first, and they said okay, and then he wrote him a letter and said, "Oh, now I want private counsel."
Okay. No, I'm
'Cause he-
talking about public. He didn't have a public defender. He didn't have anybody
No,
come in and
because
talk
he
to him.
couldn't afford it. He
couldn't
couldn't
afford it at
afford
first.
public.
Public
That's what
defender.
No, not public defender. He couldn't afford private.
No, but what
private.
I'm saying is you're saying he didn't have anybody. You're talking about the first very hearing that he was at. Is that what you're
Yeah.
saying? He didn't
Yes.
get any advice from anybody, you're saying.
No, you're not
counsel
allowed to.
talked to him at all. Like
No,
no
that's
lawyer talked to him. He didn't get any after being arrested for murder. He did not talk to anybody.
correct. No, you don't. You go in and you
Okay.
see the judge, and the judge says, "Here's what you're charged with." Reads the charging information, and then says, "Bond in the matter is this,"
Oh,
and then says, "Do
I've done
you
that.
you know
You're
what I
talking about
mean?
like the arraignment
Do you
type where
want?
you're
Yeah, it's an
okay.
arraignment. They call it initial hearings in Indiana. Yeah, do you want
Yeah,
an
you're
attorney or
right.
do you want to
Okay.
hire one? He said he'd hire, so he didn't have one the first time. But he didn't say anything in that hearing of why was I
Well,
even
what do you
arrested,
say?
dude?
But
Well,
what would
you
you
know
say
what? If
though?
the first thing I say was, man, why was I even arrested? Because I don't think that I did anything wrong.
But
But
then
do I
people would
understand the
go
charges
against
against me?
that
You're
and be
accusing
like,
me.
but Anthony, you know, people
So
be
think
like,
about
oh
this.
my God,
They're
how
standing there
dare him
saying,
say that? Why doesn't he just take, you know what I'm saying? People
yeah,
will
but
get on him no matter how
yeah,
what he did.
they would. But I mean, like, I don't know if it was me and all of a sudden they pulled me in jail and then all of a
If it
sudden
was
said, hey,
you,
dude, we're
I
charging you with
guarantee you
this.
would be
I'd be
loud.
like, are you freaking, I would be loud. I'd be
I
like, are you
know,
freaking
but
kidding me? Oh, no, I'm not. You're charging you with that, dude.
but
I don't
everybody's
know.
different. I know you would. I could see. I don't know what
I
I
know.
would do because like I was charged with something I didn't do, but I didn't go in that court. No, I'll say this. I didn't go in there when in my arraignment and be like, I didn't do it. I just like was nervous and I sat there and I said what the judge said. Like, and I didn't do
Did you
what
do it?
No, so that's not true. I just sat there and did what they told me. I did when I got to my lawyer and I had to do stuff, and then they told me, and I had to end up pleading guilty because I went through this program. But then I told them. But I'm saying like that first one where you just get arrested and then you go for your arraignment. I just
Yeah.
sat there, listened to what they said, and went back to my cell. Like, no, you don't. I didn't say
You're right.
anything.
I guess it depends. But I mean, okay, so I guess for me is I usually know I was guilty. So I'm like, yep, there we go. I didn't
Oh,
know yeah, I'm basically just sitting there going, yeah, dude, what he's
Oh,
reading is true, but I'm going to plead not guilty so I can get a better plea deal. That way I don't get hammered here. Like, that's just the way I look at it now,
Yeah.
that's funny.
So
But
I'm like,
just
yeah,
remember,
I'm
everybody is different though. So
true. That
he's a
is true.
unique character. He's not the norm. He's definitely have a unique personality. You could tell. He's quiet. He's a very introvert, which is that does make sense that he would have been quiet. And he's not an extrovert. You could tell he's very like into himself and stuff. So that makes sense. Him staying quiet. I
He's
wouldn't
a
have
little
expected
dude.
him to say anything, to be honest. The way he is, but
He's a little dude too.
he is. Maybe
It's kind of,
little people. I'm little. Maybe it's because we're short. We're like, ooh, no, I'm just joking.
he's like 5'4".
Because a
How
lot of
tall are
times,
you?
like you're little, I'm 5'2", but a lot of times, like like little dogs or whatever, they're actually extra feisty because
Oh,
they're
yeah,
like making up for.
exactly. I'm one of
But
those little dogs, I guess.
you're just I don't
Marv.
even know. Yeah, but it's cool. I mean, everybody's different. Marv, what would you do? I don't know what you would do. I don't know you well enough. Would you like stay quiet or would you be like, I'm innocent?
If I was innocent, I would be shouting it from the rooftop.
Do you think though, if you just got arrested, you've been in jail all day, you go, you're nervous as crap, and you go to the judge and you're nervous, you don't want, you know you didn't do it, but you don't want to mess up anything, you would sit there and be like, I'm innocent. I don't know. You really would?
Yeah.
Wouldn't you just like follow the rules and be like, okay, I'm going to go through the process. I'll have my time to fight when it's time to fight. You know what I'm saying?
No, I'd be
That's hard to
shouting it
do,
right
dude.
away.
That's hard to do, I think. I mean, you're on trial, dude. This is your whole, yeah, but
trial, but I'm saying that
wasn't
first
your
thing,
whole
you're talking
life.
about that first arraignment thing.
Yeah, but it wasn't our whole life either that we were facing. We were just facing a little bit of time, really.
That's true. That's true.
You know,
But
I mean,
I
if I
still
was
think
facing my whole
that
life,
first
I might
one, I would
change.
just wait till I talk to somebody. Because I know, like, don't be stupid. You might say something that, you know, you might ruin it. The judge's not going to like you. You're going to act, you know what I'm saying? Just like follow the rules, talk to your attorney and do it the right way.
Yeah, well, I hired an attorney last time, Curtis
I did
Fouts.
too, and I had to fire him because he sucked.
Yeah, well, the time before that, I represented myself. I went ahead and took it on myself and represented myself and did well. Actually, great. You guys can find all those motions online if you just look up my cases.
Who was your attorney?
It was myself.
But you said you didn't hire.
Curtis Fouts.
What? I thought he was a judge. Oh, it was before, after he was a judge, or?
Yeah, of course. I hired him right after that.
Oh, he didn't have a very good reputation.
Yes, he did. Listen, man, just because the man's a pimp doesn't mean he's,
That's
you know
true.
what I mean?
That's true. But like people were
Here
thinking he
was
was
my
like
thought.
involved in the.
I
That's
know.
why I was looking at him all side-eyed. But then I
Well,
realized
that's perfect for YouTube views, right? So I hire the attorney and people are like, oh,
Look
and
at
they
that.
come to my channel and
We're on
watch.
Twitter.
that's true. That's true.
We're
You know,
on
I
Twitter.
don't know. It's just fun. No, so do you think Richard Allen was watching from prison today?
I don't know. You tell me. Did they allow that stuff or?
Well,
I
yeah,
don't
he
even
watched
know.
TV and stuff like
It's
that.
affecting him, so why not?
Yeah, why not? Why not let him?
Were you in the same prison as him or no? Or is that a
Yeah,
different? Okay, so they
not
have.
Wabash, Westville.
Oh, okay. So, yeah, he probably but a lot of the times they don't let you watch things that to do with your case, right? Well, he
No,
should have a
they'll let
right
you
to
watch
his
whatever you
case,
want.
right?
They don't. You can do whatever you want in there.
Oh, okay, okay.
I mean, there's
So-
people walking around smoking and doing drugs and stuff. And the guard, there's only one guard, or maybe one or two guards per like 300 dudes.
I would hope he would watch it. I mean, it's important for his case, but why wasn't he there though?
There's no reason for him to be
Because
there.
he's
That's not a
in the-
debate. That's not his case. That's
Oh.
that's his attorneys versus the judge. It's about him, but it's not a hearing that he necessarily has to be present for because it's not going to. I mean, it's
just
not
like
his actual
the
criminal
reason
trial.
Judge Gull wasn't there. She didn't have to be there.
Oh,
Her attorneys were fighting for her.
that's true.
Yeah, and
it's
Rozzi and
not
Baldwin
like
didn't
they
speak.
could talk. It's not like Judge Gull could go up there and talk, or Baldwin or Rozzi or any of them. Their attorneys had to do the arguments for them. So why pay all that money to have him transferred there?
That's true.
And where are they going to put him in that room full of people and keep him safe?
That's true. That's true.
Yeah.
Yeah, they'd have to get the security, and yeah, that's true.
Security is a big
watched.
risk.
He watched. They like let him watch it, and it was like the time he could watch. You're saying he has a TV in his cell? You think?
No, he doesn't have one in his cell, but there's like he can see one from where he's at. I guarantee it. I know. Well, I don't know where he's at now. Westville, yes, I could have said I know what it looks like. I don't know where he's at now, so I can't comment on that one, I guess.
I wonder if he's happy the way it went today and stuff.
He's probably just as nervous as we are.
Oh, he's
More
probably
so,
more
it
nervous.
affects his
Yeah.
life. I mean,
It
he's
affects
going
his
to
whole life.
be. Yeah, this is his life we're talking about.
Yeah, he might just be in like a alternate like type. You know, it seems like he's just so out of it. Like almost like you almost have to be to like. I don't know. I would probably disassociate from reality if I was like. I don't know. I'd probably just like get my own little world in my head if I was freaking doing life. I don't know. That's
Well,
hard.
I'll tell you what solitary confinement can do. Have you ever? So you've been in jail, right?
Not solitary confinement. Yeah,
Okay.
but not
All right.
solitary.
How long did you do straight,
Just-
like without getting out?
Just a few days. I didn't do
Just
like
a few
major
days.
time.
Okay.
Yeah.
Marv, you've never been in jail. We took a poll last night asking my viewers who's been
Yeah,
to jail in
never.
prison. So there goes a period of time, like when you go in there, you go through like this depression phase, right? First, it's like, oh my gosh, the world is over, and you cry a lot, and it's just, you feel bad. And then you start to get a little better the more comfortable you get in there. But he is in solitary. Okay. So he only comes out for 1 hour a day. Sometimes he has a dude sitting by his cell to keep him comfort, because he has been known to be talking about self-harming himself. You know what I mean? So he doesn't communicate with very many people, and the people he does, he has to yell through the door, you know? So he's never been arrested before. So to take someone from their everyday life and throw them into that environment like that, where you're just like locked in the room and you don't see people too often, I can see how it destroyed him. I see why he
Yeah.
got skinny, but now he's getting more weight on him. I think he's getting more used to he's getting
Was
somewhat
he
better.
really in a mental institution though? Because he might have been alone in that. Was that true that he went to one after?
I guess he went to the hospital for help, which, yeah.
Okay. Was it right after? I just never been able to find
Before.
confirmation.
I thought it was before.
Oh.
No, I
that
thought
the
it was
police had been
after.
called.
I heard after too.
It was after that?
Yeah,
After
that
the
same year,
murders?
like months, just a few months
After the
after.
murders.
Yeah, that's what I
That's
heard.
what I heard.
It's in one of the reports that we have in one of those documents
It
somewhere. It does
is?
talk.
I haven't been able
Yeah,
to
it does.
confirm. Oh, I need to see that.
It's, gosh, Marv's got like a whole bunch of documents on her Facebook group, but like I wouldn't know where to find it,
See,
but it is in there.
that's very telling right there. If that's true, that's why
I
I
have
wanted
a
to
hard
confirm
time
that.
finding it.
Because if he went there a couple months after, they say like look for that. When we were like for murderers, it's like
Change
look
of
for different
appearance.
things. Yeah, and that
The
that would
beard
be
went
definitely
away.
one thing to
He had a
look
goatee,
for.
and then he went
Yeah.
clean shaved. He cut his hair,
Then he gained weight a lot
and
right
then he
after
gained
that
a lot of
too.
weight, and then he
Yeah.
grew his beard out. You know what I mean?
I don't know. I want to see if you guys do find that in a report. Let me send it to me. I'm curious.
You know what's even weirder, dude, is like, look how he looks like
I know you showed me
the
that.
dad.
But I think that's just a coincidence. Why would he try to look like the dad?
I don't know.
Why
think
would
it
he
was
go do?
purposely?
Why would he commit the crime
That's
if he did it?
true. That's true. But we don't know if he did. See, you're already saying
Right.
like you know
As
for
to
sure.
but I said if he did. If he
he
did.
did, yeah, I guess that would because I think Libby was the target. It seems like so.
Looks like
Maybe.
it.
I don't. I just what's the motive?
did
Like
look
I want to
like
know
it.
why. Why did he? Whoever did this? Why them? Like was it planned? I wish we knew that. I don't think we're ever gonna know.
I think we might. I don't know. I don't know. We may never know. If they can ever find, if let's say there is a connection between Keegan Kline, the Anthony Shots profile, and the catfishing thing, right? To get him there under the Anthony Shots profile, which they thought they were going there for. Let's say there is a connection for real between him and Richard Allen, and Keegan or somebody told her Richard Allen used the account and knew they were going to be there and showed up and did this crime. Right? So if we say that that happened like that, what if the police just can't connect it? You know, then they know it, but there's just no proof to it, but there's nothing there. Then Keegan walks away without being an accomplice, but he's screwed anyway because he just got 40 years anyway. And I think that's why they hammered him so hard.
Yes, I would agree.
Like, we can't pin you for murder, dude, but we're certainly going to.
So you
Wow.
think
He failed a polygraph when they asked him if he knew who the killer was.
I know.
So,
it's weird.
but it's not admissible. I know, though. This case gets me so excited and riled up.
I mean, it's admissible in Indiana court. They are allowed to bring it into the court, but it doesn't mean that it's like fact. Like they could bring it, look at it. Indiana is one of the ones that's admissible, but it doesn't mean it means like it's conclusive or anything. But they could use it. But I don't know. I don't know how I feel about that because why not try to get the truth and try to like get the truth out of Keegan then if he's involved, you know?
I don't know. I think the dude he had his opportunities.
Yeah, but they could just keep going at him until he breaks, maybe.
He did break. I mean, they took him to the Wabash River. What do you think he told him there? Was that related?
So you're thinking they know then? He told him something? I don't know.
I'm thinking he tried to. I don't know, man. Here's where we're missing it all, and I don't know. It's because I think yes, right, but in the back of my head, I'm like, okay, I think yes, or I want yes, but I don't necessarily believe it fully.
Right.
Because I think that he tried to give him information. They couldn't find anything at the search in the river. And they're like, all right, dude, we're done screwing with you. No deals. It's off the table. You're getting whatever the judge decides, period. Okay. And that kind of ruined his opportunities. And he's like, well, I have information and they won't listen to what I have to say anymore. Well, maybe because they just determined that you're full of crap. You know what I mean? That's what I think. But
And you're yanking their chain.
yeah, maybe he's just trying to get a better deal and just saying he knows something and doesn't know anything. Maybe he said there was a knife in the river that he threw there a long time ago and knew it was there and just tried to say, I know where the murder weapon is in the Delphi case. You know what I mean? Like just something, who knows? Maybe he was trying to just get a better deal, but maybe not. I don't know.
I would polygraph him again and rephrase some of the questions, because it could have just been like a fluke, just to see if it still keeps doing that. I don't understand why they wouldn't, unless I guess it's voluntarily. They can't make him take a polygraph, but I mean, if he already took one, you think he would take another one?
Especially,
Why?
you know what, if well, because
when he's already failed one, why would you take another one?
Because ask him different questions and reword them and try to catch him in a different slip. Ask the same question, but in a different way and see what he answers. They'll be able to tell.
Yeah.
I mean, I don't know. The dude's such a liar. It's hard to decipher what he says, I think. I mean, look what he does. His thing.
Still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons?
I'll be right
that
back,
the trial
okay?
judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that just. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds, but so I don't see how these three violations.
Okay, so this is what I got mad at. I'm gonna play that back here. Hang on.
Conflicts are waivable conflicts, and other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that just. No, because these issues have nothing to do with effective representation at trial. So
how can he say that has nothing to do with effective representation at trial? They do. That's what I didn't get. I believe they do. I don't know what everybody else thinks, but I do.
I don't think he could pursue them on those grounds, but so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So yes.
Okay, so he just said there he thinks he would be waiving it by keeping his attorneys on. Okay.
He would have to.
He would have to.
I think. But I like the way they ask those questions and stuff like that. And try to put it out there as like, well, what if we did this? You know?
Right.
This is such an interesting thing. I mean, I think that I mean, screw it, dude. Let him have the attorneys. I don't care. You know, I mean, if that's really what it comes down to, all it comes down to is the attorneys. Let's do it then. You know what I mean? Like, but I think they wasted all this time, or maybe this was strategy. Maybe this was strategy. Maybe they are doing this to waste time to keep building this defense. That way, whenever the Supreme Court
No,
makes a
because
decision,
this guy said they had the prosecutor on the ropes and they were ready for trial. So why would...
But they were complaining the whole time that they didn't have all the documents.
That's true. That's true.
See, that's where these snaky lawyers come in, man. Because
I know.
They're good with
Oh.
it. It make you think about it.
Zap,
You know what I
you're
mean?
frozen,
Did you die,
man.
Zap?
Oh no.
Am I? Oh, sorry, I was texting. Okay, sorry about that.
I thought you were frozen.
Just like,
Oh my gosh. That was funny.
Hold on one second. But I want to hear what you guys are saying.
oh, you weren't listening for that last 10 minutes, but I was asking you a question.
You asked me a question?
Yeah, a whole bunch of times.
And I just ignored you?
For probably about 10 minutes, I think.
You're lying.
Seriously, that's why I said, are you dead?
Dang it. Ask me again. I'm sorry. I'm getting people.
I'm just kidding.
Okay.
I'm just kidding. I'm just messing with you. It's funny. You know what? That's how I am too when I'm on a stream.
Yeah, I need to
Right,
put,
I
that's
think
why I
we
have it
got
on
all the-
silent, but sometimes when I see it with my eyes, I could see it. That's why I need to put it out of my eyesight. Okay. Anyway.
Nothing. I'm looking to see if I can get Mitch Westerman, man. Nobody was able to get a video footage of this dude. That's gonna blow my mind if he got through there like that.
I know.
You know what I mean? If he got through there and none of these news outlets got a video of this dude, that snake, there he is. Got him.
Did you? I was looking on Twitter.
Got him, dude. Got him. All right, hold on. Let me download it and pull it up. Yes, we have the video
It's
of
a
Mitch
video?
Westerman. Yeah, Mitch
Nice.
Westerman. Mm-hmm.
Walking out of court or something?
Walking into court, it looks like. And probably out. Let's see. Download.
Wonder how many people.
You
So
got it?
you
Okay.
ended up getting a link. So you were streaming right from you got a hold of Indiana, right? Or
Yeah,
so
we got a
wonder-
link right.
Dude, why you should have more views? I wonder who was all streaming. I only found a couple people streaming.
There was tons of people streaming. I saw Defense Diaries on there, and they had.
He's on there
over,
right now. 1.2 people watching.
Oh, they were streaming it?
Yeah.
Mhm.
Oh, okay. Who else?
It's all right. Our little channels will grow.
Okay.
Yeah, we're not.
I mean, we've been on here 4.5
not-
hours.
You know, I know. You know what? Today I'm probably going to beat Zavs. So you guys can go take a nap. Come back tomorrow. I'll be here still talking about this.
How long do you think you'll be? Hey, I think what was mine, 12 hours or what was it? I forget. But you got a
12
you still have a
hours?
long way. I don't know, maybe 10, 11. Remember I thought we looked at it. I thought Anthony and you figured that out or something when I thought
Anthony
it was.
and you. Yeah.
I thought
Me and
it was a
Anthony.
time and then I saw it was longer. Was that you? Hold on.
Yeah.
I don't know, but
It-
you
it
did at
was.
least have
Yeah.
10. I know it's at least 10 hours, but it might be longer. So you got
All
6
right,
more
we're-
hours.
But we're good. We got 6 more hours of Delphi, everybody. Are you guys ready for that?
With all the documents I have, okay.
All right. Let me share my screen. Let me remove this thing.
All right. I have to go to the bathroom again. I'm drinking water, and it's going through me.
Okay, so let me share my screen right here. And watch this, everybody. Hold on.
so much. We will check back. We want to let you know that there was another development today related to this case. A man charged in connection to a leak of evidence in the Delphi murders case faced a judge this morning. His name is Mitch Westerman, and he is now charged with a misdemeanor conversion. Here's some images of him in the courthouse as he went into the courthouse in Johnson County this morning. Police say it was back in October of last year that they were notified of evidence from the murders of Libby German and Abby Williams released to the public. Detectives learned that Westerman is an associate of Richard Allen's original defense attorney, Andrew Baldwin. Westerman told police that he saw printed copies of photo evidence on a conference table in the office of the attorney, took a picture of it as he met with the attorney. Westerman then went on to share those images that he took, and they ended up in the hands of various YouTube podcast creators. In the hearing today, this morning, the judge set another hearing date for the month of March. And that hearing this morning that Karen Campbell attended lasted just a few minutes. Well, as we continue step by step to follow this case, we want you to know that all of the updates that we have, we put online and bring them to you on air. So make sure you download the WTHR app on your devices. It's free.
And so is subscribing to True Crime Investigates, Zab Girl, and Beyond the Evidence. It's all free. It's all free for you guys. There it was, Mitch Westerman in court.
Has he been in jail the whole time or no?
He's not in jail at all. He bonded out.
Oh, okay. I didn't know. I haven't followed him.
Yeah, he got arrested and bonded out.
So he bonded out. So who is his lawyer? It almost looked like, I know it can't be Baldwin, but it almost looked like Baldwin walking in front of him. Who was that?
Michael J. Kyle.
Okay.
Let me see if I can go pull up.
I just saw him real quick, but maybe he doesn't look anything like him, but that quick he did.
Oh my, you know what? Dude, he does look like Baldwin.
Let me see. You gotta
wow. Hold on. Let me go back. This is cool. He does look like Baldwin, everybody. I can't believe you caught that. I didn't even look at that dude. All right, let's take a look at this one here. There he is.
His name is
that guy.
Mm-hmm. Yeah. So it's like, is that Baldwin?
Mitch.
But I knew there's no way he'd be allowed to have Baldwin as his attorney. But dang.
That would be hilarious, dude.
That would be
Baldwin was there and there.
Yeah.
Westerman, and he is now charged with a misdemeanor conversion. Here's some.
Well, he looks a lot better than his mugshot. His mugshot, he looks like a crazy person. He looks like a normal guy in his suit.
He's got like no chin.
That's true. Doesn't got a strong chin.
Morning. His name is Mitch.
There he is.
Westerman.
Is he a redhead?
Yeah, it looks like it. I mean, the name Mitch, I think you have to be, I don't know, Mitchell. I think when I think of Mitchell, I mean, I don't know. I guess I went to school with the kid like in grade school that was named Mitchell, and like I just always remember Mitchell with red hair, freckles.
That's interesting. I'm gonna remember that now when I meet a Mitch, and they'll probably have red hair.
That would be funny.
He is now
or they won't, and you'll be like, Anthony's totally full of crap, dude.
You might be right. Any Mitches in chat?
Are there any Mitches in the chat? And if so, what color is your hair?
Yeah. Or do you know any Mitches in chat? Like people in chat know Mitches, and are they redheads?
Yeah. And do you have a chin?
It does appear that, wow, that's crazy.
There he is, everybody. So Mitch Westerman got set for trial, or case set for March.
Yeah, Modern Family, Carly. Yes.
Modern
wait,
Family.
why am I thinking which one's Mitch in Modern Family? Is that his real name? I can't think of the character's name. It's been so long since I've seen it. And there's a redhead. Is his name Mitch as the character, or is his real name Mitch? Sorry, I had to respond to her because I'm not sure. I love that
I'm
show,
not
but
sure.
I forget all the names of everybody. But there's a
Mitch,
redhead.
it
The
is
gay guy's
Mitch.
a redhead. Is it a character?
His
or
name's
real
Mitchell.
name?
His name's Mitchell. Yeah, the gay guy in Modern Family. Yeah.
His character's Mitchell. Okay.
His
So
character's name is Mitchell.
That's
Mitch and
classic. I
Cam.
mean, you think if they're like making a family, so like they're gonna go with stereotypes. Okay, let's name him Mitchell. He's redheaded. I don't know. You might be onto something, Anthony. I never noticed.
Everybody look up the word Mitch and see what all these people see if they're all redheads. If there's something there,
That's
we've just
crazy.
uncovered a new Darwin theory.
Oh my god.
Okay, dude, I'm nervous about this. This case has me stuck, and I don't know what to think about it. Like, I'm scared of the outcome. I don't want if he's guilty for him to walk free based on some technicality somehow. I would be so
No,
upset, dude.
none of us do that. Want that? But okay, so would you want just for the chance that he is guilty, lock him up because this your fear of him, the chance he's not guilty, or wait, you see where I'm going. The chance that he gets out and he is guilty. Would you want to take more of a chance to lock up an innocent person or let out a guilty person?
That's even. I couldn't say. I mean, I would have to say that's even. That's something where it all depends on if you're the person going through it. If you're the person going through it, you say no. But if you're not the person going through it, it's a little bit easier to decide. But being straight, like unbiased and completely, I couldn't lean either way because I wouldn't know because I'm not in that position.
Yeah,
but if I was
if
in
he
his
takes
position, I'd
another
be screwed.
life, he goes out and he takes another life, then you know what I'm saying? You just like if you voted on that, then you would have taken an innocent life, and he wasn't innocent. If he wasn't, but it's tough.
Correct.
I know. I don't know.
I just think that if he's guilty, he should be there. If he's not guilty, he shouldn't be there.
But it doesn't work that way all the time.
But you're guilty until you prove innocence.
I know, but even
Don't you think?
Yeah, but even if he gets convicted or not, doesn't mean he's guilty or not for sure. So
True.
it
Yeah, it's
sucks.
all just see. That's the thing is like that's where this judicial system. I mean, because we never really know, right? People could say they did things and they never did it. People could get convicted of things that they never did just because other people believe someone's story better than the other ones.
Yeah,
I mean, that's kind of really what it is, and people get exonerated for it all the time. I just hope that there is some sort of forensic evidence that ties him to the crime. That's proof that they can bring out in something else later on down the line.
I don't think there is going to be, Anthony. I think you're just
Then I'm
gonna
going to have to go to
believe it or
jail
not. I don't
and
think
meet
there's
Yeah,
this
but
dude.
how do you know? We don't know what the prosecution has.
Oh, I know, Marv. I'm saying I don't think. I'm not saying there's not. I'm saying I don't think there's, in my opinion, I don't think there's going to be.
Then I'm going to have to go to jail and meet him.
Do an interview. He probably won't talk.
No, I mean, like I'm going to have to probably like be an inmate and go undercover.
Oh.
We're going to do like 60 days in with Richard Allen. And I'm going to go undercover, disguise myself, and go in there and just whoop his ass.
Yeah,
See,
how are
that's
you
the
going to
thing, though.
change
If
your
they
voice?
don't have anything and he is the murderer, that is their fault. Because they should have caught this right at the beginning. Come on. He was one of the guys
Yes.
there. They would have had they would have DNA. He wouldn't have had time to clean all that up. He wouldn't have had 6 years to freaking clean everything, or 5 years, over 5 years. He wouldn't have had time. That's freaking bullcrap. They screwed
Look
it
at
up,
how often
okay?
it happens. A lot of these people that are convicted were suspects in the beginning and they couldn't prove it.
But they don't have
True.
anything more now than they did before. That's the sucky. It's not like they got this big revelation. They just screwed up and dropped the ball. They should have freaking. They have the same amount of stuff now as they did before. So why not
No,
just? They would have
not-
had more then. They
they've
had the
got the
bullet. They
search.
had. What do
They've
you
got
mean?
the search evidence from it. Whatever they took out of his house.
But they would have had that before.
Oh, no.
they would.
Oh, they
No.
They would have had more. They would have had blood, DNA. He wouldn't have been able to clean all that up. What do you mean?
They would have been able to get all that if they would have followed up on that tip.
Yeah, that's what I'm saying.
Right?
Yeah.
And immediately said, okay, this guy was at the trail. How about just because he was at the trail, just like Ron Logan, just because it was his property, right?
They did
They
a
were able
search.
to go search his house because they're like, hey, it's dude's property. We're going to search this anyway. I think that they would have probable cause to search every single one of those people's houses that was at that trail that day because they admitted to being at the place where two girls just got X'd, right? And I think that if they knew that tip was there right away and realized it, they would have been like, we're going to issue a search warrant for this Richard Allen guy's house and just see what we got come up with over there too, just like we did with Ron Logan's. And then they would have found stuff.
Anyway, though, how did they have? I mean, they were able to search it now for no reason, so they should have been able to search it from there, from just him being there, right? Because there was no reason for them to do it now, but just for him being there. So why wouldn't they have had it? They should have been able to at the beginning. For
They
the
would have
same
been
reason.
able to. They would have been
Dude,
able
he
to.
would never have been able to clean up all the DNA. There would have
No.
been so much more stuff. If he is the killer, there would have been stuff that he wouldn't have had over 5 years to clean up. They would have had so much stuff. I think it's just they screwed up.
Yeah, but why?
You're right about
Okay, in the 5 years, why didn't he get rid of the gun? Why didn't he get rid of the jackets?
Because
Killers,
here's
criminals
the
are
reason.
stupid.
Dude, how many people, okay, I don't know whose mom it was in Aiden Fucci or something like that, washed his clothes, right?
Yeah.
She didn't throw it away. She washed it. Okay? She washed it. She didn't throw it away. People that do these things think, I'll just throw it in the washer. It's gone. And he especially probably didn't get rid of it because, number one, he didn't shoot them. Okay? He didn't realize he dropped the bullet. There's no reason to get rid of the gun.
Good point.
Nobody, I didn't shoot him. He's, you know what I mean? He stabbed him. So, and he knows that. And so he's like, there's no reason to get rid of the gun. If they think that I shot him, they're stupid.
That's a good point.
The pew pew.
Yeah.
But are we sure that's the same coat? Are we 100% sure that that's the same coat that they have on the evidence list?
No. But I'm for sure that it's the same coat that he's in that picture of.
Oh, well, that was before the murder, so it probably is the same coat. Okay.
Yep. But no, I don't. I mean, they say a coat that matched the description, I think.
That's why I'm saying we don't know what they have until trial happens because prosecution isn't saying anything.
You're right.
Or maybe he got rid of that coat and got another one. Just made up some shit to his wife. Oh man, I ripped my jacket today. You know what I mean? Like, I have to go get a new one. So I just tossed the other one. I mean, it's a possibility. I don't know. I don't even know if they went around searching like dumpsters and land in the landfill and the everything around there. Probably not.
Yeah, I don't know.
It's upsetting.
Evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rozzi and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rozzi on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings.
Did you hear that? Did you guys just hear what he just said?
Repeat it. What?
She was right. 948. Listen right here. Listen what the Supreme Court Justice asked him and listen to his response.
Mr. Allen wants attorneys Baldwin and Rozzi on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
They said are having found. So that means that they have already found that they think it's wrong. Is that what they're saying? Or that hold on.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
See, they admitted to she's right about finding them grossly negligent. Right there is what he just said. You know, the findings that she's grossly negligent. Watch.
That's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings.
But he just said she was.
Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a
What
relationship.
concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever?
Yeah, and that's what we went over just a minute ago, right?
Yep.
The waiver. Okay. Yeah, I just wanted to show that clip. I don't know. I like going back and just listening to what the Supreme Court justices are asking them during some of these.
Right.
Because the questions that they pose are, well, what if this and what if that? Let's hear another one if you guys want.
Today.
I love cornbread.
My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy
strategy of third-party guilt
trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rozzi, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Libby, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge.
Yeah.
Okay, but on the day that all happened, the prosecutor had witnesses, so there would have been a hearing.
Yeah, that's what they said. They said, well, they have the right. They had a right to it. Yeah,
and this
but they said they did.
No, she wasn't going to have a hearing. She was just going to remove them. Well, that's not the case because we know Doug Carter and all them were there to talk about the fact that evidence has been released in this case when there was a gag order.
That is true.
So there would have been a hearing.
Right after that.
Right after that, yes.
Yep. And that's what the intent was. And she didn't say they had to withdraw. She just said that if you choose to, or if you don't choose to, this is what's I'm gonna do. And they didn't, like I said on the channel, and like that, the dude said, well, they didn't object to that. You know what I mean? Like, until all this happened.
Right.
Let's see. Like, they're screaming coercion now. Right? Like,
it's almost like he's fighting to get Rozzi and Baldwin back on as public defenders. But if that won't work, then it's Richard Allen's right to choose his own attorney, and they should be able to get back on there as a pro bono attorney. He's fighting two different things here.
A backup option.
His main option is to get them back on there as the appointed defenders.
The bigger picture is he just wants him back with Richard. So any way he could get it, he's trying. He'd prefer them as a public defender because they should deserve to get paid. But if they can't, then he... But that's showing that's showing good. He's looking out for Richard, and Richard's, you know what I'm saying, his rights. So I feel like it's still the same fight in a way, but I would be doing the same thing. Like, well, okay, if you don't put him as public defender, then at least, the second option is...
Put him on pro bono because that's the attorney he wants.
I don't know, guys. This is going to be tough. You think it's going to be a month before they decide?
I don't know.
I hope not.
It might be tomorrow.
No, she said they were going to try to do this as quickly as possible at the end. That Justice Rush.
I think a week, maybe. I don't think it's going to be a month, but.
So I want to tell you guys something. So I want to note that the trial court, Judge Gull, relied heavily on Wheat versus U.S. 468, U.S. 153 during oral arguments. Wheat wasn't really relied upon in the trial court's brief. It's factually distinguishable as it dealt with the defendant seeking substantial or substitution of counsel, not a trial court disqualifying counsel. Okay. So Wheat, just 2 days before trial, the defendant asked to be represented by counsel who represented 2 co-defendants with all 3 waiving conflict of interest claims. But the issue was one co-defendant could be a witness against the others. Supreme Court of the United States held that when a court finds actual conflict of interest, it could decline the defendant's request for substitution of counsel despite the waiver. As noted, there is much different than the fact of the pattern presented in Allen's case. So the trial court's reliance on Wheat could be misplaced.
Yeah.
In their argument today.
So I ended my poll. Will Rozzi and Baldwin get back in the case? 57% said yes, 42 said no.
Okay. I completely forgot I had a poll.
I know. I did too until now.
Zav, what do you think?
I'm here. I just gotta run. I'll be back. I gotta go to run somewhere real quick.
Okay.
Run fast. Okay, so my poll ended up as this. Well, who do you think the Supreme Court will rule in favor for? 34% said Rozzi and Baldwin. 32% said Judge Gull. 18% said all or both of them. And 13% said kick them all out.
Wow.
Kick them all out. That's interesting. Kick them all out. Let's see here. People are asking me about Westerman. Okay. All right. So gaining weight, not in prison food, eating well on commissary. Yeah, he's gaining weight. So he is eating well on commissary, I think.
Oh, yeah.
Exactly. I think that what Richard Allen is going through is nothing different from anybody else. You know?
Right.
Like, he's not being treated unfair. As a matter of fact, I think that they determined at the court hearing the last time, based on testimony at the Indiana Department of Corrections and other officials, mental health officials and medical staff and stuff like that, that he was actually being treated more favorably than other inmates incarcerated at the facility. That was found in the court's order after a hearing on his conditions and stuff like this. You know what I mean? So, I don't know.
What am I supposed to be looking at on my case, Jinx?
All right, I'm going to my case too. My case. What are we looking at on my case, Jinx? Because I'm looking too. All right, so I'm looking on nothing on Mitch Westerman's case. Are we looking for Richard Allen stuff? Is that what you're looking for?
That's what I'm looking at. RA changes.
State of Indiana versus Richard Allen. Okay. So here we go. Order issued. What? Say it again.
I said, did you find it?
No. I don't know what I'm looking for. All I know is that the last thing that I saw on his Supreme Court thing was they issue an order on one of the writs of mandamus that the justice ordered. They've reviewed the briefs and other filed materials and conferred with each other because Allen bore the burden to persuade the court to issue a writ, and he's not done so. The petition was denied. The disposition is final.
There's an amendment or something to that effect. Okay, send me a screenshot.
Hold on. I'm looking for it too. Everybody, we're looking for an amendment. Acknowledgement of oral argument. Where are you looking at? All right, there's that. There's that. I'm not seeing him in Carroll County anywhere for some reason. Wow, there's a whole lot of Richard Allens now. There it is, Carroll County. All right.
There's a lot of Richard Allens now. Yeah.
I know. It's like, holy cow. And there's a whole bunch of stuff filed in his document. All right. So it looks, yep, amended pleading filed. Motion for leave to amend. This is filed by the, all right, motion for transfer Richard Allen on the 12th. Amended pleading filed on the 18th today by the state of Indiana. Motion for leave to amend filed. Can someone get those documents? It's early enough. We could call and get them. Or they might have them on the link. You know what I'm talking about? For the Allen County Superior Court. Or the Circuit
I gotta
Court.
find that again.
I think if you probably just type it in Google Allen County Superior Court. Hold on. I'll see if I can find it, everybody. County Superior Court. Delphi link. There it is. Allen Superior Court, State of Indiana versus. Here's a zip file. Okay, it looks like there's a whole zip file of things. Let's see what's been added. Last modified. Okay, it appears there's, holy cow. There's nothing new.
Not yet.
Nothing new that I'm seeing put in this file. That file is pretty much just for everything else. So, okay.
What is it? Allen County? I want to say that.
I just typed in, it's called Allen Superior Court.us/Delphi. Takes you right to the website with a thing that you can click and get all these documents right there.
I got it. Okay.
As they update them. So for you guys that don't know what we're looking at here, there we are.
Say these things, and Mr. Rozzi presses at her. Well, what's that proceeding going to be?
We're going
And
to listen to this while we do this.
That the judge says the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on
check your text,
record,
she said.
The judge's personal
check your text, Jinx said.
Bias towards the strategy and that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
Because you're saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think I don't think those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the 6th
My
Amendment
concern is
requires.
getting this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the
A
case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to be fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're not.
Why didn't they show up for the hearing? I don't understand.
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case. Excuse me, the lawyer will eventually
I got the
pull
documents
out
up.
the case, or a conflict of interest will develop.
All right, we're going to stop that. And we're going to take a look at this real quick. I got them pulled up right here.
Okay.
The state has filed a motion to amend the charging information against Richard Allen.
Yes.
Okay. Wow. Breaking freaking news, ladies and gentlemen. This is a bombshell now. Bombshell report. The state of Indiana, the prosecutor today, just now, filed a motion for leave to amend charging information, which means they're going to change the charges against Richard Allen. They're going to amend them. They're going to amend them. They may have more evidence now that we don't know about. Gosh, where's Zav at? Zav, are you still listening? Okay,
Just
comes
go.
now the state of Indiana by. Can you switch through them? I got them all three over there on the right in that thing.
Okay.
Because I got to make the screen big. Comes down to the state of Indiana by prosecuting attorney Nicholas Charles McClelland and respectfully ask the court to leave to amend the charging information filed in this cause on October 28th, 2022, and in support thereof on October 28th, 2022, the state filed charging information alleging these offenses: murder as outlined in count 1 and murder as outlined in count 2. The defendant was arrested on October 26, 2022 by a detective with the Carroll County Sheriff's Department. The probable cause affidavit executed by then detective, now Sheriff Tony Liggett, and filed with the state on October 28, 2022 identifies acts of murder on or about February 13, 2017. The discovery in this cause also revolves around the acts of murder occurring in Carroll. Okay, let's go to the next one. Carroll. Where are we at?
I know we got so many things on there.
There we are. County. Okay. On October 28th, the state filed charging information. These allegations. Carroll County on that day. The charging information of the probable cause in this matter reflect the charge of murder, IC 3542 1-1, subsection 2, commonly referred to as felony murder. Specifically, that Richard Allen did kidnap victim 1 and victim 2, Abby and Libby, by force, and in the process of committing that felony, both victim 1 and victim 2 were exed. The state hereby moves to amend the charging information to add additional counts, which include murder under Indiana Code 3542 1-1 for both victims 1 and victims 2.
Along.
Okay, hold on. And the other one with kidnapping under the same section for both victims 1 and victims 2. So felony murder and murder, intentional homicide.
Yep.
He has it now. The state is asking the court for leave to file these amended charges because the charges are more accurately aligned with charging information with the causes discovery and probable cause affidavit. Because of the clarity of the discovery and probable cause affidavit, the defendant has been on notice since the beginning of this case that this amendment does not prejudice the defendant's substantial rights, that the trial for this matter is 9 months away, giving defense adequate time to prepare to defend the amending charges, that this amendment does not substantially change the state's theory on this case. Wherefore comes now the state of Indiana by prosecuting attorney Nicholas Charles McClellan, and prays this court grant this leave to amend the charges information filed in this cause on October 28, 2022, and for all other relief just and proper in the premises. This is huge. This not only means that they believe Richard Allen is the bridge guy, but they firmly believe that Richard Allen went there intentionally to commit this crime and can prove it.
Oh my God.
Bro, wow. New charges filed against Richard Allen. Holy cow, everybody.
Wow.
Wow, dude.
Oh,
intentional
my.
homicide.
Zap,
So they
girl,
got-
thank you so much. Says, thanks for everything you do. I love your input on this case. You're really good at true crime. Miracle Hearts, thank you for the super sticker. We appreciate it. And we appreciate all the donations today.
Yes. Thank you very much for people. Man, this is so nuts, dude. New charges filed against Richard Allen. Holy shit, dude. Well, I mean, whoa, dude. We're live now and there's new charges filed. Yeah. Thank you very much, dude. Yes.
This was from today. This is today. Wow. Thank you, Jinx, for sending that.
What is it?
That document.
Yeah, yes. You know what? And also thank you to another person, another creator out there. I don't know if that person wants me to name them, but I mean, if they say yes, it's okay. I will. Appreciate you for. They also sent me the documents. Same time, actually.
Awesome.
Didn't even see it until just now. So
Awesome.
appreciate you very much. This is big news, everybody. This is big news. Richard Allen just got charged with murder. Holy cow, Zav.
Yeah.
Thank you. Was that holy cow? Who's that on? Is that on my channel or your channel?
I don't know.
Holy cow.
We'll figure it out today.
Awesome, Zav. That's awesome. Thank you for doing that. You guys rock the most. So what can we make of that? What do you think that means now?
I think wife Lilith says it all. Rick's going down.
He's going down.
That tells me the prosecution has more than what we know about on him. And do you think that the reason they filed this afterwards is because of the comments that attorney made about having the prosecutor on their heels and their back foot, and the prosecutors coming back saying, you didn't have us running from nothing. We've got stuff. Is that their way of letting the public know they have what they need on Richard Allen?
You know what? In a way it is. It's almost like a show. All right.
Yes.
It's like, all right, dude, you guys want to go out there and talk all this smack, dude? Watch this.
Yeah.
You know what I mean? I bet McClellan was sitting back this morning going like this. I bet they were sitting there watching this going, you know what,
yeah.
Dude? We're gonna find out what's happening. I don't even know if Nick was there. He might have been there. But if he wasn't there, he definitely filed that thing first thing this morning and then went to the hearing.
Yep.
Or he called Shane Evans at the courthouse and said, hey, dude, go ahead and file it now.
File it.
And watched and seen what happened in there and said, all right, you know what? You guys want to throw screwballs? How about this, dude? We ain't punks. You know what I mean?
Says that tightening the screws on RA so he talks.
Yes. Slamming
and
down.
that might be exactly why there's a multi-purpose in this. Get him to finally talk and to prove that the prosecution does have evidence against Richard Allen.
Substantial evidence to prove his guilt.
Right.
Is what it appears.
Right.
By filing that charge. That they're
Right.
confident they can walk in there and be like, here, jury, look at this. Here's what we got. He's the dude. That's what they think. So that changes my whole opinion. Zab, I'm curious to hear your opinion on that. If you type it in the chat, does it change your opinion on anything that the prosecution changed their charging information, that they're changing their charging information?
Yes, Cynthia. Has the prosecution been holding on to that for the perfect time to amend it? You betcha.
I would be.
They are sick and tired of the public supporting Rick and want us to know what is behind all this. It would likely do away with the idea of a speedy trial since they would now have to prepare for different charges. Possibly. I thought from the beginning that they had way more than we thought or knew. I agree with you, Delana. I've been saying that all along. Now what does that mean? The trial will happen? Oh, the trial's definitely going to happen. It's just a matter of when is it going to happen?
Yeah. When's it going to happen? That's the question. When is it going to happen? Wow. I'm going to end my poll and start a new poll. So did Richard Allen watch this from prison? Everyone said 54% said yes, 45% said no. What are you saying?
This is exactly what's going on. They're playing chess. The two sides are playing chess with each other. And I told you that the prosecution has been holding on to everything.
Everything.
Everything. Now, oof.
Yeah, here's the I'm going to drop the link. If anybody wants to call in and tell us what you think about this. This is so game-changing.
Oh, it is.
I'm just blown away at this. This is crazy, everybody. I'm going to pin it on my channel, everybody.
Bogey says, so KK has nothing to do with this. Makes sense what everyone is commenting. I'm always learning. We're all always learning.
No, wait.
Holy moly.
Hold on. We're not necessarily still accurate on that. What if they found the link? What if Keegan Kline gets new charges?
Oh!
It's a possibility. You know what I mean? I mean, I'm not ruling it out. I'm not saying it can't, it will. I'm saying it could. What if they did find the connection that we were just talking about here just recently?
Yeah,
right?
they absolutely could.
So far, there's nothing filed against him.
This investigation has never stopped, even after Richard Allen was arrested. It has never stopped.
No, it's still going on right now today.
Exactly.
Yeah, I mean, wow, dude. Holy cow. So now, wow, dude, this is just, I'm just so blown away, dude. This is nuts. So I'm remaking
Miracle
it.
Heart says, game on. Yeah. Wow.
Wow,
No,
dude.
it's going to make it easier. It's going to make it easier.
Yeah, because he's got both of them. He's got all the charges. They overcharge. I don't think it's going to be harder. I think it's going to be easier. They wouldn't file that
No.
if they thought it was going to be harder. Okay. Here's the thing. If we go back to Mark Lopez, he actually had a video that said it would have been easier for them to file it as just regular murder.
Yeah.
Yeah, he actually said that. So I'm making a new thumbnail for the thing, putting new charges filed.
Do you think KK being moved could be something to do with this? I don't know.
No, I don't know. Okay, there's so much that I have in my head right now that I don't know.
I know.
Do you know what I mean? I'm lost when it comes to this. I don't know what to think, everybody. It's too much to think about, I guess. You know what I mean? Like, I don't know.
This is crazy.
It's got me going nuts here. I'm just
Yeah.
stuck.
Oh, wow.
Where does it say they have more? Well, it doesn't say they have. Wait. Not sure. That was a smart move. Just pressure on them to prove more. Oh, okay. Where does it say they have more? Well, I'm not saying that it doesn't say in there that they have more, but they have
wouldn't
to.
have brought on
Yeah.
extra charges if they didn't have more.
Yeah.
I'm telling you, they are holding things to the vest. They are not letting anything come out. Let's.
Okay. Can I see your face in the back chat for you real quick, just to make sure? If you're not there, I can add you, but I'm not going to put you up. So if you don't want to be on camera, currently you're not on camera.
How do I do that? Oh.
Okay. Now you're on. Do you want to be on camera?
No.
Okay. Go ahead and take yourself off
now.
and just go ahead and talk to us.
You.
Okay. Because you're now, everyone can hear you, but no one can see you. What's your
Yeah.
name
All
and where are you
right.
calling from?
I'm a transplanted Texan here in Oregon currently. How y'all
Okay.
doing?
We're doing great. How about you?
I don't have any makeup on or anything. That's why I don't want my face shown.
Okay.
And
That's
with
fine.
it, now I had a nasty fall and I have a black eye, so I don't want people think I got into a fight.
That's no problem. You're fine. What's on your mind?
Well, I seriously, this has been heavy on my mind. Have not been covering Delphi as much as you have. Excuse my accent. I mess up that name of the town all the time. And I appreciate the fact that you do. Thank you very much. Because you're the reason that I got caught up and I was able to understand the case. Let me preface that by saying I had brain surgery 2 years ago. They took a tumor out of my head the size of a tangerine. I'm actually 2 years ahead of my prognosis because I'm able to walk and talk at the same time. So, but I have learning disabilities, and you did it perfect where I understood everything that was going on.
Oh, that's
With that being said, why hasn't anyone asked the question if the is it Baldwin, I believe? Am I pronouncing his name right?
Yep.
Baldwin Powell. Why hasn't anybody asked the tough question, looked into the fact that since he's being covered by one of Baldwin's lawyers, did he do it for Baldwin under the table?
We've
Because
asked
they wanted to continue the story?
We have asked that.
Okay, I haven't heard it, so I apologize.
No,
That's all right.
You know what?
But it's like, to me, it's as clear as day. I mean, and I've had brain surgery. All right, and that's saying something. If I could see it, why can't the lawyer? Why can't the judge and all that?
They can see it, and you're talking about Westerman, right? Taking the fall.
Yeah.
Okay. You know what? To answer that, I want to respond to that with one of the video update on Westerman that kind of explains everything and kind of ask that, and then I think we could maybe follow it up with what we were talking about last night to legal analysts on what they think about it. You know what I mean? Just give everybody I'll show you guys two different things. I'll show you guys three different things. We'll show you the Westerman video and then the update, and then we'll go from there. So here he is, right?
Man accused of leaking evidence in the Delphi murders case, and one that really started all of this, is going to be in court now in less than an hour.
This will be
Actually, you know what?
That one, yes, I did see that one.
Okay, this one.
Nobody on the prosecution side has ever leaked to us discovery materials that was protected by an order from a judge.
Yeah.
Dude's dead, man. Dude's dead, man.
Does that make sense to you?
Dude's dead, man.
The prosecution's never leaked anything to us. But he didn't say the defense or the prosecution has never leaked anything to us. The defense team leaked it to them. I bet that they were maybe asking, I bet they're all friends, and they were asking what he thought because he's an attorney. And Kevin saw the photographs, and he had the photographs. That's my thought.
Yeah, and that's not the first time. Sometimes you'll have news media who calls and says, we've been given this. We know that we're not allowed to have it. It's illegal for us to have it, or it's going to like ruin a trial. The thing is, if something, especially on a trial, gets released that are very discriminatory in the case, it can literally have a case dismissed. It can impact a case. It can have a count of a charge against somebody dismissed. Who is giving you this information and why? What is their motive, right? Is it helping them to maybe pollute a prosecution, or even just to confuse the jury? Yeah.
Yes, it's incredibly disturbing that anyone would come in and take photographs of graphic crime scene photos of two beautiful young girls for any reason, let alone to start distributing for reasons unknown. Frankly, that's one thing that still is a mystery, why this guy would have done that. Anybody who's practiced criminal law and tried cases knows that that's absurd. No criminal defense attorney would ever want crime scene photos out to the public, because what it does is it incites the public against their client. So the thought of, or the mention of Baldwin doing it intentionally was obscene to me. And I've heard it mentioned multiple times. And you know, as far as whether or not his rights to a fair trial have been potentially injured by this leak, I'm just not seeing it, because the photographs never made it out.
I disagree with Bob Mata. I don't know. I would love to interview him. I would love to have him on the channel. Bob, please come on the channel, man. I disagree with what you're saying, and I want you to explain why you think that there should have been an evidentiary hearing when they clearly said in those transcripts that they voluntarily withdrew, even though they didn't want to. They should have let her say what she said and then went on the record to object. Bob Mata of Defense Diaries is a defense attorney. And every single time I've seen him on Court TV, he's a defense attorney. He defends the defense attorneys. Always. And I don't understand why he's so adamant to defend defense attorneys, but I get it. That's his profession. That's what he does for a living. So he's naturally, even if I guess he doesn't realize it, he's naturally opposed to the prosecution side of things.
What do you think about that?
Very, very interesting.
It is interesting. It is interesting.
Sounds like the truth, honestly. I mean, yeah.
Well, I mean, there's two sides. I mean, I think that he could have been a ruse to distract him, but he also, am I froze? Yes, I'm froze. Hang on just a second. I don't know why I did that. All right, I'm back. Yeah, I don't know why I did that at all. So I had to fix my thing. So for some reason, it's having an issue with something. But is it a ruse to distract everybody from this case? I guess that's the big question. You know?
That's a very good point, because I could see that.
Well, it could be.
I mean, I can also see he makes bank, because, I mean, think of how many defense lawyers get in trouble. But
Exactly. There are, I mean, I don't know. This is, it raises concerns, because I think that they could have done it on purpose to push the narrative. But then again, I also think that Mitch Westerman could be the fall guy, but I don't know. There's all sorts of possibilities, right? And we don't necessarily know which one's going to be the right one without digging in a little deeper.
true, but also think of the minor punishment he gets. He's probably like, you're going to set me up, you're going to protect me, and this is the only thing. If the lawyer doesn't work, yeah, I'll do it. And then he's going to get rewarded later on down the line. You watch.
Exactly. Now,
But I also come from a background of a lot of cops. I think I'm the only cop in my generation that didn't bother to become a cop. Oh, wait, that came out wrong. Person that didn't become a cop. Everybody else did, and they're like, that's laid out. That's planned. That's not on accident.
Not on accident.
Yeah, they said that's going as smooth as butter. Half the public doesn't believe that he'll do it. The rest of it is like, oh yeah, he'd do it. He's a lawyer. Hello.
It's funny. I am. Okay, so you've been watching this case. Do you think that the man on trial, Richard Allen, is the suspect, the bridge guy, the guy that we see on the bridge? Do you think it's him?
Absolutely. And again, I don't know if you've ever had a brain injury or head injury, but they put you through tests, and this is really odd, but they put you through tests where they hide the numbers or images inside a deep pattern, and you have to filter it out.
Okay.
And maybe it's my eyesight or something. I can see Richard Allen in that. I feel like I'm looking at one of those tests, and his face is pretty clear to me because of those tests. And I wish we could put that in evidence, but we can't, obviously. But
Right.
so they might want to reach out to a neurologist, therapist for that test. I don't want to add to it because they're already taking longer than supposed to be to take care of this. As a matter of fact, I was talking with some people, and I can't name them because they still work in the law official as a law officials. But they said more than likely to control the kids, even if he had a gun, because the inclination of going down the hill or the incline, as you know, because you've done a redo of it, is for any normal person, it's kind of hard to get down in one swoop without maybe tripping or falling. What if he did that part, but there was another person literally on the bottom waiting and also armed, and that's how they were able to control the kids. And, the rest of it, I honestly feel was led by another person. He might have been involved. He probably could have been involved because he was bad enough to take the kids. But he definitely, that's him on the bridge. I know this 110% because of my weird
I
vision.
thought there was another person involved at the scene.
But that makes the most sense. And we're talking about law officials that still, as a matter of fact, I may want you to touch on this later, and I'll get in touch with you then, Greeno. But they were thinking, honestly, that might be the same way with John Bonet. Someone was upstairs that knew the house, maybe the maid, and someone else was dealing with what happened. But they said that would be the best way to control them kids instead of just one person having it all, one person bringing them down, and the other person's down there waiting. Because there is patches where you can hide out and people don't see you, but there's no way a group of people can do a ceremony and somebody not see that many people.
You're right. I totally agree with that. That it wouldn't be very easy to do. It wouldn't be easy to do at all. It would
not
be
at that time of the year, even though the trees hadn't fallen with all the leaves, not that time of the year. There would have been impossible.
correct. I agree. I'll be right back, everybody.
Okay.
No, I agree with you.
I mean, not only that, but there would have been more signs there at the crime scene. Even if you're a hunter and you brush away the footprints, there's always more signs that there's more than that there's a group of people.
Yeah, I don't necessarily know that Richard Allen is the guy on the bridge, but I agree that he played a big part in it. And I've always said that I thought there was at least one other person involved.
Yep.
Because Libby, she would have fought. You can't tell me she didn't fight. You can't tell me that. There's just no way.
There's absolutely no way that two teenagers would sit there and be quiet during that whole ordeal.
Right.
Unless they were being held a gun on each person and they didn't want to have the other person killed because of them.
Right. I agree.
So.
Because if Libby had the chance, she would have taken action.
Yeah, yeah. I mean, not only, I mean, they did say that they found some stuff underneath the nails. I don't know if it was clear or not, but.
But that's
Not
the thing
sure.
is we don't know any of that because the prosecution is so tight-lipped.
Absolutely.
You know?
But I think they're that way still because if we're right and there was another person, the evidence that they have may very well point out who that other person is, but they don't have enough to convict.
Right.
So I'm not sure. All I know is that from them tests, when I looked at that video, and I replayed it too, time and time again, just to make sure, I saw the same damn face. I sketched the face. And then Richard Allen came in. I said, that's the damn face. Oh, excuse my language. But
That's right.
that's the face. That's him. So honestly, had I been there and gone to CVS, I would have dropped my stuff right there. I'm trying to keep my language clean. I would have called the cops right there and not let him leave. And honestly, even if you look at the younger picture, because remember that picture was made with a face covering, so they had to add some detail. The eyes, the nose in that area, exactly the same.
Yeah.
Same dimensions.
Same
And that
dimensions.
comes from a
Dimensions,
sketch
different
artist, a
description.
police sketch artist.
Mm-hmm.
So
And you're a sketch artist?
no, I'm related to one, but I sketch.
Okay. I'm glad that you said that.
Not a police sketch artist. I'm just a sketch artist.
No, hold on. But you know a police sketch artist?
Yes.
Okay. I would love to talk to you after this stream in any way, shape, or form. I'm going to give you my email address is posted in the description. I want you to take it. I want you to contact me because I have been looking for a police sketch artist to help make a sketch and show people how accurate or inaccurate they can be and explain how they do it.
Oh
Would
my
that
gosh,
person be
yes.
willing to do that? Because I would like to tell that person, describe how someone I know looks, okay, because I know that person really well, and see how well they create it, and then show the viewing audience, like, look, this is what I said, this is what they made, here's how accurate it is, and the person who's doing the sketch will never know who the person that I'm talking about is until afterwards. Right? Because I want to show it as if that would be
I'll be glad to ask.
amazing.
If they can't do it because they might see a conflict and get in trouble, if they can't do it, he's my uncle.
Okay.
He actually, that's how I became a sketch artist because they thought that would be the way I would go into law enforcement. But I love my family, but when it comes to cops, I'm like, no. So it's interesting family reunions, let me tell you. But they keep their cop business out there and they bring the family in. So, you know. But again, I'll ask. And if he says aces, I'll give him your info. If not, then I mean I'm a very distant second choice. But again, he did teach me.
Okay.
And I can already tell you right now that job is hard as hell. Because they'll be describing something, you'll draw it, and they'll go, no, actually that's not it, and start all over. Or they'll give a description and he'll sketch it and they're like, yeah, that's it. And then it goes out and then they're like, you know what? I remember this. And then they have to change the sketch.
Yeah.
He says sometimes he feels like he's doing Etch-a-Sketch because people change it so much. But yeah, I'll be more than happy to ask.
Awesome.
That'd be
If
awesome.
not, I might be able to track down another one. So,
Okay.
like I said, I got a whole family of them. So being related to cops kind of opens doors.
Right.
We greatly appreciate it. You know what? And we thank you for calling in and stuff like that. We really appreciate that. That was some good input that you have. I'm gonna take it here, and if anybody else wants to call in, you guys are welcome to do so. But thank you for calling in.
Bless y'all. Y'all have a good day.
Okay, you too. Bye-bye.
Bye.
All right, awesome. That's so cool. So you guys can call in. I posted the link and pinned it in the chat box. And also I was over here. I was just posting things on social media, trying to keep everybody updated. New charges are going to be filed. Not technically filed yet, but they are going to be filed against Richard Allen. Wow, dude.
Yeah.
Breaking news. Okay, so I wonder what all these I wonder what everybody thinks about that. All these pro hymns.
Wow.
What do they think about that? Do you think this is going to change their attitudes, or they're going to be like have an immediate defense, go on the defensive, like people like the Unraveling?
I don't
or
know.
You know, I think Bob Mott is a supporter, not of Richard Allen, but more on the defense side. So when he sees that these new charges are filed, I kind of wonder what he's thinking.
Interesting.
I bet we can see Court TV tonight.
Oh yeah.
Someone reach out to Court TV for me and tell them they need to have us on, okay, versus the murder sheet. All right. Tell them we'll give them exclusive, never before seen information.
Wow.
Richard Allen just. I'm so happy, dude. I'm so happy. This case has me
I'm just so blown away.
Today was a huge day. The Supreme Court of Indiana really laid it out there for me. I mean, I really enjoyed that hearing. I've never watched anything like that. I always think it's so boring and stuff like that. I watched it today. It changes everything. They have a strong case against this dude. This isn't no weak case.
I've been telling you that.
Yeah, but you also thought that he's not the bridge guy. I do. Do you think he is now?
No, I still don't see him as the bridge guy.
But what if he is?
If he is, better yet. Then I'll say I'm wrong.
Where is that video? Oh, I played it from the thing from YouTube. Mitch Westerman.
Carly says Marv same.
What? Well, no, see, here's the thing, dude, is they're giving me reasonable doubt. They're giving me reasonable doubt. That's the problem. When they start giving me reasonable doubt, then I'm start getting worried. Because I'm not easy to convince reasonable doubt. Because I typically think that most people that are arrested for crimes are guilty. Because they usually are and plead out.
Okay, so you know how that attorney for Allen and Rozzi and Baldwin said that he had the prosecutor on his heel and basically they were getting the drop on him?
Yeah.
Not anymore.
Oh, no. There's a drop.
Now the prosecutors had plenty of time to go reinvestigate that part of it and prove that it was not Odinism.
Prosecutor drops a bombshell. Way to go, McClellan, dude. You know?
Nice play. Nice play. Absolutely. Oh my God.
I wonder what Sterling thinks about this. That dude better be watching. Watch. Sterling's going to be like, oh, I didn't catch it, dude. I don't know what happened. Yeah. Lots of people are messaging me about this. They're like, what's going on with this? What's going on with that? So Westerman was in court earlier, and we showed a video of him earlier. His case is set for March. So he'll be set on to go back in court in March. And it's going to be an interesting one. You know what I mean? What do you think?
So let's play devil's advocate here.
Okay.
I know we're excited and everything, and we're pumped, but let's look at it from the other point of view. Is this Nick McClellan's way of trying to seem like he has better evidence and just punking out the defense?
No. Nope. He's not going to play that kind of game. He's more straightforward to the law when it comes to it. Okay. He's not going to play the let's speculate game. He's going to throw it out there and be like, here's what I got, dude, because he knows how important this is.
Right. For a prosecutor to take it to trial, they have to believe they can win or won't bother.
Yep. I'm posting on X right now.
What are the new charges? Sorry, I missed it. What, you've got the better document. What it was the actual new charges?
Murder. Okay, so there's difference. We should revert to let's go. Can you share Mark Lopez? Can you
I have
can you
so many
share?
screens open. Hang on.
Hang on just a second. New charges to be filed against Richard Allen. Okay.
Oh, if I could type. If I could type.
Okay. So what did I ask you to look for?
Mark Lopez.
Mark Lopez, yeah, on YouTube, and let's watch his Mark Lopez, his felony murder versus intentional. I think we should watch that. I'm going to look and see if I've got it in here, but I think that's going to be a good video that we could all benefit from.
Okay.
Let me see where he's at. Did you find it?
Nope. I'm looking
Mark
through all of his videos.
Lopez. Felony. Nope. Yeah. It's like the way the charges are. Let me see here. I'm going to look through them with you. All right, I see him. So it looks like it's going to be a while back when Richard Allen was first
that's
charged. Yeah. So you could search his channel for all Delphi, right?
How?
Right there. No, see right there by community. It's a little magnifying glass. Click it and type in Delphi
There we go.
and watch. All right, here we go. And
it's way back there.
it's way back there. It's like felony versus intentional. Tim standing in front of the wall. Let's see. Yeah, because he describes it the best way possible.
Yeah.
And I think that it's going to be it'll be hard to not understand it after he describes it. You know what I mean? I think that everybody would deserve that. He is a criminal defense attorney out of Indiana. And let's see where it is. Case overview. No. I don't think that one's it. Let me go to it.
I got it.
You do have it?
Yes.
Okay.
Hang on.
Delphi murder case. On October 28, 2022, Richard Allen is formally charged with the murder of two young girls in 2017. On that same date, the prosecutor files another motion to have the entire case sealed. Like apparently he wanted everything sealed, even the fact the case was filed. On that same day, judge grants it. Literally everything is sealed. For a hot minute, you cannot even find a Richard Allen's case on mycase.in.gov, which is Indiana's online court records database. This is so unusual. Once a person is arrested, I am not aware of any instance where everything is sealed. At the basic level, we should be able to access two very important documents, the charging information and the probable cause affidavit. The charging information is what the person is being accused of, the crime the state says they prove if go to trial. This is a basic right in this country. People, including the accused, have the right to know what they're charged with. Now, the probable cause affidavit is the evidence an officer and prosecutor submitted to the judge to show a crime was likely committed. The level of evidence for probable cause affidavit is a lot less than required for a conviction, but it lays out reasonable grounds for belief of guilt.
Carly, can you post Mark Lopez's YouTube link, please?
Not having the probable cause affidavit. This is not normal. As someone who's been a criminal defense attorney for almost 17 years, as a lawyer who has defended all sorts of crimes, including murder, I have never seen anything like this. Sealing things like this is not the normal course of business in Indiana. In fact, the court seals so much, the Indiana Supreme Court Public Information Officer has to get involved. Now, this Public Information Officer does not tell the court how to do their job, but they do encourage that the process be more transparent. Immediately after the Indiana Supreme Court Public Information Officer gets involved, the case against Richard Allen at least appears on my case, along with the most basic information, including cause number and future court dates. Shortly after everything comes online, the judge recuses himself. Why? I have no idea. And no explanation is required or necessary. That's a good thing. We want to encourage judges to get off cases where they feel they cannot be impartial or where their ability to be impartial could be questioned. Why? Well, the American public believes in the court system, and the integrity of the judicial system is paramount. So we still have a mostly sealed case. A new judge from Allen County has been appointed, and now there's a hearing on November 22nd to see if the case should continue to be processed while under seal. Now, what can we tell from what's been filed? Well, not much. The charging information is still under seal. But now we know Richard Allen has been charged with murder, kind of knew that. But beyond that, we don't know officially too much. But there are some breadcrumbs sprinkled throughout. There are 2 counts of murder listed under the charges, but this is not what I would call normal murder. Richard Allen is charged with a second type of murder that is not intentional murder, but murder as a result of or in combination with some other crimes, some of which are pretty horrible. I'm not going to even read them out loud. You can read them right here. That's not the end of the story, though. Indiana also has something called accomplice liability. Accomplice liability basically is if you aid, induce, or cause another person to commit a crime, you're just as guilty as if you committed that crime yourself. Think about the getaway driver, just as guilty as robbing the bank. So I have a theory based on what I can see online and based on my experience defending criminal acts, including murder. I think Richard Allen is not the main show. He's somehow connected, but there are more people involved. And that makes sense. If Richard Allen was the main person involved, why not just charge him with normal old-fashioned murder? Why charge under this weird Section 2 murder? By charging this weird Section 2 murder, the prosecutor now must prove additional facts, such as other crimes have been committed. And I'm going to let you know a little secret. Prosecutors are just like everyone else. They don't go out of their way to make more work for themselves. They just don't do that. I believe the police know that Richard Allen is somehow involved, and they're trying to shake this tree to see what else they can get. I believe he was somehow involved with the online chat rooms that other suspects and individuals have admitted to taking part in with these young girls, and that somehow Richard Allen facilitated the meetup with these 2 young girls and the man that ultimately committed these heinous crimes. Now, I'll be the first to admit, this is all just theory and speculation because we don't know what the official charges are. We don't know what the probable cause affidavit is because it's still under seal. And
We do now.
They're supposed to be in Indiana. Most importantly, you must remember, Richard Allen is innocent until and unless he's proven guilty in a court of law. If you have any questions about this strange case, these strange developments, give me a call, 317-632-3642. And remember, always plead the fifth.
Mark Lopez Law. And there you go. There's the documentation that we were just talking about. 2002 Indiana Criminal Code, Title 35, which is Criminal Law and Procedure. Article 42, Offenses Against a Person. Chapter 1, Homicide. This is the section. It says this is what he's going to be charged with. He is a person who knowingly or intentionally X's another human being. X is another human being while committing or attempting to commit arson, burglary. Okay, so he's charged with subsection 1, which is the first one. Okay, and subsection, where is it at? 2, committing. Okay, so he's charged with both of those, 2 of the top one and 2 of number 2. Okay.
Yep.
And he's attempted to commit that crime while engaging in a felony.
In this situation would be kidnapping, and that's why they
Correct.
put that in the document.
Exactly. So they're saying that they can prove that he intentionally went out there and did that. He knowingly and intentionally committed the crime. It wasn't an accident. It wasn't somebody else that did it. They're saying he committed that crime and he knew what he was doing was wrong. And he did it on purpose. Is it accurate? What do you think?
Yeah.
I think so too. I think it's fairly accurate.
I can't wait for the trial.
You know what? The trial is going to be amazing. I can't now. After I watch this, I can't really wait. I'm so stoked. 9 months away. Wow, dude. We got a lot to discuss, and I bet a lot more crazy stuff's going to happen in between that 9 months, don't you think?
Oh, yeah. As soon as the Supreme Court rules, look out.
It's, a whole nother nest of flies are coming this way.
Yep.
As soon as that happens, it's over with, dude. We got some crazy stuff that's going to be happening. I know it. Because then they're going to get back to fighting about the case, the defense, the memorandums, the push the Odinism theory, all that stuff. They're going to try to push all that.
God, y'all, it's
Oops, there we go. I'm just going to skip through a little bit of this and just
on remand or similar to
No,
Just let him go
I
or
think if
whatever.
there's a concern, say, for example, the pretrial.
Can you control that?
publicity,
You can
the
control
press
that, can you?
release, if you say, listen, I
Yeah.
think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge can have a hearing, provide proof, or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public is going to be hurt, the entire Indiana judiciary is going to be harmed because this trial has been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either.
What did he mean by the trials for show?
That's what I was wondering.
I'm going to rewind that just a hair. We're at 25:52.
We got to hear that context again.
Yeah, I want to hear that one more time. He says the trials for show. I don't understand that. We're going to try to hear it again.
But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think.
What the hell does that mean? Trials for show? It's a practice only trial?
Why would it be a practice only trial if they went back to if he goes to trial with vibrato and screaming?
I don't understand that. That is so stupid. That is a stupid comment to make.
Basically, because he's saying that Alan can appeal because he didn't get the attorneys he wanted.
Yeah. And you know what? Hang on. I'm gonna actually look through this thing here. So
no, Emily, neither one of the girls were.
Hold on.
That's not true.
So he is charged
from what
with,
I've heard.
I see 34. Let me pull this up. I'm going to read the charges again, and we're going to look at the document right there. I see he's under 35, 42, 1-1, 2, which is commonly referred to as this. It's the second one down, number 2 right there. Okay.
Right.
That's the one he's committed. And they changed it to 1-1, not 1-4. Okay, which is what you're looking at, Emily. He would be charged with 35, 42, 1-14 is what he would be charged with. And he's not charged with that. He is charged with this one right. Where are we at here?
We got too many things up.
Here, the bottom one, 3542 1-11, which is, how do you look at that? Is we look at the top. 35 is the chapter, 42 is the article, chapter 1 is homicide, chapter 1 is murder, okay? And it's subsection 1 right there, which is a person who knowingly or intentionally X's another human being, okay? And 2 other charges of X as a human being while committing or attempting to commit. And we look through there and we find kidnapping. There it is. Okay. That's what he's being charged with. So no, he would be charged with subsection 4 if one of the victims were pregnant. So we could exclude that. But yeah, I wanted to make sure that I was looking at that thinking, man, I better make sure that that isn't what he's charged with. So you had me double check it there. So good.
Emily,
Good
we
thought.
know that in section 4 it says a fetus, but they're not stating section 4 is a part of his charges.
What does? Section 4 does. Listen, what I'm saying is, yeah, you're right. It does say that, but they're not they're not listing that section.
Right.
Yes. Can we? I did read part 4, sweetheart. It's this. Hold on. There's a news article. Fox 59 just posted it. We're going to take a look at it and we're going to talk about it. Okay. Fox 59 just posted it. Court TV's live right now. I'm probably with the murder junk. Let's see here. So we're going to look up new charges. Richard Allen to face. Let's see. Damn, I can't find it. Understanding. Expected in court. There's Mitch Westerman. Well, I'm not seeing it. Let me go through here and see if I can find it in a different way, shape, or form here. Okay. And pull it up for you guys. They charged him with, yeah. Because they're actually charging him. Join live and hear me tell you. Okay. Join my live now. Okay, so I got people join. I put Johnny my live now. That means
Johnny my live.
Johnny my live now.
Come on, people, Johnny my live.
Johnny my live. Okay. All right, so now here I got the video. I'm gonna pull that video up here in just a second. There it is. There it is. Okay, new charges filed.
Yeah, okay. Emily says, "Oh, I thought all those was the charges."
No,
just
no,
the first 2.
Just one section of it. Yeah. All right. So here I'm going to see if I can share. Let me see here.
Jinxie, I know you said that you didn't think Baldwin and Rozzi are death penalties qualified, but they would have to be. Otherwise, they would have never been appointed. I think Baldwin is the one that is death penalty certified. Because
on the same,
they have to have at least one lawyer that is certified in this case, because that is a charge, or that is something that the prosecution can go after.
Yeah, exactly. And so, you know what? Here, I'm going to read this to you guys. On the same day, the Indiana Supreme Court heard arguments, which was just a little bit ago, whether or not Richard Allen's original defense team should be reinstated on the Delphi murders case. Carroll County prosecutor Nicholas McClellan filed new felony charges against Allen. Allen was previously charged with 2 counts of murder in October 2022, and after being accused of exing Abby Williams and Libby German on the Monon High Bridge in Delphi, Indiana in February 2017. On Thursday, McClellan filed additional charges against Allen more than 1 year after his arrest. Allen now faces a total of 4 counts of murder and 2 felony counts of kidnapping. According to the new filing, McClellan argues that previously released investigative findings included cause that Allen kidnapped Abby and Libby by force prior to their exing near the Monon High Bridge. Due to Allen committing the act or attempting to commit the act of kidnapping during the alleged crime, Allen can also be charged with 2 counts of felony murder, where murder is committed during the act of another crime. McClellan stated that these newly admitted charges more accurately aligns with the charging information leveled against Allen in the high-profile murder case. Allen's legal team has been notified of the new charges leveled against their client. Allen remains in the midst of a battle with Judge Fran Gull over his defense team. However, as Gull previously removed Allen's original attorneys, Brad Rozzi and Andrew Baldwin, after she found them grossly negligent, or did the 2 willingly withdraw. This is all in the wake of an evidence leak. On Thursday, an attorney representing Allen argued before the Indiana Supreme Court for Rozzi and Baldwin to be reinstated. Allen has previously pushed for a speedy trial in this case, which is currently set to begin in October, and it's unclear if the new charges will affect the proposed trial date or if potential Indiana Supreme Court decision will once again shake up the docket.
I'll be right back.
Okay. So that's where we're at, ladies and gentlemen. So that's what we're doing. I'm going to pull us up here and switch this thing over here. What the hell's going on here? There we go. Let me pull this over and let's continue on with this.
What honor, we don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that two different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect.
To the guest that showed up, and if you unmute it, you'll be live. You're on, if you can hear me.
The defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance.
But I'm really struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can straight.
To the person that came into the chat room just to type a bunch of crazy stuff to me and then leave, you, congratulations with your life. I hope that you find Jesus in some way, shape, or form, because there is something seriously wrong with your mental state of mind. And let me tell you this. If I had warrants and things like that, I would just never, ever, ever turn myself in for it. Ever. And so I'm not surprised Richard Allen never turned himself in for it. Okay. So who wants to do that? That's retarded. And if they can't do anything, who cares? Right? But if they can, then so be it. But if they don't, who cares? Let's get back to that.
Your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I look at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage.
Yeah, to clarify that, it's not my daughter. My daughter's not here. It's Marv's daughter. I think, do you want to be pulled in, Marv? Are you back in?
Yeah, I'm here.
Okay.
She had an appointment and she didn't tell me about it, and she just walked through the door.
She just walked through the door. Okay, let me see here. So I'm going to add this thing at the bottom here. Media slot, you have to catch me up. Yeah, you'd have to catch me. That's what he said. Yeah, people don't like just turn themselves in. You know what I mean? Like, I mean, especially accused of crimes like that, people aren't just going to turn themselves in and roll with it, you know? A lot of people seem to think that, why didn't he just turn himself in if, you know, but why didn't he turn himself in if he wasn't guilty? That's what I want to know. If he didn't do anything, why didn't he just step up and be like, I didn't do anything. Here I am. You know, let's talk about it. You guys want to accuse me? Prove it now. But like Zap said, just because I would doesn't mean someone else would. You know what I mean? All right, there we go. Save layout. All right, there we go. Got this layout saved. All right, so now we're here. Tell mom to call it. Yeah, you know what? Where's she at? Is she in the chat, Jessica? Where's she at? Are you in here, Tina? There you are. Call in. How about you call in? I just aired it. The new charges are basically this. They're saying that they can prove that he intentionally committed the crime. Okay. Yep. And also committed a crime while committing the kidnapping thing.
Right.
Okay. So
thank you so much. We appreciate it.
It's funny. They're like, only one. Look, this is how politically motivated Richard Allen's defense team is. And this is how interlocked with Defense Diaries and Bob Motta that they are, that push this Richard Allen theory. Posted just a minute ago by Defense Diaries on X, a repost from the Weineke law firm, which is one of the attorneys that were there today representing the defense. But only one content creator was sitting in front row at Defense Diaries. He has been boots on the ground during this entire case. I refute that 100% because I've never seen Bob Motta. Never, ever seen Bob Motta go to the crime scene, walk through the creek, go up and down the hill, interview people in person, show up at every one of these court hearings. Because I can tell you there's about 4 press conferences that I never saw him at. So if you guys want boots on the ground, I mean, dude, Marv came to Delphi and met me in Delphi. Right? And Marv walked to the freaking bridge, in the snow like this deep, dude. I mean, it was so deep and it was so cold. It was so cold, everybody. And actually, I wanted to show something from that. If we can here in a little bit, I'm going to pull it up anyway. Downloads.
My socks. Thank you.
All right. I'm not even sure how I get to this damn thing. What are you doing? Socks.
I bought socks when I was in Minnesota with her a couple weeks ago, and I forgot them there, and she brought them back to me. Yes, Andrea, your bestie's here. She's going to take a nap.
Going to take a nap. All right, I see everybody. All right, so now downloads remain.
She drives through rush traffic, so rush hour, so she's not happy.
Gotcha. Okay, man, I can't seem to find this anywhere. What was I looking for? I lost track of what I was looking for. I was looking for something that had to do with this. Oh, I know what it is. That video. I got it. So you pulled up that thing for the list of capital, the murder attorneys, right? I pulled that up, and they're not listed on there.
No, they
Death
aren't.
penalty attorneys, they're not listed on there. So,
but they
if they're
have
not
to be, because otherwise they would have never been appointed.
correct, I think that they do qualify, and I think that they even said that in Baldwin's motion. Hennessy Law Firm, I think, said that. They're like, I mean, he's qualified. Why is he not? Let me see here. So someone, where the hell was that document at? I keep forgetting it. Let me see. I can't find it. Oh, I know what I'm looking for. Man, I keep losing track of what I'm looking for here.
I know.
This is how sporadic I am, everybody.
I'm looking in that Hennessy document to see if it states it.
Okay. And I am looking for... Oh, here we are. Okay, I found him, I think. Here we go. Here's part 1. There you are, part 4.
He was snookered and abused. Oh, that's kind of funny.
Can I play a memorial video?
Yeah.
From Randy? Okay.
Heck yeah.
Let me pull this up and share this, everybody. Give me just a second.
It's not in that one. It's okay, Jessica.
What's up, Jessica? What'd she say?
She said she won't call in. She's scared. It's okay.
What? Tell your mom to call in? Jessica, which Jessica? Oh, who's scared? Oh, she's scared. Call in, Tina. It's just me. Come on. It's just me. It's nobody else. It's just me. Me and you just having a conversation, just like normal, just like we would in person. Give me a call, because your opinion is valued because you're from there, you know. And we all, I mean, we've talked about this for years in person, and so don't feel nervous, don't feel scared. Your opinion is valued as a community citizen from Carroll County, and I respect your opinion.
Thank
Let me
you.
go ahead and share this. Good thing to remember them. Now, some of the music may cut out at times, but I'm going to pull it up on the big screen for everybody. This is one of Randy Gravitt's
Good
memorial
one.
walks. This is the first one, and you'll see how it progressed. I've got them all. I'm going to mute my microphone while this plays. It's a few minutes long.
I'll go back. All right.
Yeah, I don't know how many times I've walked around out here and just snooping through the woods, and trespassing, and just to see.
I've walked all the way.
I have too. It's big, isn't it?
You don't dare look around.
No, I tell everybody that. I say you got to watch where you're stepping.
And I'll tell you what happened to me. I went across. It was the 14th, and I got stopped by cops and stuff just before the southeast end there.
Right.
And I talked to him. And told him some stuff. And I was coming back.
That's going on YouTube.
Gotcha. It's amazing recovery. Yeah, I got all my back.
That was the cop.
Oh, that was
Yeah. The guy. Does it say lives taken much too soon? Rest in peace.
Yeah. That's it.
Just briefly. On here. Where? Yeah, doing something. So Don, how did you hear about this today, man?
Well, like I was on one of the groups, and I seen that I don't know if Mike Cunningham had posted it or who did, somebody, and I just, hey, I'm going.
Yeah, been following the case for a while.
Since day one.
Day one.
And I came up here on the 14th with all intentions of joining the search crew. But I got up here too late. Everybody had already taken off. I didn't know where I was going. I didn't know High Bridge existed.
Right.
Even though I'd been around here. And so I just drove around. Finally, I found where everything was happening.
Yeah.
I found a guy down at Riley Park, and I asked him, where's High Ridge at? He said, well, if you go on out 200, you'll come to a dip in the road. That dip in the road is where the old railroad track crossed 200.
Oh my God.
Yep.
And I said, okay. So I went out, the flashing line on 421, turned left. Came on out 200. I found 625.
Mm-hmm.
That comes down here.
To the private drive.
Right. And I pulled down in there, and then I seen the cops and police cars. And that was about the time that they found the bodies.
Oh, wow.
So this is, what's your name?
Don.
See, I tried to tell you, but I didn't say no damn name. Angel.
Out here, basically he'll be sitting right here to see the girls. And you won't be able to see them at all.
Mm-hmm. You can see people coming as well.
Yeah.
Make sure you're not going to get caught. Trail looks a lot different now than what it did then, because there used to be a couple trees right here, and this orange barricade was actually sitting
right there,
somewhere right around in here. Yeah.
Well, I mean, if somebody's on you, though, even if they were out there just a little ways, there's no way back.
It's very beautiful out here, isn't it? Run across there, Don. Show everybody how that's not possible.
There you go. We're doing down here called a bridge walk for Libby and Abby, and Ginger, who made the flowers for us for Libby and Abby, and she also had angels statues, and she gave them to them to be able to bring them out here.
So this is a memorial walk for the girls.
Yeah, for the girls, yes.
And what are you going to do with these after we're done here?
We're going to take them to their headstones.
Okay.
And that way, the family can see them at their headstones.
That's a good thing, Randy. Yeah. It's a really good idea for you to do this today.
No, I think he.
Do you think he came down this way?
Came down this way because the old Marine who told me the cemetery, you can cut through here and get to the cemetery.
Yeah.
From that, yeah.
What do you think?
I think he came from the other side and kind of timed it where that he seen there was no oil for nobody else by Abby. And, you know, they were still talking about the weird guy. I think he turned around and I think he did his attack right on the
What about you, bud? What do you think?
Well, based on all the videos that I've seen and all the live videos, it's really brings a new perspective when you come out here, you know. And it's just totally different. And I'm not really sure, to be honest with you. I mean, I'm assuming over this way.
There's so many possibilities.
Is the hill over on the other side?
The hill's on the other side.
If you go and wait, you know. And just,
Well, the strange part, he walked right on the edge of this bridge. Yeah. That's the, like, I would not walk on that. There's no way. If I slip and fall off one of those timbers.
And we've got back home, we've got railroad bridges, you know.
Yeah.
And we go through. I always go in the middle. That's
Well, if you're looking at it from this point of view, the second platform on the right is where Libby was standing when she took the photograph of Abby. And the photograph was facing back this way.
Okay.
So they were standing on that second platform, and Libby was looking this way with her phone.
And that's why he said a killer be.
How come he's not in the background?
Because he was back there watching to make sure no one else was coming, but waiting until they got to the other side of the bridge where he could seclude them.
Yeah, that's where the cell phones too far away.
I'm gonna walk out on it. What your thoughts are coming out here, man?
The first thing is, I was kind of telling you, this is actually a lot more physical than I thought it would be. It's not secluded in the ways I thought it would be. Actually, I'm looking at a house right now.
The mirrors?
Yeah, I didn't realize they were that close to the trail. It's kind of got like a haunting vibe out here. I was just telling you that. It's weird, isn't it?
It is weird. So what's that make you think about the suspect or what you said about being here?
This place, no doubt. I got lost trying to find this place, and I have GPS. And I still got lost. There's no way that road over there, where they said he parked, there's no possible way that he didn't know that that place existed beforehand. He didn't just stumble across that. Yeah, you have to be, at one point, have been a local out here. I didn't see how you lived out here and didn't even know this place exists.
Never knew. A couple of other people I talked to, they said that same thing. Said, I didn't even know this bridge was here, man, until this happened.
Just did was drop one of the flowers off to Libby's headstone and an angel cherub. Now we're heading to dropping one off for Abby. Ginger made two of them. That's worth putting at the headstones and keeping us all a reminder of who we're looking for and for these two girls.
So we're not going to.
Okay, you guys hear me now? Sorry. All right. So, sorry, I was talking to myself. I know. I was talking to myself and talking about this video, and I said, you know what? Man, that video gets to me bad. Okay. And it's been a while since I watched it, and I remember making it, and I just remember how emotional that day was. Now I have a caller. Tina, you want to go ahead and excuse me. Tina, you want to go ahead and unmute your microphone before I pull you in here? Jess, can you help her with that? That way we can get you on here. So just push the unmute of the microphone button, and there you go. Now okay, so you are live on the air with us.
Hello.
What's up? Okay, so you're from the area. What was your question that you have? I knew you were asking about the charges or something.
Yes. Yeah. If you go back and explain all that to me.
So originally, Richard Allen was charged with felony murder, which is they're saying that the girls died as a result of him committing another felony act, which was kidnapping. They're saying that he's the guy on the bridge that kidnapped them, and then they died shortly afterwards. That would indicate that there possibly could be someone else involved, right? That maybe someone else is the one that actually did it, but he led him to that area for it to happen. Now, what they've done is they're amending those charges to include that same thing, 2 counts of that, but 2 counts of straight intentional, like murder 1, homicide. You did it on purpose. Where they're saying they can prove that. And by doing that, he now faces 4 murder charges. And the 2 felony murder charges carry 45 to 65. The other ones carry life without parole.
It still doesn't make any sense to me.
It doesn't make any sense.
I've never heard of it.
Well, I'm not either, but I think that they feel they have a stronger case now against him. That's what I think.
I don't know. Let's do the math. 2 girls were murdered. That's what you get charged for. I mean, it just doesn't make any sense.
Well, because it's the way the law is written, and you know as well as I do, the law is just odd in the way it's presented, right? The way they word things and the laws in themselves are completely odd sometimes. And when they're doing all this, that's why they have all these subsections and stuff like that. And like Emily thought earlier in the chat, she thought that it was all of them, all the sections that were listed in there, and that wasn't the case. So it's hard to understand law to its fullest, but
it is.
I think what we're getting today is a glimpse that they believe dude is the dude, like for sure, and that they're going to convict him of it and prove it that he intentionally tried to do that.
Right.
What do you think about the Keegan Kline thing, though? Do you think that that's somehow connected to Richard Allen?
Oh my gosh, you don't know how many nights I lay there and I think, okay, this. I mean, how did he know that them girls? He came prepared. How did he know them girls were going to be there? So I'm leaning towards yes. I think something's going to come out about Keegan Kline.
I mean, what do you think it is? You think he'll be charged with new charges in the near future at any time regarding this? Since Allen's getting a heftier charge, you think
He might be. Yeah,
he might be.
I think so. Maybe.
Marv,
Yeah.
what do you think?
He could very well be. I'll say this, that as soon as that came out, Ruckus had made the comment in a Discord, more arrests are coming.
Okay. That's not
Yeah.
entirely factual, though.
I know.
We haven't seen that. And I don't see any indication from my investigation into this. Okay. And
you have to remember they've not since the beginning, but fairly early on, they have always said individual or individuals.
Because they couldn't rule it out.
Even Nick McClellan in court said there could be other players. They're still investigating this crime.
They may have more solid evidence now then.
Yeah.
They may have been able to, Tina, you know as well as I do, you don't just find the bridge. Okay. You don't just find that place.
No, I didn't even know it was here. Yeah, I didn't even know it existed until this happened.
You didn't?
No, not at all.
So just to answer guilty of crime by Jay, we don't know yet. The Supreme Court has to make a decision yet. Today was them just listening to the arguments.
Which we aired live right here. So if you guys rewind the live stream, it's going to lump a long live stream. But if you guys, I screen recorded it too, so we'll re-upload it in a different section by itself so you guys can watch it without commentary from us.
Yeah.
It's interesting. Tina, is Jesse there with you?
Yeah. Yeah, we're both here.
Okay. Jessica,
Yeah.
do you think Richard Allen is the suspect?
Oh, you don't want my opinion on that.
No, I
Yes,
do.
we do.
If you don't think it is, tell me. Come on, you tell me everything else you don't like.
No, I don't think it was him.
No. Do you think it was someone completely different? Why would they frame the dude from CVS, though?
It's Carroll County, Anthony. You know how they are.
Yeah, but they knew that this was going to be in the spotlight. You know what I mean? Especially, I'll throw a camera right in their face and be like, why'd you arrest this dude? But why would they just pick him at everybody? Have you ever interacted with him? Have you guys ever interacted with that dude?
Well, she's on it now.
I have multiple times, actually.
CVS?
Yes.
So what was he like to you? Because I only remember talking to him one time vaguely.
What was your opinion?
He's very quiet, very nice guy. There was one time he was stalking. I was going down the alcohol aisle in CVS, and he was stalking pads up like down the aisle, and like I had my slides on, so you could hear me coming. The dude like didn't even like turn around and see who was coming behind him or anything. You know what I mean? Like he had, what's the word I'm looking for? Like
not a care in the world.
Not a care. Yeah, he didn't. I mean, it's not like he was like scared of anything, like looking over his shoulder or anything like that. So
When was this?
Right, a couple of weeks before he had gotten arrested, and then I went to CVS again one time, and there was an officer walking into CVS at the same time I was walking in, but I don't know what had happened because I got my stuff and I left. So, and then he ended up getting arrested like a week later. So, yeah.
Yeah, that is interesting. So, in no indication. So, I mean, how much that like we've talked about this case and stuff like that, and these are friends of mine, everybody. So I know these people that we're talking to here. Like we, and going around and walking around in Delphi and talking about this case and stuff for like years, and especially right after the crime happened, that whole summer, being glued to those trails and trying to figure it out. Why is it so interesting I mean, I don't know. How many people do you know that's actually from our town that actually follow this case like this? You know what I mean? Because most of the people on the internet here, they're watching from the world, not Delphi. Do you guys know other people that watch from Delphi?
There's a few, and like my friends, like I'm older, of course, and we watch it. But two girls were murdered in Delphi, and you can go into a grocery store and nobody even talks about it.
Right.
You're right.
But yet you listen to these people online and they're like, Delphi have their secrets. People are afraid to talk. Well, I'm not afraid to talk. There's just nobody wants to talk about it.
No, if you do talk about it, you'll probably come up missing.
Or in jail.
Right. Yeah. Yep. Exactly.
I mean, we know. I mean, the Randalls. I mean, you guys know.
Yeah.
Geez, I mean, like just people. When you hear like these movies and these little movies where they show like these small town sheriffs and stuff and all this stuff, and they're all backwoods and they're like, well, and it's like they run the law and they're like, we are the law. That is what it's like there.
Yes.
It is horse and buggy and all, literally.
Yes. Well, I'll tell you. I have told so many people this. The Holly Bobo case from Tennessee.
Yeah.
You can ask Jessica. I was on it all day, all night. I had every one of them guys' names wrote down.
From the very beginning.
Yeah. And it may be hard to believe, but I did. I had every one of their names wrote down. So my son asked me. No. I was just doing my own stuff. And, that was years ago. But my son asked me, Mom, why haven't you got this solved yet? Like, because I live here. That's why. I don't go out and ask questions. And
yes,
do all
you
that
do.
Stuff. Well,
I'll tell you what. I remember one specific day I was walking out of the courthouse or filming something from Delphi and ran into both of you, and you're like, "Hey, come here," and we started talking about Flora and Delphi.
Yeah,
because
but
we're interested in it,
Yep.
like, and we've all been accused of it or some way, shape, or form.
Yeah,
You know what I mean? All of us.
And let me tell you this: while I'm live, I get so aggravated. Let's just say that this was me and Sherry, my friend, and it was Jessica and Sherry's daughter, and we took them out there and dropped them off. I'm telling you what, we would be the worst parents in the world because that is a secluded area.
Yeah.
Yeah. Very secluded.
It is. I mean, I didn't know it was there, so I mean, it had to be secluded for me to not know, and I walked all over town, So.
So because of who it was, is what I'm trying to say is what's making this what it is, and money. That's what I think. That's my opinion. Because
profiting off of it,
I would have been the worst parent in the world to drop her off out there. And that's my opinion.
Right.
But you hear all the news channels saying, "Oh, it's not secluded," blah blah blah. Yeah, it was.
It was secluded.
Not now because they got it all fixed up.
Right. And to add to that, what was Delphi like before the crime happened? Describe the town, describe the people. what it was like from both of your perspectives, from your perspective as someone who's a little bit older than me, and then Jess's perspective for someone who's my age. What was Delphi like before this, and what's it like now? What happened?
Well, I know what it was like before. There's just a bunch of druggies, in my opinion.
You think
I
so?
mean, yeah.
Oh yeah.
And we had the apartment building there by the
Yep.
laundromat. That was, I mean,
Delmain Apartments.
yeah,
Delmain.
Delmain Apartment.
Yeah.
So
But
okay, so it was all druggies. Okay, not all, but you would say druggies, and then I would have to also say that the majority of the population in Delphi are older people, right? When you
yeah,
think like old, and I mean like older, like in 70 plus, probably,
yeah.
right? Because
Mhm.
it's a retirement, used to be a retirement type place, but there are a lot of people that use drugs, use substances. It's a lot of country and stuff. Did you feel safe in
Oh, yeah.
Delphi? Did you feel like, because we never had anything like this, you know what I
Oh, yeah,
mean?
I used to, back then when that happened, I slept with my window open with my fan in the window
Yeah, doors
when
unlocked,
I
leave
lived
the
at
car
that
unlocked.
other
It's
apartment.
fine.
And
Yeah.
it wasn't anything to let your kids go to a park by themselves at that
No,
time.
No,
mm-mm.
no,
No,
it's,
not at all.
and it's just, it changed the whole community because now everybody looked at each other. I mean, you know, and it's okay if you
Oh,
guys
yeah.
did, even if you guys looked at me sideways at one time, like, man, could it have been him? You know what I mean? Because I
I
did.
never
With
thought
people I
that.
knew.
I never thought that at all.
I
No,
know,
I
but I
never
mean,
thought.
No, but there
people
was
did.
one rumor at one point in time saying that me and Greeno was down there, and I didn't even know the bridge was there. So, like,
Yeah,
I mean, I don't know.
I've seen all these rumors and speculation.
Yeah.
It's like everybody in Delphi has been targeted on the internet in some weird way.
Oh,
If your
yeah.
names come up on the internet, you've been targeted. So what do you guys think about today's hearing? Did you guys watch it? Do you understand what happened? Do you know what happened?
I wasn't here.
Yeah, I watched it.
Okay. What do you think's going to happen? Do you think they're going to kick off the judge, the defense attorneys, or leave them all in?
I think he's going to get his lawyers back.
Okay. And what about the judge? She going to stay or go?
I think she's going to go.
Okay.
Now, is
That's
she going to
just my
go?
opinion.
Is she going to go because the Supreme Court's going to kick her off, or is she going to go because she got this promotion and she's
Maybe a
not going
little
to
bit of
have
both.
time?
Maybe, yeah. That I knew she got the promotion, so I'm thinking maybe a little bit of both. But I really believe he's going to get his lawyers back. That's just what I think.
Oh, yeah. You know what? Some people in here in these chats are some idiots, ain't they?
Yeah.
All right. So do you have faith in Tony as the sheriff in Carroll County? Did you vote for him?
Do what?
But did you vote? Do you vote?
Yeah, I vote.
You still live in Carroll County?
Oh, yeah.
Did you vote for Tony Liggett for sheriff?
No. No.
Did you vote for Tobe Lesenby for sheriff?
No.
Did you vote for anybody for sheriff?
No.
Would you vote Greeno for sheriff?
Yes.
There we go.
Yes, I would.
You guys are funny. Man, I really think we could change this town. We know the ins and outs of this place, you know, I really do. I mean, I think if I was given that opportunity, I think that I could do something good for the community of Carroll. And then just, that's it.
We're
I mean,
felons.
I know. I know. We can try. We can at least ruffle some feathers, and they'll take it to the Supreme Court or something.
And then an off-the-wall question.
Sure.
Okay, so Richard Allen, they took him in for questioning, yada, yada, yada. He had a chance to run. Why didn't he run?
Run when?
When
When they came in and searched his house?
Yeah.
Well, where's he gonna go? I mean, think about it. Let's pretend your husband and you and your daughter, okay? And your husband is this dude. And what's he gonna do? I mean, what's he gonna tell you? Hey, I'm leaving. Okay, I'm leaving you. I'm just all of a sudden he's going to tell his wife, I'm leaving you, tell his kid, get screwed, I'm out of here, or just disappear on him like that. I mean,
Well, I don't know.
the
It
thing
just
is he
seems
has a conscience. That's why he told his wife what he did, because he didn't want to leave his wife. He needs her. He needs that emotional support. He needs her. He
yeah.
needs to hide behind her. You know what I mean? Like that's
But
him.
like usually, like 9 times out of 10, he has to know. Okay, they're on to me, and he didn't do anything. Like usually, like they would off himself or run.
Mm-hmm.
Yeah, but he didn't do anything. He just sat back and let what happened happen.
Yeah, which is sad.
My thing is, though, he drank alcohol. When you drink alcohol, you talk like no tomorrow. You know what I mean? Why didn't it ever come up anywhere?
It might
Yeah,
have.
and
Man, it might have, dude.
it might have.
It might have. Think about it. Have you ever hung out at JC? I mean, my Uncle Herb owns that, right? So,
Mhm.
or owned it. I mean, it's not there anymore, but I mean, dude, that's where he used to hang out and play pool, was at JC's, right? So
Like nothing
they,
ever happened.
well, didn't they raid JC's right after his arrest?
Oh, I don't know. I never heard that.
You didn't hear that?
No.
I was told that.
Hmm.
I was told that, but
No.
I was, in Cass County myself at that time. So
Mhm.
I assumed it to be true, but I guess I couldn't say. I thought that they did a raid on that. I know people were interviewed there and stuff like that. My great uncle did say that people talked, but he didn't say anything.
Yeah.
I mean, dude, someone has to know. Someone had to know in town. Someone had to know.
You
I
would
mean, do you think
think.
his wife
Yeah.
knew? Do you think his wife knew?
How could she not, though?
I think she had a suspicion. Just my opinion. I think she had a suspicion.
I would have. I mean, all of a sudden he ditches the blue coat. If I would have saw Richard Allen wearing that blue coat and those pants, I'd have been like, that is the dude. That's him. But I didn't recognize him in the red. Just what he was wearing threw me off.
Mhm. I'll tell you, I went to his first hearing,
Yeah.
and I've been to a lot of hearings for family members.
What was it like seeing him?
That's what I'm getting ready to say. I have never seen anybody shackled and chained the way he was. I mean, I guess I figured there'd be more people there, like on the outside, where they're bringing him in and yelling stuff. There was only that one guy. I just couldn't believe. I'm like, this is the guy that they're saying. I didn't think that he would be that short. I could not believe the way he looked. It was just all shocking. I just couldn't believe it.
What did you think of how he reacted? Was he more shell shocked, or?
Yeah, you could tell he was shocked when they was walking him through.
Yeah, I remember Barbara McDonald describing it live, saying that when he
Don't get me
walked in,
started on that.
he made eye contact with the family.
No, he
And
did not.
he didn't?
No, he didn't. My eyes
didn't.
didn't go off of him. I was only like 3 seats away. I could have reached out and touched him.
Wow.
And
You should have.
he
I
did
would
not.
have. Man,
Do what?
you should have. I would have.
Yeah. Well, I did try talking to his mom because I know his mom from somewhere. And I tried talking to her, but she was just crying so hard.
She
And I
does
was
look
with Julie.
familiar,
I was with Julie.
doesn't she? You're with Julie
Huh?
Melvin?
Yeah.
Okay.
I was with Julie, and yeah, I was. You can ask Kelly Brown. She'll tell you. I was just. She said, Tina, I'll never forget the look on your face because I did video chat with her right after, and
Wow.
I was just shocked. But
Yeah, I was on the phone with Julie, like during all that stuff. like in and out. You know what I mean? Like
Yeah.
before she went in, after she got out of there, I was just crazy about it. Are we ever going to see a resolution in this case, man? Okay, let me ask you this: do you believe in the Odinist thing?
No.
Not at all, right?
No.
Do you know
I
Brad
don't
Holder and those people that they talk about, Westfall? Any of those people? Do you know who they are?
Yeah, I know who they are. I don't know them
From-
personally, but I know who they're. Yeah. No, I
Right.
don't think so.
Yeah, I don't either. I just don't see it. I mean, I think that's
No.
pretty dangerous to throw it out there. You think Ron Logan was involved?
Now that
I do. I do.
I don't. Okay, here's my. I don't want to believe that he was involved, but there may be a connection between, because you asked about the Keegan Kline, and then so maybe if it's not Keegan Kline, maybe Ron Logan had something to do with it. Is there a connection between Richard Allen and Ron Logan? We don't know. Barbara
Isn't it
McDonald.
weird, Linda, from being in the area, isn't it weird that you can't really piece together his life? I mean, Richard Allen's, we don't know a lot about him. We know that he went to one bar frequently. We know he's got a wife and a daughter and where he lived. But other than that, you can't connect him to anybody. Don't you find that weird?
Well, too, because if he had his Facebook and stuff up there, we could connect him to a lot of people, but there was nothing from the beginning.
Right.
So.
Well, here's my thing.
It's
Were you
hard to
shocked
connect
when
anybody.
you found out it was a dude? Were you shocked? Were you like, holy shit, that dude?
Do you what?
Were you shocked when they
Yes.
arrested him? Like, that dude from CVS?
Richard? Oh, yeah.
Yeah.
I'm like, what? Yeah, I was
Did it blow
shocked.
your mind that you missed it? That you didn't know? Well,
No, really, because I don't ever go into CVS.
right, but did it? Oh, okay. Well, I did. Okay, Jessica, did it blow your mind that you looked at him and didn't realize that he was the bridge guy?
Oh yeah, absolutely. Like I've talked to him. Yeah.
That's
Yeah.
scary.
Yep.
Do you think that he watched my YouTube channel?
Probably.
I would like
He
to think
probably watched a lot.
I bet he did. I would if I was him. I would keep up to date on what people are talking about, especially people that are running around locally knocking on doors. You know what I mean?
Mhm.
Subject. If you got me showing up at your door, you did something wrong, dude.
Talk about
Yeah.
the shock
So,
fest.
Any other
People are
questions,
Oh,
Marv?
yeah.
Or you guys want to say anything else?
The fact that everybody's like, why hasn't, like when they take him into court and stuff, why isn't he screaming, oh, I'm innocent, I didn't do this? Well, the dude's got a shock vest on. I'd keep my mouth shut too.
True.
Yeah.
Yeah, I guess so.
Yeah. I mean,
Hey,
seriously.
here's another question. Why is he in prison? Why don't they house him in Carroll County? Answer that question. I want your guys' opinion from a local standpoint. Why won't they house him in Carroll County?
They very well could if Carroll County wasn't so corrupt, because that's where he should be, is in a county jail, not in a prison.
Correct.
It just
But-
goes to show you
Sure.
that they're corrupt, not just Carroll County, other counties too. We don't know
Yes.
if he did it or not as of right now, because he's innocent until proven guilty. So he should be able to be treated, like anybody else that is arrested and go into the Carroll County jail.
Yeah.
It's not like somebody's going to come in there.
Okay, so here's the thing. Would he be treated any differently in Carroll County jail versus being in solitary confinement in prison? Where's he going to be in the county jail? Jessica, which block is he going to be in?
Probably an H.
H. And that is what block? Max.
What do you,
That's what they
yeah,
call it,
right.
max.
Yeah.
Well, it's a two-man cell. They'll put one person
Yep.
in there. Okay.
Cameras in there.
There's cameras in there. There's a little shower. It's tiny. It's small.
Yep.
Would he rather be in jail or prison after facing Carroll County versus where he's at? He
But he's
can't be
not.
safe.
he's not
Huh?
being able to have the right kind of counsel in the prison. They can't drive 10 hours.
I do agree with that aspect of it, that it is far.
That's just ridiculous.
But the Public Defender Commission just set up an online portal where they can communicate online with their clients via a device, electronic communication device that is private, cannot be used as evidence against the defendant, as it is protected by the 5th, 4th, and 1st Amendment.
Oh, that should
So
be interesting.
yes, so that means that they'll be able to do video visits with him and present evidence and screen share, it says. So they'll be able to be like, hey, take a look at this document. Do you see this? Yeah, we're reading it. It's kind of like we're doing right now. Exactly what we're doing
Yeah.
right now. They'll be able to do that with them. So I think that may be an
That's a
option
good thing.
around it. It may be an option around it, but I do agree with the fact that they should have access to him in an expeditious manner. If, for example,
I
if something
agree.
happens today, they need to go talk to him today, they should be able to go down there and get in there. They shouldn't have to wait till
Right.
administration opens or something like that.
Yep.
Mm-hmm.
And the prison should make accommodations to bring him before them and let them sit in a room together. If they're worried about him attacking them, leave him handcuffed and shackled on the feet and hands, okay? And have a guard in there with them in case he tries anything and tries to harm them. They can tase him or slam him or whatever they need to do. He's protected. They let Ted Bundy and other people do interviews with news reporters.
Exactly.
Okay?
Right.
They just set
Yeah.
a distance away. Okay. But since they need to share files and stuff, it would make sense that they sit across from a table, a long table that he would have to jump over in order to get there. And they have in the prison bolts bolted to the floor with like a little hook on it. And the chain goes through that. So you can't even walk away from that area. It's like the little ball and chain thing.
Right.
They could do that
Yeah.
very easily, accommodate for those attorneys.
I don't
What
know.
else?
There's so
Anything
many
else?
other things, but I'll think about them when I hang up.
Yeah.
Then type it in the chat.
I will.
Okay. Anything else you want to
Um,
ask or talk about? Yeah, I mean, you're welcome to it. This is Delphi. My specialty.
Well, other than Delphi being so secretive, I hate that.
Very secretive.
And there should be no gag order. I don't
You're right.
think.
I mean, McClellan alone has enough skeletons in his closet.
He
Right.
does. He's been arrested.
If you want to talk about McClellan, I've been at
seen
the bar with McClellan before.
Me too.
Oh yeah, I got video of him and Patrick Manhan at the bar in White County for his birthday. So I mean, I mean, so and to say that he didn't drive home drunk that night is a mistake to say that. Everyone
Right.
did. So yeah, it's not all bells and shiny whistles with our law enforcement or government officials in Carroll County for sure. But I honestly have faith that Richard Allen is the right guy. For one thing, I do back him up on that.
Yeah. I believe he's the right guy.
Rude.
No, I believe they have the right guy, but I just want to see more evidence.
Yeah.
You think? Yeah, I would like to see more evidence, and I think that we're probably going to see a little bit more of that. You know what? Here's what might happen. When they file for an amended charging information, they're probably going to file an amended probable cause affidavit or a memorandum in support of it, which will include why they changed it. Why are they amending the charge? They have to give a reason why they're amending the charge, right? What is the reason? Why charging with intentional homicide? Now, they may change. They may reveal some more information that we don't know. We may find a link. I pray we do. Please just let it be over. Is what I want. But anything else?
I do have another question.
Sure.
The guy, because of the leaked pictures and all that.
Yep.
Why him? Why did he off himself?
I don't know.
It
I
just
don't
doesn't.
know.
I think about that a lot too.
I think there's more than that.
Huh?
I don't think there was more than that. I don't think he specifically said, I'm doing this because of this reason. I don't even think he said why he did it. There had to be something
Well,
else going on. He was a
you gotta
military decorated person. He had
exactly.
a family. Okay, he could have had he could have had PTSD from some event. He could have been going through a bad relationship or something, or just been miserably depressed, and just that's what happened. And it just happened to be coincidental that he's one of those people. I don't see someone doing that.
Maybe.
I don't know. I don't see someone just seeing that and be like, oh gosh, I can't take this, and just, I mean, someone could, I guess. I guess if they're not
Mhm.
mentally strong enough, but if being in the military, I would assume he would be mentally strong enough to do that,
You would
to
think.
see that. Yeah, you would think.
Well, and I look at it this way too, that you are one of the main reasons why two loved and beloved girls in the whole world, their pictures are now out and could get out to anybody and everybody if not protected.
Yeah.
Right.
And your name's gonna come out. You know it. And it happens. And he's like, I can't deal with that.
Yeah, maybe. I don't know. I would like more information on it though.
You're going to get more information. If there is jury trial, you're going to go.
Oh, I'm gonna go.
Yeah, we're going. Yeah, hell yeah, we're
Yeah.
going.
You better be.
Yeah.
I'm going to need her in that courtroom. Hear me?
Oh yeah. Yeah.
I'm going to need a camera in that courtroom. And you're going to operate it.
Me?
You were just
Any of you. I'm just messing with you. Just like
Yeah,
put
I
you on the
don't
spot.
know about all that.
Shoot,
Yeah.
I'll do it.
Take pictures of that dude. Take pictures of that dude if you see him, or just take pictures of anything you got. You know what I mean?
Yeah.
Anything at those hearings. Nothing's going to happen to that Westerman dude for leaking those things, but I think he's just being the fall guy for Baldwin to get him back on the case. But they
Yeah.
didn't mention any of that today in this argument, so I mean, I guess
Mm-mm.
that kind of excludes that option. They didn't bring that up. They didn't say that, so I guess my thought was wrong on that.
Yeah, I don't think anything's gonna happen to him.
True. Okay, and there you go. Someone said Legacy Investigation says, how do you know that he was shocked by going into the courtroom rather than just acting shocked?
Mm.
Could you see through him? Have you seen him more than once?
No, that was the first time I've ever seen him.
And the only time you've ever seen him in court, I mean.
Yeah, well, that was his very first court appearance.
Oh,
I mean,
okay.
you know what I mean? No, he just had this blank look on his face and in shock.
Okay. Yeah, I mean, I would, because he probably didn't expect it. Like Jess said, a couple weeks before he's arrested, dude doesn't expect a thing. And I wouldn't have suspected a thing either if I looked like him and they released a second sketch of some young cat.
Exactly.
Okay, because he was
Yeah.
over 18 to 40, right, when he committed the crime.
Mhm.
And the first time they said he was 31 to 65, could be anywhere. It looks like the first sketch. He looks more like the first sketch, I think, than the second sketch. The second sketch is supposed to be the bridge guy still, but he's
Mhm.
18 to 40. So since Richard Allen probably thought, you know what, I'm not 18 to 40 and I don't look like that. I'm not that young kid. They have no clue. He thought he was golden.
Well, I'm not saying that he was shocked because he was arrested. I mean, that happened. Him walking through there is what I'm talking about.
Yeah. Oh, okay. I see
Just-
what you're saying. Yep. Walking through the courtroom. Yeah.
Yeah.
I bet he was like, shit, dude, look at all these people here. Look at this.
Like he looked like he could just literally have.
Go ahead. Sorry. It automatically mutes you when I did that. Sorry, go ahead.
Oh, I said he looked like he could just faint right then and there as he was walking through. He was pale. Didn't even look like the same. Maybe because the picture that I seen, you know, the quite a few pictures, and then I seen him in real life.
Right.
He He just didn't look the same. He looked shocked. He looked like he could just pass out. And maybe it just hit him when he walked through. This is real. They got me.
Exactly.
You know?
Would it you? I mean, I seem to think that would be a. Oh, I don't know. I mean, that would be shocking.
Walking into a hostile room like that, for
And
the
all
very
the-
first time, that would shock me and send me into panic.
Especially because everyone in the world is looking at you.
Yes.
You. And now if you're guilty, you know that they know. And you're like, you feel real unsafe at that time.
Yep.
From
Yeah.
everyone, the cops and everyone. You just, that
Yes.
person
Yeah,
has to
and
feel
there's-
like, I am not safe. I feel
You
like
realize
they're going to
that
lynch
you
me.
were- You realize right away that you were the number one hated man in that room.
Yeah. And
there was a large presence of police officers and the Indiana State Police and the ones dressed in the green, whatever they are.
Media and yeah.
Yeah. So yeah, I mean that's probably what it was.
Yeah.
I would probably feel that way too.
I definitely
But-
would. I would freak. Not ever
Yeah.
being in that situation.
You know what?
Huh?
I wouldn't freak out. I'd be like,
Oh, you would too.
Oh, you would too.
whatever, dude. Get out of here. Next caller.
I was next door to you in there.
You know what? And I was like, I run this jail, dude.
You're right.
No.
You guys remember when Lesenby came back there and was asking me for advice on how to run the jail? I was like, well, you know what, dude? If you just let me be the trustee, I'll just.
Well, I'm just gonna say I'm disappointed in both of you for even being in there and
You know
talking
what?
to Leslie.
It was just a social experiment. To
It
make
was
sure that
not.
First, I wanted to make sure that Jessie was okay. She was in there alone, and I wanted to make sure she was okay and had a next door neighbor, right? And second, I wanted to go in there and see if I get the inside scoop on Richard Allen and all this Odinism theory stuff.
Ready?
Oh.
No.
Okay.
You know what? I'm not proud of it, but our experiences in there have led me to be a better person these days.
Yeah.
Well, that's good on both of your guys' part.
Yeah. So stay out of trouble,
don't
Jessica.
do it again.
You listen to Marv. Stay out of there.
For sure.
Stay out
Both
of
of you.
Yeah.
Okay. I gotta wrap this up.
Guys. All right. Hey,
Oh,
Jessica, how do we keep it on this channel?
Southern style.
Southern. There you go. All right, girls. Thank you. Love y'all.
Love you.
Bye.
All right. Bye.
That was cool getting to listen to somebody from right there.
It is really cool. Yeah, and those are friends of mine. So, I mean, like she said, they've been accused, and rumors fly on the internet and stuff. So this is just a different.
We saw how easy it got out of control with rumors on the internet.
It gets out of control real fast.
Yeah.
Why is it so hard to keep? But there's truth to some of it.
I know.
That's
Well,
the
we're
problem.
realizing that now.
That there's truth.
There is some truth in there, yes. We're realizing that now out of all the rumors we've heard, and it just boggles my mind. It really does.
Yeah. I'm still stunned at today, man. I'm still
Oh, I
stunned
know.
at the hearing. I mean, I don't know. I didn't know what to expect. What I saw today was not what I expected. I expected it to be boring, bland, just like, Your Honor, like the dry, clear eyes, like boring court hearings like that. Today was straight in there, man, and straight to the point. We're going on the record in this case. What's up? Who are you? I'm Lehman. I represent the defense counsel in this case, and this is what we got going on. Bam, 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 bam. Question.
Did I not tell you last night it was going to get heated?
Yeah.
And you're like, no, it's not. I'm like,
yeah.
You have no idea.
Yeah, and this was interesting. I'm so excited. It's exciting for me. I don't know. Now I can dig through all this stuff. I got so much more stuff to look at
It's a
and dig through.
learning opportunity for all of us. All
Big
we
time.
see is normal trials, normal judges, and this is different. The
This
Supreme
is not
Court is
normal.
different. No, this is not normal. So that's why when everybody was asking, well, shouldn't Richard Allen be there? No.
No.
That's why Judge Gull wasn't there either. Librato and Scrimmon, they weren't there, but Baldwin and Rozzi didn't have to be there. But these are their attorneys,
They wanted to be
representing
there and
attorneys, so
see
they
what the questions
wanted to
were.
be there.
Do you think that shows? I got a question for you. Do you think that shows confidence in the judge and her counsel versus the two defense attorneys?
I do, actually. She was confident enough that her attorneys could fight for her rights and her position in all of this and know that she could still do her job and not have to be there.
That's a strong woman to be able to do that.
Mm-hmm.
Most people, and I know I would have the issue, I'd be right in there, right next to him. Hey man, ask this, ask this, ask this. It's like you can't do that in there, but that's how I would feel. Like
Yeah.
I need to be there, man. I need to see what they're saying about me. I need to know. I need to offer input because this is me. And what if I lose? But she doesn't feel like she's going to lose.
So here's one of the things that's so different about the Supreme Court, though, too. These individuals, these lawyers that have to represent their clients, they don't get just to pre-plan all of what they're going to say. They have to come up with stuff right on the cuff because you've got 5 other higher justices asking them questions, saying, what about this? What about that? That's how prepared they have to be. They have to be prepared for any kind of question and have an answer.
Do you see how well they did that? It's almost like these guys are so good. They could be actors in a movie because of the answers that are given was like this. Well, who's to say that, Baldwin and Rozzi withdrew their appearance? Well, by their own mouth, Judge, because Rozzi said specifically, quote, and they just say it word for word, exactly what's written on a whole page document. One of these motions that we read, they read it from their mind. He said this, quote, honor about this day. Richard Allen said this by his own mouth, Judge. He said that. And according to this case law, Shepard, I'm just going to make something up, Shepard versus State of New York, blah, 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 blah. The court found this, and they're just coming up with that on top of their head.
Right.
Like, that's to answer a question that was posed
and
to
how it applies to their situation.
Yep. And then the Supreme Court will respond back with, well, maybe it kind of does a little bit, but not necessarily, because that's not necessarily the truth either. We ruled this way, and they correct them on it. And so they're learning that some of the things that these attorneys are saying is case law and works on their case may not necessarily work on their case for the judge and for the defense. Both. The Supreme Court may not rule on that.
I don't think.
I don't think so. I don't think so.
Oops. I hit the wrong button.
I highly doubt that.
I don't think they would have made a decision that fast.
No. Prosecutor files more charges against Richard Allen. Yes, they did. They did reinstate him.
Did they? Oh,
hold on. Lady, hold on. I have a news story. I'm going to read it. Okay, now, dude, breaking freaking news again, dude. Live in the Delphi murders case, an update. The Indiana Supreme Court orders Richard Allen's original defense team of Andrew Baldwin and Bradley Rozzi to be reinstated to the case. The court will not remove Judge Fran Gull from the case and will not order the trial to be commenced within 70 days. The ruling is in. Nothing changed. Nothing changed. The ruling is in, ladies and gentlemen.
Oh My
We
God.
have an update in the Delphi murders case. Richard Allen has been charged with 2 counts of intentional murder. The defense attorneys have now been reinstated back on the case, and the judge stays, and there is no order for a trial to commence within speedy time. Therefore, so Scremin and Liberato will be removed from the case, I assume, at this point.
Yes,
Damn,
it's
where is
exactly what
Savdor
that
at?
means. I just changed the banner. Judge
Did-
Gull will remain the judge. Rozzi and Baldwin are reinstated. No order for speedy trial. That was
Correct.
quick.
Dude,
Holy crap.
holy shit. This is crazy.
What exactly does it say?
It says exactly that.
Put it up
Let's
here.
go. Okay, listen, go to the Supreme Court website again. Go back to
Oh.
that. Go back to it. Indiana Supreme Court order. Delphi. The Indiana Supreme Court orders amending rules of court, other orders. Select
I
right
can't
there, published
freaking
order. Right
believe
there it
it.
is. Right there. I got it. I got the document. Boom.
Put it up.
Hold on. I'm gonna pull it up right now. I'm gonna share it. Save as. Use this as a thumbnail if you want. Let's see. Order Supreme Court. All right. So this is a PDF. Let me save it as a thing. Everybody, man, I'm like so scrambled here. This is freaking awesome. Hold on just a second, everybody. I got the order right here from the Indiana Supreme Court. I'm just going to screenshot them and send them to you. Okay. So let me go ahead and pull them up here. I've got them, and we're going to go right here. So if there's anybody out there, any other creators out there that still aren't covering this case, breaking news. Marv, you can change the title and the thumbnail if you want.
How do I do that?
You can just go into like the settings at the top, I think, up here, like edit it or whatever. Like how you can view it on YouTube. It gives you an opportunity to edit too if you want.
Okay, so
I mean, I don't know. Hold on.
I don't know how you do this.
Let me publish this thing. Or let me get these things up.
My
There's a
God.
published order. Okay, here we go. I got another one too. So, for everybody that's just tuning in, we have breaking news again in the Delphi murders case. Marv, earlier we found out that the prosecutor, Nicola McClellan, filed new charges against Richard Allen for murder, right? And wow, that's so intense. All right, here's the other 2 documents. I got them right here. So, pull this one up. Pull this one up. Order reappointing public defenders. Download. Pages 2 in a MP4. Here we go. I'm looking like right at the camera, everybody. MP4. Of Baldwin and Rozzi to be reinstated. No speedy trial. Okay. All right, got it. So I'm going to present this right here for everybody so you guys can see this. And let me pull it up from my downloads so you guys can take a look.
Oh my God.
Okay, so where's it at?
That is the quickest decision I have ever seen.
You know what? You guys were right. I mean, I thought people was going to say something completely different. That was that blew my mind right there. Let me see what we got going on here. Here we go, ladies and gentlemen. Let's go ahead and take a look at these documents. Right here, the first thing we got is an order Reappointing state public defenders on December 30th, 2019, the court issued an order appointing Amy. Or wait, no, that's a different one. Hold on. Sorry, I got the wrong one.
Not right.
It's gonna go to the second one. Hold on. Sorry. Here it is. This is it right here. The relator, Richard Allen, seeks relief from the court under the trial court rules of procedure for the original actions. Relator has requested a permanent writ of mandamus, asking this court to order the trial court to reinstate his former trial counsel, attorneys Andrew Baldwin and Brad Rozzi, as his court-appointed counsel. 2, order the trial court to commence relator's trial within 70 days from the issuance of the writ. 3, remove the special judge from the relator's case and appoint a new special judge. Having considered the written submissions and having heard the arguments of counsel, the majority of the court votes to grant the petition for the writ to relator's request to reinstate attorneys Baldwin or Rozzi as his court-appointed counsel. The court unanimously denies all other relief sought. The court will promptly issue a written opinion explaining its reasons. The pendency of this matter in the court does not stay the proceedings in the trial court. Done at Indianapolis, Indiana on 1/18/2024. You know what this means is we're going to have a trial much sooner than later.
Yes, we are.
And we have a guest that's gonna join us for an opinion.
Yep.
What's going on? You have to unmute your microphone. Chris. So there's a microphone icon on your screen that you have to unclick. There you go. Now we can hear you.
Can you guys hear me?
Yes.
Yep.
Okay, so even though Richard Allen acted alone, I believe that Keegan and Kline probably told him Libby was gonna be on the trail that day. Would you guys agree or not?
I think that maybe Keegan Kline told him that they were gonna be on the trail that day. Yes, I think that is a very good possibility. Marv.
It's possible, yeah. I'm not ruling anything else.
But even if Libby, hold on. But even if Libby was targeted by them, why though? Could she have known some secrets about them or something?
She could have, but I don't know. I mean, it's a possibility, but we're not really sure. You know what I mean?
So with this new stuff happening, could the trial be much sooner than we thought after all? Maybe.
Absolutely.
Yes, absolutely.
We could have a trial within 3 months, if not sooner.
You're right.
3 months, if not sooner, and if Allen finally decides to plead guilty, maybe if he knows he's got no chance, then maybe there won't be any trial.
Well,
Yeah,
you know
but
what?
at
You're
this
right.
rate, I don't see that happening because he thinks he's got a great defense.
Yeah,
He does think that.
Exactly. Plus, he has no conscience and no remorse, so of course he's not going to plead guilty.
You're right. You're right. He's not going to plead guilty, or he
So-
already would.
So
have.
how would the Allens even know Richard Allen in the first place, though?
The Klines?
I'm curious
I don't
about
know.
that.
Maybe through online communication. That's maybe the only way that they communicate with the Kline and Richard Allen. I think. Maybe that's it. Probably maybe that's the only thing I can guess.
I think maybe possibly that they could have been members of an online child trafficking ring or an online child pedophile ring together. That's also possible.
Right. It is very possible. I think that they're linked into that kind of stuff in some way, shape, or form. I'm not sure exactly how, but I'm pretty sure that there is a link We just don't know it yet, but we're going to find out about it probably in the court's trial. So, yeah, and they're going to stick with the Odinist theory.
If the trial might be happening much sooner after all, I wonder if they're going to end up finally releasing additional evidence against Richard Allen that they had, maybe.
They will at trial. They will give that at trial.
It still has to wait until trial.
Yes,
yeah.
to get more evidence out there. Yep.
Okay.
Yep, that's exactly. Okay, anything else, Chris?
Yeah, couple of things. Do you guys believe that Brad Holder or Anthony Neighbor-Gull may have been involved with Richard Allen as well?
No, I don't think so.
I don't think so either.
No, I don't think that they were involved.
Because I heard that those guys were are kind of sketchy as well, but I'm not sure.
Well, a lot of people say things about people that aren't necessarily can't be proven, or and stuff like that. People make up rumors and talk bad about people sometimes. So we can't determine whether that's just people talking bad about people because they don't like them, or if it's actually true. So we have to keep our minds open to think that they're not guilty, right, of anything unless they've been charged or convicted of some crime, and they haven't even been arrested. So
I read the filing. It said that the Richard Allen kidnapped the girls, and as a
Oh, you're breaking up, Chris.
are you there, buddy? I think you cut out, man. Hello? He's gone. Okay. You know what? Good questions, Chris. I'm not sure what was happening there. You got taken off there for somehow, or you got locked up or something like that. So they've issued an order. The new attorneys, the old attorneys are back on the case.
I didn't think it was going to happen today.
I didn't think it was going to happen today either, dude. They made a decision quick. They went in there and said, "We're getting this shit over with. Let's get it on."
Wow. Breaking news. Oh my God. Supreme Court comes back with decision within hours of arguments. Judge Gull remains on the case. Rozzi and Baldwin are back on for the defense.
Within 2 hours.
Oh my God.
Within 2 hours, the decision was
back on
made.
the case. No speedy trial, no order for speedy trial, but that doesn't mean that Rozzi and Baldwin can't now submit a request for speedy trial, which means we would have a trial within.
We might have it if okay.
OMG.
This is crazy, dude. This is blowing my mind here. I am.
We thought the charges being amended were the best thing for today. No, we're going to get a trial in 2024. That was fast.
I'm so relieved. This is part of it's over.
Oh. Let the motions and the hearings begin. You know it's going to happen.
Man, dude. That is such a good thing, dude.
We will get to read the findings, Honeybee. They'll be coming out. They have to release it, but it's going to take a little bit more time for that to happen.
Yep. It's going to take some more time.
No, that means they're in charge of his defense. They are reinstated.
Yeah, they're reinstated. That means they are the defense team again, and Scremin and Labrado are gone.
Miss Persevere says, I'm just saying, that's going to be a really awkward courtroom. Oh, you got that right.
Yes, you got it right.
So do you remember? Oh my God. So do you remember basically they were asking the questions of the attorneys this morning? What if we just let Rozzi and Baldwin come back in and then Judge Gull can do whatever she wants and have a hearing and exclude them the right way? Do you think that's a possibility?
Oh.
Remember,
Dude.
that's what they were questioning. The high justices were questioning that.
You know what? They did say that. They did say that. Well, what if we let them back on and then they actually go through the formal process then and then find out?
Oh
You
my
can't appeal
God.
it though. But you can't appeal it though, they said, because you already tried the writ.
Right.
Holy shit. Dude.
Oh my God.
This is nuts. I am trying to send this freaking document to Twitter.
And send it to me too, please.
Okay.
Oh my God. I wasn't even looking for a decision. I never even thought one would be coming today.
Dude, I know. Like, I never knew.
I am shocked.
Okay, so I'm sending to other creators right now.
Okay.
Documentation on the case.
I want to download this. Oh no, I don't want to. I want to download it and put it on the YouTube group. Or
dude,
the
what do you
Facebook
guys think? Yes, what do you guys think about this, dude? Like, what do you guys? Are you guys
I'm in
what do you guys
shock.
think? I'm in shock. Holy crap, dude. This is nuts.
I know that one High Justice Rush said that she wanted to get this back on track, but I didn't think it was going to be like within hours.
You know what? I didn't expect it to be within hours
God.
either. I'm trying to get someone to call in here so we can talk to him.
I have to go to the bathroom. I'm shocked.
No, you can't. You're not allowed to.
Oh my God.
Let's see.
I'm just dumbfounded. Anthony, I'm like,
dude, I know.
My God.
This all happened. This is a big day. So this has been a huge day, everybody. I'm like stunned at this. This case is absolutely nuts. I'm going to play a video. Okay. And then I think we're going to have a guest call in. Okay.
Oh, thank God.
Yeah. So I'm going to play a memorial, another memorial walk. Okay. For everybody, because today, man, I just want to remember Abby and Libby because this is a big day.
Yes.
I told everybody I'd be live all day. If you got to take breaks in between, that's fine. I will too. We'll just take turns. Because I want to continue talking about this all day. You know, I don't mind staying on the stream all day.
No, I agree. I agree.
This is really big news. We've had 7 hours.
We've been on the air 7 hours, 41 minutes. No big deal. We'll go another 4 or 5.
Dude, we're going to smash Zav Girl's record. It's over, Zav. Okay, it's over.
Oh my gosh.
Okay. Out. Let me go to this document. All right, here we go. So this is going to be a memorial walk video. It's not the best quality because I had to re-download it, but this was in 2021. And then whenever I have the individual that's coming into the video here in a minute, go to the video and it's in the I'm playing the video. All right, so we're gonna take a second to remember Abby and Libby, what this is all about, and we'll be right back.
Hang on, I got a phone call.
Sorry, I have to do it in this particular way. Give me just a moment. here's what I have to do. I have to share it in a different way. So I have to present a shared screen and then share it like that. So we're going to take a look at this, and we're going to remember the girls for just a minute, and we're going to think about we're just going to take a breath and think about everything. There's breaking news in the Delphi case. Today's been a long day. Mitch Westerman appears in court for leaking the crime scene photos of Abby and Libby. He has now been set for jury trial in March. Other hearings are coming up over the next 2 months for him. Also, yeah, no, I didn't want a speedy trial. I thought that there was not going to be a speedy trial. Richard Allen has new charges against him for intentional homicide. So he has 4 murder charges right now. We have the defense attorney, the Supreme Court hearing that was held earlier today where the oral arguments were heard. So the prosecutor filed new charges against Richard Allen. Then all of a sudden, we've got the Supreme Court deciding that the defense attorneys are reinstated. The judge is staying. So they're saying that everybody gets what they want. Everybody gets exactly what they want. And there's no speedy trial. Okay. Good luck with that. There's where we're at, ladies and gentlemen. So I'm going to go ahead and share a video. Let me pull this thing out and share this right here, ladies and gentlemen. So let me go ahead and pull this up and share it with you guys on right. Where are we at here? Media player. To share audio, share tap screen instead. There we go. Media player. All right. And can you guys see and hear this right here? Let me know if you guys can hear this, okay? No, you guys can't hear that? Okay, you guys cannot hear this? Okay, so then what I'll have to do is I'll have to do it like this. So let me go ahead and stop this share and reshare it like this for you guys. And we're going to do it like this, ladies and gentlemen. So entire screen, also share, and go like this. Let's do it, ladies and gentlemen. Let me mute myself. So what do you think about events like this? What can that do can it help the case? Can it hurt the case? What do you think?
It can only help the case. Like keep just raising the bar levels on it, they just get it more and more out there, because someone's got to know something. That's what I feel.
We freshened it up, put mulch down, and took out weeds. And I think the girls would be very proud of what we did today. Please add more stuff. That's always welcome. And enjoy the trails.
So I've probably been out here 50 to 60 times maybe.
Yeah.
And walked across that bridge, and I'll tell you what, everybody that comes out here is definitely scared to walk that bridge the first time.
Yeah, I see it. It's looking kind of, yeah.
Looking kind of scary.
Yep.
Right now we're at the historic Monon High Bridge, which is the area that Abby and Libby were. This is where they were last seen on February 13th, 2017. And it's an abandoned railroad bridge that sits 70 feet high and 853 feet long. So the greenery down at the end is actually covering up the end of the bridge, but it's a lot longer and higher than what it looks from here. I mean, once you step out on the bridge, you actually get a sense of how big this bridge is.
Please don't let me die.
I won't let you die.
I'm scared.
Are you scared?
Yes.
Ben, are you okay?
Yeah.
Stay towards the middle.
We're having a walk for Libby and Abby to remember.
Why do you do this thing? What does this do for the case? What do you think it helps with?
Hopefully it helps people come away. They can find clues to bring the killer, and somebody would know it's something, or that bringing awareness to this case faster.
So tell me a little bit about the bracelets and the koozies that you got today. How did you acquire those, and what did you do with those?
With a bracelet and a koozie, I got it from Becky today. I called her up and asked them for them, and so people can get them for free, and they can remind them what they did today.
What's up, YouTube? I'm Anthony Greeno here at the Monon High Bridge Trail, and I am with Ed Bounds from Crime Pursuit Podcast. Ed and I did a podcast on his channel, on his podcast, actually, a few months back called Delphi 4 Years Later. So if you haven't heard it yet, then go on there and check it out. You can also find him on YouTube and Facebook. So, Ed, tell me why you came out here today.
Well, it's been a couple of years since I've been out here, and, you know, I was hoping every time we come here, we find something that we might have overlooked. The very first time we came here, I brought a whole team here, and we did the whole area looking for ideas, how things could have played out. And, you know, it's not until you come here, you know, like you said, until you come here, it's different. You know, it's one thing seeing this on YouTube or TV or whatever, but to actually be right here, it's an experience.
It really is an experience. Now, when you first came here, I know you said you didn't cross the bridge. How far did you make it?
Well, if you look right out there where that big gap at, so, you know, most of my team, they stood back. Me and another person, it was Chad, and we and him got out there. He got right over the gap there. I got to the gap, and then all courage and the man left me. If that ain't never happened to you, you're a lie. So it was like a bear jumped up there, and it was like he said, "Go back that way or face me." So I chose to come this way. It was rough.
Are you going to cross it today?
No, not happening.
Not at all?
Black folks don't do that, bro. We don't do heights and stuff like that. That's and that's just my thing, because if something happened to me out here, and I got a big black family, they'll be like the friend, what the was he doing out there? That's what he get, you know what I mean? So I'm not gonna take no chance of crossing that bridge. I'm gonna die, but it won't be today on this bridge.
Yeah. So do you have a person of interest? I know that we've primarily discussed that on your show.
Yep.
Who is your person of interest? Is he still a person of interest? Has anything changed since the last time that we have spoken?
No. My stance, and I'm firm on, and I don't have a problem. I'm just saying, assuming, but my person of interest scares Kurt. And when we came out here years ago, what we noticed, as everybody that's out here, you only got 1, 2, 3 people's brave enough to go cross that bridge. Just any Joe Blow ain't gonna come out here and run across that bridge as fast with their hands in their pocket like the bridge guy did.
Right.
Bridge guy knows this bridge. He knows this area. He knew where he was at. He knew that he could cross that bridge without falling. Any Joe Blow is not going to go cross that bridge. I told my co-host, Angela, when we got here, I said, you'll see exactly what I'm talking about. When you get to that bridge, I don't care. And her favorite character is LL Cool J. And Anthony, I'm willing to bet if we put LL down at the end, she's going to say, well, can you fly me over there? She's not going to go down there.
Use the drone.
Yeah, she's going to have to catch a ride on the drone. But the thing is, if you want something bad enough, you're not going to go down something dangerous. The person that crossed this bridge, that followed two people who have crossed this bridge before, knows this bridge. He knows the area. And another thing, I know you said you believe the person was local. And in interviews with Garrett, he told several that this is local to him. This has been home to him. We know Ashley Garth stayed here. We know they was in a relationship. On our way through here, if I'm wanting to kill somebody, I'm going to take them out in here or wherever. I can push them down and he'll get rid of them. I'm not going to wait to get over there, cross a creek, and then get over to our property and then do it.
It makes you wonder why he did all that when he could have just done it at the end of the bridge or wherever.
He had the opportunity because I believe where the memorial at, he saw them coming in. He was sitting there at that bench. He saw them coming in, and he took trail 2 so they wouldn't see him following them on trail 1.
Right.
And he stood back and waited till those young ladies got more than halfway down. And from what we talked to people from Delphi, they said one of the rules here is when one person go cross and somebody else is coming, they don't cross at the same time like on the sidewalk.
Correct.
They wait till the person get down there, which made sense why Abby and Libby was waiting, because they're thinking, hey, this is just a guy hiking, waiting on him to get across.
Yeah.
And unfortunately, we know what happened when they waited for him to cross.
Yeah, ultimately, they got killed.
Yeah.
Yeah. So, I mean, and you mentioned Garrett as being a local person. We do know that he has ties to the Ron Logan property, which is literally just right over there. I mean, it's not far, everybody. The Ron Logan property is, if we just took this path here around, we would end up at the crime scene where Abby and Libby was actually found. I know that most people don't realize that you actually got to cross the bridge, go down a hill, down a second hill, which is on a private driveway, and then you have to go over towards the creek, and then you cross the creek, which is only about a 3 to 4 minute walk. And then they were left in the most isolated location on Ronald Logan's property. Now, in some of the video footage that I've previously filmed, you can actually see that area. But we could get to it if we went there, but it is considered trespassing, so we're not going to do that today. But Garrett Kurtz is familiar with that area, and he has actually said that.
Yes.
Okay.
Yes. And we found out that his dad introduced him to Ron Logan at a very early age. Garrett Kurtz was in the horses and stuff like that. Ron Logan owns horses. Garrett Kurtz was very good at helping Ron Logan with those horses. So he knew the horse barns. He knew the area. Ron Logan taught him how to survive just with a knife and just local survival skill right out here.
Yeah.
So that would let me know that this would be somebody that knows this area. Like, this is your area. You can take me places that I don't know nothing about. You can say, Ed, we got this going on here. We got that going on. I have to take your word because you're local. You know this area.
Right.
Just like if you come where I'm at, I know my area. This person knew the area. Now, I made another point. If you do this, if you go down this trail, which we sent somebody down there, and then we went double back out, and then we went to the graveyard and went down to Ron Logan's property.
Okay, yeah.
So if you do this whole thing, you will find out with stopping and breaking, you do about 2.5 hours. What was about 6:30 when the sheriff's department and them started searching?
Yep. Yeah.
They searched, they called the search off about midnight or whatever because of weather conditions.
Yes.
But the family remained still searching to 2 o'clock in the morning. We talked to some volunteers and everything. Nobody found nothing. They didn't find nothing. They was out here 2 o'clock in the morning, desperately looking for these girls.
So are you suggesting that they was moved?
No, I'm suggesting they was in the barn, in the horse barns. Nobody nobody knew where they was at.
Okay.
So I believe they was in the horse barns. I believe Garrett was out watching, looking. He could hear. It was in the fall. I mean, the winter with hardly no leaves. There was no leaves or nothing. He can see people. He can hear people out in the distance searching. I think what happened, he waited until everybody left, and then moved their bodies out there where they found them around Logan's property. Because if you think about it, he had 2 women to deal with. So figure, he just got them out as far as away from the horse barns as possible, and just get them there. Figure nobody would really question about where they was found. They were just found in some woods. So he thought that's how it would get questioned.
Right.
So my thing is, if as an ex-criminal, I'm not going to go uncharted waters, unfamiliar territory to kill 2 people.
Right.
I'm going to do what I got to do right then and there and get the hell out of here.
Yeah, you don't want to linger around
No.
either. If you're going to do a crime like that, you're not going to linger. You're going to get it done, leave, be gone, because you already know what the outcome is going to be.
Now, to make another point, when I said we did this whole walk, the whole thing, the next day, and you can verify this, what time did they find the girls? Around noon.
Around noon.
Okay. They started searching. They got everybody out here at a certain location around 8 or 9, and they had a list. They wanted people to sign with their name and addresses and stuff to find out who was all the volunteers that was going to be searching. That's why they wasn't able to get started till 10 a.m. When they got started, it was around 10 a.m., somewhere around there. I don't want nobody to say, well, you said exactly 10. Well, it was around that around that area. They started around 10. Guess what time they found them? Noon.
2 hours.
2 hours. So they were there, and numerous people. I don't know if anybody told you. I know people. Ed, that was searched.
Yeah.
That was searched that night. I promise you, Ed, it was searched.
Even ATVs, they said.
Yeah. So that's why I believe they was in the horse barns.
Okay.
So if they wasn't in the horse barn, it couldn't have been around Logan's house. His house sits far. When we went to his house,
It's too far up the hill.
Yeah,
it's up there pretty far.
Yeah. So somebody that knew them horse barns and was comfortable and knew that nobody wasn't going to be there. That's just my take on it.
Tell the viewers here how they can find your social media and all that stuff.
Well, we're on YouTube like you are, but we're mainly a podcast. We're on anywhere you get your podcasts, Spotify, Google, Apple. We're everywhere. Wherever you listen to podcasts, Crime Pursuit Podcast is there.
And are we going to be doing another podcast?
Oh, yeah. Yeah, we're going to be definitely doing another podcast because I want to talk about the new suspect that people think is a suspect.
James Brian Chadwell II.
Yeah. So, me and you, we need to chop that up. And I know you covered a lot about that. And who better to talk to about that?
We can do it, man.
Exactly.
Anytime.
Exactly.
Hey, dude.
All right.
Great to meet you.
All right. You too, Anthony.
All right, man. Ed's got some great points. Do I believe it's Garrett Kurtz? No. And he knows that. And everybody knows that. Do I have a suspect in this case? Absolutely not. I don't have a suspect in this case. I believe that the person that we're looking for is someone that nobody really suspects. It's going to be that person that you just think is a nice guy. And I just don't feel that it's a criminal. I think that it's the guy hiding in plain sight that's right there in front of us. You never know. Maybe he shows up to some of these things sometimes and we wouldn't even know it. So I want to say thanks, everybody, for joining us today here on True Crime Investigates. I want to say thanks to Randy Gravitt for hosting this event again today. And I want to say thank you to all the viewers and everybody that showed up here today. So on that note, everybody, I'm Anthony Greeno here at True Crime Investigates. Keep it Southern style, y'all.
All right, go ahead and remove that and pull in Marv. And
I'm
so I
still
wanted to say,
shocked.
I'm very shocked at what's going on here. So, ladies and gentlemen, if you saw in that video, Ed Bounds, he was a true crime podcaster for a while, and he disappeared for a minute, but he's been back, and he's on Facebook. And right now, ladies and gentlemen, we're going to bring in Ed Bounds to give him an update on what's going on in Delphi, because he does a lot of his own thing, and so sometimes people can't keep up to date, but I share everything I can with Ed, and like he shares things back if he hears it back with me. So, ladies and gentlemen, this right here is Ed Bounds.
Welcome.
Welcome,
Hey.
Ed. What's going on, man?
Thank you. Yeah, I'm sitting up here and I'm watching the news. As you can see, I'm in the studio, and they've been talking about the Delphi case off and on. I've been waiting for the new updates, and I got on the phone and started running my mouth, and was in a long conversation, and just had hung up. And I had the TV on mute, and then when me and you connected, um, I'm at loss right now. What's going on? So I don't know the new update that's going on.
So here's what happened
Okay.
today, man. So they had today the man who leaked the crime scene photos, Mitch Westerman, first thing this morning, went to court for conversion for leaking those photos. Okay. And his case is set for jury trial. But then following that at 11 o'clock this morning on Eastern time, the attorneys for Delphi suspect Richard Allen were going against the judge who's presiding over the case. They want the judge kicked off. The judge kicked them off and hired new attorneys at her own, and they wanted a speedy trial. They wanted the judge kicked off, and they wanted the Baldwin and Rozzi reinstated. The Supreme Court heard oral arguments this morning. We watched it. It took about an hour for the hearing, a little over an hour, probably about an hour and a half for the hearing. 2 hours later, we have a written order from the Supreme Court where they've reinstated the attorneys for Richard Allen of Baldwin and Rozzi, got rid of his new attorneys, and set the what else did they do? They kept the judge too.
Judge Gull stays. Rozzi and Baldwin are reinstated, and there was no order for a speedy trial.
And Richard Allen, was charged with 2 more counts of murder. 4 counts
that
of
down on my little thing down here on my computer, where I'm getting a message that he was given 2 more additional charges.
Yes.
murder. 2 murder charges. Now, this is also a question. Could this also mean that there's 2 more victims, or are we assuming they're the same ones and they're going to take off the other charges?
Well, I'm assuming it's the same ones. And the reason why I'm saying that is I think they're trying to get it right before they have to be forced to make it right. You don't want to give this guy anything to come back on appeal. And I think they're trying to get it right. My question to you guys is, where are they trying the case at?
Allen County.
Okay, in Fort Wayne?
Well, no. So
No,
okay.
it's supposed to
I'm
be
sorry.
in Delphi.
It's in Carroll County.
It's gonna be in Delphi, but they're bringing jurors in from another location.
From Allen County.
That's what I thought. I didn't know. I know one of my producers from my podcast had mentioned that she thought it was being tried somewhere else, and I told her, I said, I know that there's going to be a different jury that's not from there, but I didn't know if it was going to be tried there in Carroll County, or was it going to be tried somewhere else. It's been so many twists and turns with this case. It's just, it's crazy to keep up with it.
Dude,
Yeah.
everything. It's been, it's been since first thing this morning. It's been going on and on and on, and there's just not been a dead moment in this case whatsoever. Today, there has been constantly updates, all provided throughout the day from in courtrooms, outside of courtrooms, Twitter, YouTube, and social media, news updates that we're following. We are to a point in the Delphi case where now the judge reset their case on the new attorney's motion for trial in October of this year. So they pushed it way back. Well, the judge or the attorneys are actually probably going to want to move for a speedy trial. So I think that we're going to have a trial for Richard Allen within the next, I'm going to predict, 6 months.
If not sooner.
If not sooner, man. We may see one within a couple months.
Yeah, I agree.
Let me ask you a question. Are you going to go to it if it happens?
Yes, we are going. My executive producer, Angela had said, my co-host, that she wanted to go. And so then my executive producer said today that she would really, really like to go. And so I gave both of the girls my word that I would take them to Carroll County and we would go to the trial. So yes, we will be there if God save the same.
Okay, that is good, dude. Have you been back to Delphi since that day we went?
No, well, Anthony, I was a little emotional seeing that video because right after doing that interview with you, it was just a couple months and my life changed significantly.
Yeah.
When I got sick and I was in the hospital for 5 months. And so,
In a coma?
Yes, in a coma for 2 months. I had to learn how to walk again. I spent 5.5 months inside the hospital, having to learn how to walk again, feed myself, all that. And so, when I saw that video, that was the good me. That's when, my feet was in perfect shape. That's when I didn't have heart problems. That's when I didn't have lung problems and everything else. And so that video was like, wow, I missed that old guy.
That was a good time, dude. That was really good to meet you. I remember reaching out to you saying, hey, man, we're doing a memorial walk. This would be a good time for us to collaborate on something. And we did that Delphi 4 years later thing that year, too. So it was kind of like a double up on that. Dude, so you and I talk behind the scenes and stuff like that about this stuff. What about, have you seen the pro Richard Allen people?
You know what? So I had been, well, actually, somebody that I talked to that's in law enforcement had talked to me about that and told me. And then I know somebody else that's, well, they're in probation, and she was sympathetic with him. And I'm like, what the fuck? And I set my cup of coffee down, and I said, wait a minute, sympathetic? Did I hear you right? And she says, well, yeah, he lost a lot of weight. He looks scared and all that. And that ties in to my law enforcement buddy telling me about these pro Richard Allen people. And listen, man, if you don't mind, I want to go on a little rant. Okay,
yeah.
Know me. Ma'am, excuse my language. I know you probably don't know, but I don't bite my tongue. I say what I have to get off my mind. I want to say to the pro Richard Allen people, you know what? Shut the fuck up. Because first of all, that's somebody's kids that was found brutally murdered. I don't feel sorry for this man, nor will I feel sorry for him. Let me tell you, as an ex-criminal, here's the bottom line. You commit a crime, you deal with the consequences that come with it. And just like I used to tell my kids, you ask for rain, be willing to deal with the mud that comes with it. And the whole thing is, this man is accused, and look like the state have overwhelming evidence to say he's the one that did it. And so I've been seeing where people was, oh, well, they're moving him around. He don't like it here. Well, where the fuck he want to go? To a country club? Do he want us to deliver him lobster and shrimp and steak? What else do he do? He want fucking Papa John's pizza? Do we deliver him a case of Coke? People, he is accused of murdering 2 teenage girls. Okay? And that's the bottom line. The Indiana Department of Correction system, I have never seen them protect and move around a person like they have moved him around. He went to Westville. Now, I understand them not having taken him out of Westville because Westville is 85%, 90% black ran and black offenders in that prison.
That's what I say all the time. I'm like, you're not safe there, especially for a white nationalist organization.
Well, white guy is not safe in Westville. So I understood that, okay? But then they moving to another facility. Oh, well, it's harsh here, and it's this and that, playing the fucking violin. and then he's down there. I guess he's at Wabash Valley. Let me tell you, prison is not a pleasant place. Okay,
No.
it is not a pleasant place. It was not meant to be a pleasant place. Okay, it is meant that way just so you can go serve out your punishment and say, look around, this place sucks, and
Yeah.
I'm not committing no more crimes and coming back here. Okay, prison is designed for punishment.
Okay, so what about the people who are going to say? What about people who are going to say, well, he's not convicted yet. He's
Okay,
innocent.
okay.
Why
So
isn't he in a county jail? Right?
yeah, so well, they bitched about the county jail he was in.
Yeah.
You know, when they put you up for safekeeping in the state of Indiana, they put you in the Department of Corrections.
hmm
Okay. Now, let me tell you something. I was incarcerated as a pretrial detainee, where I couldn't bond out. Do you think the jail staff treated me differently because I hadn't went to court yet?
No, you're
You
treated
are
the same.
still accused. You are still accused. And so the bottom line is this man is accused for murdering two young ladies, two young girls. And so, you know, even let's say if it's possible that he could be innocent. Well, you know what? It sucks. It sucks to suck. Okay. But unfortunately, we got a lot of innocent people that went through the system and they had to do the time and everything. They didn't get special treatment. No one gets special treatment when you are accused or convicted of a crime.
Exactly. You don't. You
Yeah.
don't get any special. You're all treated like crap. He
Yes.
didn't go through anything I didn't go through.
No, and the whole thing is we got murderers coming through the system every day. How do you feel about them? You know, so the people that defends this man, these are the liberals that fucking say, oh, well, let them all out. You know what? I tell you what, let's let all the murderers out. Let's buy them fucking ice cream and brownies and fucking take them to Dairy Queen and just let them run the streets. You know, that is just the stupidest thing to have talking about, oh, well, I have compassion and he looks like he's lost weight and he looks like he's stressed. So fucking what? He needs
Yeah.
to look like he lost sleep because I believe that Carroll County they got their man. You know, I really do. You know, Anthony, I told you I thought it was Garrett Kurtz. And, you know, I was wrong. Law enforcement knows they got it right. I had it wrong. And so it's time to get behind what law enforcement has presented. And so I believe that there's enough evidence from what I see that they have their man. And so I just cannot believe the people that started to defend this guy. And when you have talk shows like this, you need to appreciate these YouTube channels because without them, police, law enforcement, whatever, they put those cold cases to the back
Yeah.
because they got other cases they got to worry about. Then you have somebody like True Crime Investigates who comes along and bring life back into that case and then get people talking about new evidence pop up and stuff like that. You have to appreciate shows like this that come on because without these shows, these cold cases go colder. And that's just the bottom line. So I appreciate all the YouTube channels, the YouTubers that has their own shows that take the time out of their personal time to present a show to help victims get their voices heard. And the thing that chaps my ass is when you got a troll or somebody got something negative to say or got something to say, let me tell you fucking troll something. And all because I dealt with you when I had crime pursuit.
Yeah.
Get you a hobby. Go buy you a fucking puppy or something and quit being miserable. And let these people do their job and just wait and see what plays out. The bottom line is 2 parents are without their daughters. And they're never coming back. They were minding their own business on that bridge. And we should be supporting justice for Abby and Libby at the end of the day.
Absolutely.
I agree. You know what, Ed? You couldn't said it better, really.
Yeah, well, you know me, Anthony. I'm sorry. I don't bite my tongue. For people that don't know me, I have my own podcast called Ed Bounds Live After Dark. It's only on Facebook, and on my show, Anthony, I don't bite my tongue, and I don't care about anybody trying to come attack my page or trying to do anything. That's what I got lawyers for, and we make enough money to, because the thing what people don't understand with digital technology, your phone or your device leaves a trace of who you are. You done logged into a personal email, or you doing some banking on that phone or something, and you're using it to harass. It's called harassing communications. And now that you're making a federal offense because so many people are doing it from other states or whatever. So you can find the people that do stuff like this, because Facebook and YouTube keeps you can delete stuff and they can go pull it back up. People don't know that.
Yeah.
And they go and get that little whatever, bring it up, saw what you said, saw what you did, and now they turn it over to law enforcement or turn it over to an attorney who got the order from the judge to get it. So when I'm gonna let y'all know, y'all can try to contact me if you want to for my views and my opinion, but I can assure you I will tell you fuck yourself, and I'll let my lawyer handle you, and I'll laugh at you in court while I watch your car and your camper and everything, because I'm trying to take everything you have. If I got to pay this man money to take you to court, best believe I'm trying to take everything you got. And look at the law in Indiana. I can and will do it.
Yeah.
Exactly. Hey, man, dude, thanks for giving us input and stuff like that and letting us know and like listening to the update and kind of just being updated and being interested in the case and, doing everything that you've done to raise awareness as well for Abby and Libby.
And thank you for having me, man. And you and this young lady here, I want to say I appreciate both of you guys, what you're doing. Anthony, you do this day and night. I mean, man, you be up 2 or 3 o'clock in the morning. We'll be, texting back and forth, and you're working on something. You're looking into a case, and you're trying to do this, and you're trying to. And people don't realize how hard you go, and I know it. That's why I only listen to your channel, because I know how hard you go for these victims. People don't realize the shit you do for these victims and their families.
All the work.
It's a lot. It's a lot of work.
My hats is off to both of you, and thank you for having me on.
You're welcome. Thank you for coming.
Thanks, Ed. Just go follow Ed Bounds, everybody, and check this video out real quick, everybody. Yeah, like that.
What up, Facebook? You are about to enter the most dangerous podcast on the planet. This is Ed Bounds Live After Dark.
Hey guys, it's Angela, here with my 2 cents.
Hey, what's happening, y'all? This is Ed Bounds, a.k.a. Petty Eddie. You know, people say they're the hottest podcast in the city. What do you say? A lot of people say it, though.
This is Live. After dark. No one is safe, and I mean no one.
Oh, I love it.
How do you like it? So that's Ed Bound's intro.
Yes,
Love
yes.
it.
Come to the Facebook page, Ed Bounds Live Podcast. But the show is is produced by Ed Bounds Live Podcast. Brooke McCall is executive producer, and it's called Ed Bounds Live After Dark. Come check us out. We are hilarious.
Absolutely.
I'm going to post a link for you, Ed, on here, okay? That way you
All
got
right,
it. So,
and I appreciate that, Anthony.
all right, brother, man. Thanks for joining us today.
All right, y'all have a good evening.
All right, man. Later.
Tina, yes, I did look on my case. Nothing's been updated on there yet. So
Yeah, nothing's been updated.
I'm sure they're working on it.
Exactly.
Wow.
Wow, dude, breaking news all day long. There's Ed Bounds right
All
there,
day.
Facebook. Ed Bounds Live. There you go, everybody. So go follow Ed on Facebook. Like he said, he's unfiltered, uncut, unfiltered, bringing the truth, politics, relationships, crime, whatever it is. He's talking about it. Go subscribe.
And while we're in the middle of that, I just want to say, Sir Lopez, thank you so much for your super chat. And keeping eyes peeled. Thank you so much.
Thank you. We greatly appreciate those super chats and the donations and PayPals or Cash Apps, whatever you guys want to do. We greatly appreciate that.
And we apologize. We've hit the 8-hour mark on Facebook, so the stream is no longer working.
I
hope everybody
noticed
knows
that.
we're still on, and to come here, but
Yes.
so we're still here.
We're still here, everybody. We're still here, and I mean, this is really cool. You're welcome to call in, people. I have the link pinned in the top of my chat. I'll drop it again here for you guys in the comment section. You guys call in, let us know what you think about what's
I'm
going on.
dropping it right now.
We've had a bunch of updates today, and like Zav Girl when she was live on Savannah Soto and Matthew Guerrera. While she's live, breaking news, arrest happens. Then this happens, a new arrest happens while she's live, and it's like, how do you get? It's like, whoa, dude, why we've been live today? And other creators messaged me, said, man, we were live stream all day for 6 hours, and then all of a sudden ended it, and 20 seconds later, the Supreme Court issues a ruling. Or 6 minutes later, or something like that, the Supreme Court issues a ruling. It's like, okay, got to go back live again.
Yeah, we just kept going live. We didn't end.
Didn't end
We're
because
still
I just
live.
knew today was going to be a day.
Wow.
So what's happened today, Marv? Do we have a list of things that's happened today?
We do.
In order, run us down on a chronological case summary of today's happenings.
Okay, Mitch Westerman had his hearing. He's going to have 2 more hearings, a regular hearing and then a final pre-trial hearing in March.
Yep.
So that's Mitch Westerman. We all know that he's the one that leaked the crime scene photos.
Yep.
Then, oh my God, then we had the Supreme Court hearing for Delphi for Richard Allen. Lasted a little over an hour, about an hour and 20 minutes, I believe. That was awesome to see firsthand. If you didn't get to see that, rewind the video and watch it. You're going to get a perspective that you've never seen in the court system before.
Exactly. It's really good.
We get done with that. We're talking about all that. And all of a sudden, new charges come in for Richard Allen.
Yep.
Holy moly.
And they charged him with what now? What's his charges now?
Okay, so I have to...
Intentional homicide. That's
intentional
what it is.
homicide with kidnapping.
And the other 2. Yes.
Right. So now you have chapter 35, 42, 1-1-1, knowingly or intentionally slays another human being, and number 2 slays another human being while committing or attempting to commit, and in this case, it's going to be kidnapping.
Mhm. All of the 3 down do not
Do
apply.
not apply.
Yep. Only sections 1 and 2. Those are 2 charges that he's being filed. 4, actually. 4 charges. 1 for each one of them. Then what happens?
Then we're just getting through that and we're like, oh my goodness. And then we get the decision has been made in less than 2.5 hours from the Supreme Court.
The Supreme Court made a decision.
Judge Gull remains on the case. Rozzi and Baldwin are back on the case. Does this mean that Judge Gull can now have a hearing to disqualify Baldwin and Rozzi like they said in the Supreme Court hearing? I believe that is a possibility.
That they could have that hearing just to do that.
Yes.
So the new defense attorneys are back on the case. Or the old defense attorneys are back on the case, not the new ones. Sorry, I misworded that.
So now we're waiting for the official information from the Supreme Court to come out stating why they made the decision. That's going to tell us more.
Why they made the decision.
Holy moly.
I'm trying to pull up that document. I don't know why it's not in here anymore. I thought I put it in the thing, but I guess I didn't.
Which one?
The Supreme Court ruling. We had it on the screen earlier. I don't know what happened to it.
What do I put it under?
Those overlays.
Overlay, right?
Mm-hmm.
Okay.
There we go. Yeah. All right. So yeah. So we'll show you that order by the There it is. I see it. All right. By the Indiana Supreme Court, ordered today at less than an hour and a half. About less than 2 hours. Probably closer to an hour and a half to 2 hours.
Yeah.
On the case, and they agreed to keep the judge.
Judge stays.
The judge stays.
Will she take herself off of some cases due to her new position? That's the biggest question.
Yeah, I would assume she probably would. I mean, I don't know. So how that works is they typically assign those cases to other judges,
right,
to kind of lighten the caseload. They kind of divide it up in between those different judges in those courthouses to try to lighten the caseload when something like that happens. Since she is the chief judge now in Allen County, I think that she can have the say so on she's kind of like the boss of the other judges.
Right. So is she going to keep some of her cases, or she's a special judge that was chosen? So is she going to choose another special judge to take over?
No, she can't do that.
Who would choose?
Only the higher court, the Supreme Court, could do that. The governor would appoint a new judge. Actually, that's who does that.
Okay.
The governor of Indiana would do that.
So if Judge Gull chooses to remove herself from the case,
then the governor will appoint another judge.
Okay. I'm almost wondering if that isn't I don't know. She might. I don't know. All I know is it's going to be awkward at that courthouse.
So let me ask you a question. Are you glad that they got reinstated?
I am, in the fact that a trial will happen this year, and we don't have to wait another year.
I hope they're ready for this.
They all better be ready.
I worry that, now I feel more confident that Nick's in a better place, McClellan, with his filing of intentional. I think that they may have a connection that we're not all aware about yet.
Yeah.
Jeez. Does anybody want to call in and tell us what you guys think about this hearing, or if you have any questions about what happened today, if you missed it, call in and ask. We'll kind of run you down on it. Yeah, so he's got new charges, and the attorneys are back on. So I wonder what those attorneys are going to say now.
Oh my goodness.
I mean, they're going to be pissed, dude. You know what I mean? It's almost like, do you think that now dude, what if he is like, oh yeah, way to go, dudes. Yeah, that really helped, didn't it? You guys went in there and pissed off the prosecutor, and that dude filed more charges on me.
Yeah.
Thanks. You know what I mean? Like, your guys' shenanigans.
What do you mean by all 9 pages?
Do you have? No, we don't have all 9 pages of the amended filing documents. But let me see if we can get them.
No, the attorneys are back on. They are reinstated as the public defender. They are the public defenders. Can you send them to me, Andrea, please? I'm still in shock.
I'm still in shock too.
From everything that's happened today.
Indiana Supreme Court order.
I'm just like, oh my God.
Orders appointing judges.
Thank you so much, Misty Free Spirit. We love your support. Thank you.
Order, let's see. This court will promptly issue a written opinion explaining its reasons.
That's what I'm kind of waiting for.
I keep looking for it now. I'm looking for it right now, and I'm not seeing it. So, yeah, I'm not seeing it at all.
All right, I'll have to see what Andrea is going to send me.
Okay, and I'm reading something else. I'm just trying to see.
ATS, it is a lot to process. Wow.
Well, you're telling me, dude.
I was saying I was hoping for a decision by Wednesday. He was saying it's going to be weeks. Neither one of us thought it would be today.
Oh, yeah. I never thought it would be today. I said weeks.
Okay.
Yeah, weeks is what I thought. Let me see here. Take that thing off. Do what?
I'm flabbergasted.
At the rulings for today, right?
Yes. I never ever expected it to come in already.
Man, I keep looking for it, everybody. It's not there. Other orders appointing judges, disciplinary actions, approving local rules. There's nothing else there besides that one order. So they haven't issued a conclusion. I'm looking for it. We're going to see if we can find it one way or the other. Yep, to be reinstated. There's all sorts of news articles covering it now. Supreme Court heard arguments surrounding Delphi. I wonder if there's any... I don't have it
yet, Andrea.
I wonder if there's any interviews today.
We do know that Becky Patty was going.
She was there.
Legacy investigation says at Beyond the Evidence, just FYI, the stage area is blipping on me. So I'm excited. It was doubling both yours and Greeno's voice.
Oh, I gotcha. Man, I'm sitting here just looking at video footage of, today and everything, of all the people that were there and stuff like that. It's pretty interesting. The full hearing, there it is. All right, let me get this.
Oh my God.
Let me go ahead and pull up this whole thing here from everybody. All right, so what I'm doing right now, ladies and gentlemen, is I am downloading the full hearing from my thing. And we're going to go from there. What?
Miracle Hearts, thank you so much for the
Oh,
super
thank you very
sticker.
much.
We appreciate it. Is this me or is this you? Oh, no,
What?
that's me. Okay.
Is what me?
I got it. I'm on the screen.
On what screen? Oh,
On our
there it is. Okay, so what is that?
So this is Carroll Circuit Court, January 13th, 2024. Okay, that's just the cover page. Here we go. Count 1. Slayings.
Okay.
You know what word I mean. Nicholas C. McLeland, being first duly sworn upon his oath, says that on or about February 13th, 2017, in the county of Carroll, the state of Indiana, Richard M. Allen did kill another human being, to wit, victim 1, while committing or attempting to commit kidnapping. All of which is contrary to the form of the statute in which case is made and provided, gives us the case numbers, and against the peace and dignity of the state of Indiana. Scroll down. Count 2. Same thing. Did kill another human being, to wit, victim 2, while committing or attempting to commit kidnapping. Count 3. Nicholas C. McLeland, being fully duly sworn upon his oath, says that on or about February 13th, 2017, in the county of Carroll, the state of Indiana, Richard M. Allen did knowingly or intentionally kill another human being, to wit, victim 1. Count 4.
Wait, go back. Go back. Stop. Go back down. Yeah, read that one again. Count 3.
Nicholas C. McLeland.
Hold on. Okay, that's one. Okay, that's victim 1. Okay, now go down to the other one. The next one. Sorry, go to count 4. I'm sorry. I think I might have seen something that I'm very curious about.
Same information, but for victim 2.
Hold on. Hold on. Let me type something in real quick, okay? Don't change it from that. I want you to read me that, or I'm going to look something up real quick, okay? While we're looking at that document. So all I need is 3541 2-4. 3541 2-4.
This part says, all of which is contrary to the form of the statute in such cases made and provided, to wit, 3542 1-1 and 1C, and then 3541 2-4, and against the peace of dignity of the state of Indiana.
Huh? This is so odd. Okay, so do you see that one? Okay, wait a minute. Let me see that one again. 34-C 2-1. Okay, you see how it says 3542 1-1, 3541 2-4.
Yes.
Okay, and then that's on victim 2, and then go up to the other one.
It's the same thing.
It's the same right there, 4-2
Yep.
and 1. Okay, now go up to the other counts above that one.
Same thing.
So murder. How does he have 4 counts of murder?
they're putting 2 different murder counts against him for each victim.
They must be dismissing the other ones.
No.
That's what they're doing. Yeah, they're going to have to. They can't charge
No,
him
they're
double
not.
They can't charge him with that's the double jeopardy.
It's for the jury to decide which
Not
count.
on that. He would be charged. He would be going to trial on the same thing twice. He can't do that. You know what I mean? They can't try him on murder and then try him again for the same murder. You see what I'm saying? What they're going to do is they're amending the charges. They're not just adding them. So they're going to take the old charges, get rid of them, and put on this new charges. I think.
Now wait, there's a count 5.
What is it?
Kidnapping.
Okay.
A level 3 felony. 3542-3-2A and LC 35-42-32B and 3541-2-4. Nicholas McClellan, being duly sworn upon his oath, says that on or about February 13th, 2017, in the county of Carroll, the state of Indiana, Richard M. Allen, while armed with a deadly weapon, to wit, handgun, did knowingly or intentionally remove victim 1 by fraud, enticement, force, or threat of force from one place, to wit, the Monon High Bridge, to another place, to wit, a wooden area. And then you have a count 6 for victim 2 of the same exact thing. So now instead of 2 charges, he has 6 charges.
Dude, this is crazy. He has 6 charges now. And one of his charges is this, and I'm going to post it in our banners here and put it up on the screen. So check this out. So when I look that up, that subsection right here, it shows up on the screen. So 3541-2-4 is aiding, inducing, or causing an offense. Universal citation, Indiana Code 3541-2-4. A person who knowingly or intentionally aids, induces, or causes another person to commit an offense. Right? Which it doesn't make any sense. Okay, so if he's causing them to commit an offense, okay, which is contrary to law, that is a what would you call that? That would be he's not aiding it, he's aiding in causing the death of them.
Right.
You know what I mean?
So is there a second person?
No. Nope, not with intentional. They're saying that he took him down the hill, he did all that, he's the bridge guy, and he killed him, and he's the only one involved, is what they're saying now.
Yeah.
I think they finally got over that hump of this thing. Or if they just can't prove it, they're just going to go ahead and stick it to him. You're either going to talk now or you're going to get this. So do the new charges buy them more time? The state?
No.
Probably not. I mean, the defense has ample time. Right now, trial is scheduled for, you see, this is why McClellan filed that stay. Before all that. Now they can't do anything about it. They can't change it because it was filed before the Supreme Court order came out, right?
Yep.
So he's charged with murder.
The trial's coming.
And murder with kidnapping.
Yes.
And straight kidnapping.
Yes.
Okay. So if they can prove he kidnapped them and they died, he'll get felony murder. If they can prove he kidnapped them, they died, and he's the one that did it, then he'll get the felony, the murder charge. Yes, the defense attorneys are back on. Rozzi and Baldwin are back on. The judge is still on. And there's no speedy trial order. And Allen has 2 new updated murder charges. Currently has 4 murder charges at this time.
4 murder charges and 2 kidnapping.
And 2 kidnapping. He has 6 charges now.
Yes.
I'm surprised we don't see anything related in a sexual manner. After all this time, I still don't understand. If it wasn't, then that is such an odd crime scene.
Yeah.
You know what I mean? If it wasn't that kind of a crime, then it was an odd crime scene for that, I think. Some people think there's more people involved, and that's perfectly fine if you guys think that.
I still think there's more people involved.
Who, though? Well, why wouldn't he tell? You gonna go down like that, or are you gonna tell?
No, he's
No.
not gonna tell. He's gonna go down for it to protect his wife and daughter.
To protect who's gonna go down? Richard Allen to protect them? I mean,
Richard
he's
Allen
not. I mean,
is gonna take the fall so that he can protect his wife and daughter from anyone else involved. He is not going to tell on them.
No. He didn't cause another person to commit a crime. He aided and induced in causing their death by committing the crime.
I know, but I'm telling you.
No. I was answering someone in the chat.
Oh.
Honeybee, I was saying, no. We're not saying he aided and induced somebody else.
Look at this.
What?
I want you to look at this. Witnesses. Kathy Allen. Betsy Blair. Stephen Buckley. Sarah Carbaugh.
Mm-hmm.
Who's Matthew Clemens? Who's Jeremy Clinton? Dan Doolin. We know him.
Mm-hmm.
Who's Josh Edwards? We know Kelsey German. Who's Jay Harper?
I know Jay. He's a cop.
Who's Brian Harshman?
Cop.
Jerry Holman. William Coffers.
I don't know who that is.
Tony Liggett, police
These
officer.
must be cops, some of them.
Wesley McWhirter.
I don't know who that is.
Stephen Mullen.
Oh, Steve Mullen. Yep.
Steve Mullen. Okay.
Yep. Those are cops, I think. Cop. Or those are cops.
AJ Smith.
Don't know who that is.
AS.
Yeah. Don't know who that is either.
RV.
Wait, that would be Riley Voorhees.
BW.
Wilbur.
Bree Wilbur.
Yep.
Terry Wilson.
Terry Wilson, the one who drove down the road. Gotcha. Terry Wilson, everybody.
That is a much bigger list than there was before. I'm telling you.
Okay. Then that means they have more evidence.
Yeah.
That's all that means. Yep. They got more evidence now. So they have more evidence that they're willing to present.
Yeah.
That's what it is. More testimony, more evidence. I like this. This is interesting. This has got me, I'm just stuck here. You know what I mean? Thinking about this. Like, how is this going to impact the case going forward now?
I know.
What's going to happen? I mean, are we going to, what's going to happen? That's just all I'm curious about. How does this, is this good for the case? Is this going to be bad? What's going to happen next time?
This is going to be good for the case.
It is? Don't you think it's going to cause an uproar on social media and the media outlets and make it even harder?
Oh, it's going to cause an uproar in that. But for the actual case and the trial, it's going to be a lot better.
Okay. Well, I hope so. I would really hope so, because I'm sick of
I sent that to you, by the way.
All this drama stuff. Send what to me?
That document. It's in an email format.
Okay.
It's copied in there, so we'll have to snip it and put it in our files.
Okay. I am
6 charges. He went from 2 to 6.
Gotcha. 2 to 6, ladies and gentlemen. 2 to 6 charges, just like that. That's nuts. Now,
Now
what do
what
you think?
happened?
What do you think he's feeling?
If it were me, I would be shitting a brick and panicking. The first 2 were bad enough. But now 4 more charges?
Yeah.
Yes, Andrea, if we could get it, that would be great.
Yeah, that'd be cool. So that question that I had right there, what do you guys think? Guilty or framed?
Guilty.
Guilty. As my opinion at this time, based on everything that I have seen, no. Based on, and I don't have all the evidence. But if I was to lean one side or the next at this time, it would be guilty.
Okay, that would be great, Andrea, if you would put them right on the Facebook page.
Put them right on that Facebook page.
And if you could share the link to it in the chat too, I would appreciate it. Guilty.
Okay. Guilty. A lot of people are saying guilty here. I'm going to pull up something while we're sitting here and check it out, everybody. You want to watch some of it again? Sure, everybody.
Good morning.
Up to you.
Welcome.
This is the whole hearing.
I need about 5 minutes.
Go ahead. You know what?
Because my daughter's going to be leaving, so I need about 5 minutes. 10 minutes, if that's okay.
All right. So here's what you should do. Okay. So, can you control that thing right there?
Yeah.
You can control the video?
Yeah.
Okay. I'll step out too, and I'll watch it from my phone. And then
This morning,
you guys can watch the Supreme Court hearing and get updated with that as we take a break.
There you go.
All right. So you guys get updated on the Supreme Court hearing. This is what happened today in the Delphi murders case. If you guys want to listen to the arguments and what they talked about, because we're still going to get a ruling from the Supreme Court on a brief conclusion.
Right. Why they decided the way they did.
We expect that later today, I expect. Within a couple hours. All right. We'll be back, everybody.
Case of State, ex-rel Richard Allen, relator, versus Carroll Circuit Court and the Honorable Fran M. Gull, respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnicke. Good morning, Ms. Winnicke, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and counsel. Counsels, we've been conducting oral arguments. You'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that the court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review, this implying the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of the court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion that the trial court judge has.
There's an absolute duty to follow the client's wishes, and when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record that had preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But, Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rozzi and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with a senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rozzi on that case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve...
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed relationships with.
Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you
They're saying that his counsel may be constitutionally ineffective.
suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regard to the disclosure of the Westerman material. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride
I'm
behind
asking you
these
to tell
lawyers.
us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under the court's case law. You bring the defendant into chambers, and you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interest, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel.
To wit doesn't mean to wit someone. It just means to which. It's a legal term to saying to which this is who. To which Abby Williams, or to which this charge. To wit on this date. That's what that means.
If and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counselor, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all, and in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
yes, Judge.
That's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rozzi, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think we would have had a full record even then, Judge. The judge was saying that there was the coercive action of the judge. I'm going to go out there and I'm going to say these things, and Mr. Rozzi presses at her. Well, what's that proceeding going to be? And the culmination of it that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think I don't think those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
My
Amendment
concern is getting
requires.
this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
A lot of events in this case that led up to that hearing, correct, with regard to sending
I want people to pay attention to this. Pay attention to this.
information on a case to another criminal defendant with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery.
The Supreme Court justice is acknowledging the fact that there's been some shady stuff going on the defense's part. So just wanted to bring that up and point that out.
Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland effective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation, because one is the lawyer's not being a lawyer at that point. They're
not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme.
No, they can't. They can't make a motion to have the judge removed now. They already did that. That's exactly what this motion was about. That's over. The Supreme Court ruled on that. Once they rule on that, that's it. And they issued it. They issued a ruling on that already. So they won't change it. That disposition is final.
misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, was literally going behind the scenes, talking to co-defendants who are represented, trying to manipulate their testimony, the judge at that point just proceeds forward the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea, because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, and other than that one rare exception.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't. It depends on what record the court would build regarding those. No, I'm going to change that, Justice. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity, and somehow establish that that might be affecting his trial, and that fully and fairly advise him that's a repercussion. But if when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it.
Well,
So
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge, or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did...
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that that would constitute ineffective assistance of counsel for a Sixth Amendment violation, so if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason, that there's an intimate relationship going on. And she pulls them in, goes into the chambers and said, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance to counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, in that case, it would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that.
I think that they're going to have to waive the conflict of interest in their final, in their ruling when they come up. I think the Supreme Court might say that he has to waive that.
Yeah, I do too. But I want to keep going because there's a section in here from the other judge that talks about bringing back Rozzi and Baldwin and pretty much starting over, and then she could have a hearing to disqualify him, and I want to hear that part.
Okay, we'll roll with it.
And I do think that you can waive, you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. And that the inadvertent disclosure of pretrial discovery has not the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rozzi developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask, with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for the counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say for example the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge can have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice-only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October, and when the judge said it in October of 2024, one of the lawyers, I believe even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rozzi back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on a rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, through the ordinary appellate process. And third, on the merits, In removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that two different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing, we don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case.
Oh no! Oh crap, we lost Anthony. Okay. I think it's the way that the screen recorder recorded that there's an echo, and I apologize. Okay, here I am. What a day. Here he comes.
What's up?
Hello? I lost the recorder too.
I know, I seen that. So I had to just grab it. I'm looking for it right now. Recorder.
The echo is the courtroom mics. Okay.
Yeah, it is the courtroom mics. It's not us. Here it is. All right, so we want to get to that part where we were at.
Yeah, because I know it's coming up where they start talking to him about.
Is it him that they're talking to?
I think so.
With that, I'm butting that up against the Sixth Amendment constitutional right to counsel.
This.
And particularly when they filed the second petition.
It's the guy on the end.
Private counsel of their choice. That's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back to withdraw?
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel. What Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I look at Wheat several times as strong as what you're doing, and I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril, and this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court, one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief from the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So you're still you think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel, and on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can be any serious question that these kinds of claims for Sixth Amendment violations of the right to select counsel are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
and just
violation.
So I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent, so State versus Tippecanoe County? The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in 2 ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done, there's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking no hearing? No, I have the suspicion that this is going on. I think you're incompetent, and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rozzi got together with their client and drafted a letter. On the 12th, Mr. Rozzi filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rozzi said, I've got a life outside of this case. I've got a life outside of this courtroom. I have family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of his actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
I do know, because she said then at the hearing on the 31st, what's changed. So, which means...
Well, we won't know what would have happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rozzi. Mr. Rozzi himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial Is counsel
I keep
capable of
getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys, and so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of word out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with a lot of different people playing, in the Wheat case. I don't think Wheat is tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But where can you point to me saying, with regard to saying somebody is incompetent or negligent? We have a string of cases, so these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it's certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side. I think your position.
Well, Your Honor, our position is, under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, Wheat went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings, and it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise a speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold conditions preceding for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel, we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was moving counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly, on this record, has engaged in conduct that's detrimental to his defense.
Okay, Anthony, so did he just say, and this is the part that I think I guess I wanted to hear.
Okay.
She could come back, and she has to speak to Richard Allen, make sure that he's aware of all of this, and then waive his rights for ineffectual counsel?
Yeah.
Okay. And I think the next part here might be the part where he asks about, or one of them asks about, then could she have a hearing to basically throw them off the case again and do it the right way?
Okay.
All right, I'm going to play it and we'll see.
All right.
I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you, Mr. Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen's counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstate counsel, and if the judge is correct, then that will weed itself out. There'll be a hearing, and it'll be done a proper way in the trial court, and then come back up.
The state shares the concerns, most especially the Attorney General.
Okay, that was her question, correct? Did I hear that correct?
Yes.
So that Judge Rush, the Chief Justice or whatever, she is saying that if the judge truly thinks that they are ineffective and negligent, she could have a true hearing and make that determination.
Yeah, is what it seems like.
Yeah.
That's exactly what it seems like. So, I mean, if they're saying that so that means that the judge has the opportunity to still file and have the hearing and still basically say the same thing and kick them off the case if she wants. Do you think that she'll do that?
Not I wouldn't, but who knows what she'll do. Because then they're going to come after her really for bias. And
yeah, I don't think she would. I think she'd just go ahead and leave it as is. And just be like, all right, go ahead and represent him. See what you guys got going on. But if they did something else, then that's grounds gone.
Right.
That's probably why they want to hurry up and get the trial, because they just keep screwing up.
Right.
You know what I mean? I mean, that's just what I think. I don't know.
Yeah, Legacy, that's what I got out of that.
Delphi murders. I am posting on X right now. If you follow me, it's at TC_investigates on Twitter.
Oh my goodness. Okay, do we want to just finish this out, or what do we want to do? Because that was the part that I was waiting to hear.
Yeah,
I didn't realize. I don't know.
Let's see. We're at 45, and it goes to. Let me see how long it is. All right, we're at 45:56, and it goes to 100. So 55. Yeah, it's long. It's almost another hour.
Yeah, we're okay. We can stop playing it.
Yep. So we can stop playing it right there. I thought about. Are you done streaming? Are you good? This has been a long day.
We've been on almost 10 hours.
We have to be 10 hours. We have to make it past that.
Okay.
We have to make it past that. So
how about we answer some questions for a bit?
Okay. Yeah. Questions from the chat, everybody. If you got a question, if you guys want to super chat or highlight your comment, you guys can do that. That helps support these channels. And if you don't have the means to do that, you can still ask a question and we'll answer them. Just whenever a super chat comes up, we will answer those as a priority. The Weineke Law Firm also posted something else on Twitter. It says, what a whirlwind of a day. After an argument, Mark and I predicted the outcome based on how things went. But we did not predict an answer so soon. That was a blessing. Even though we did not get everything we requested, we are pleased with the outcome. Mr. Allen has had a difficult time throughout this case, and I hope this outcome encourages him to keep fighting, because I know Andy and Brad will.
Oh, we got a caller.
Mm-hmm.
I think.
I know it's not working. Your devices are not connecting anymore for some reason. So yeah, so you guys got any questions? Let us know. We're gonna stay on for another 10 more minutes so we can like get past the 10-hour mark, just to say, man, I did that once.
Yeah.
January 18th, 2024. Where was I at that day? I have an alibi. I was live on YouTube.
My husband came home and he's like, "You're still alive?" I'm like, "Yep."
Yes. Be like, dude, you have no idea. You're gonna have to sit down and watch all of this 10-hour stream.
Yeah.
Tell him, say, hey, as soon as I get off this live stream, we're gonna go back and watch it.
Legacy says, "Be right back. Going to reboot. I'm in for the whole 10 hours, guys." Aww.
Yep.
And we got to thank you guys. It's been a long stream. A lot of you were here in the beginning, left, came back. So we appreciate it.
And new updates have happened by minute. By the minute. I mean, we have had a fantastic day live streaming. Yes. I'm anxious to see how many people have actually tuned into the stream today. Once we end it, we can check the analytics and let you and find out. Mr. Marv rewatch. Yeah, there you go. There's one of your members only. You have to sit his ass down in front of with some popcorn for 10 hours, and he's going to sit there and watch us talk Delphi, and he's going to be fully in the know. And at the end of that, if your husband has any questions on Delphi, me and that man need to talk, because I'm going to be like, listen here, sir, Mr. Marv, You cannot you cannot not know what's going on with Delphi if you watch this 10 hours of
He
stream.
said he
You
was
are fully,
following us throughout
he's
the
following.
day. And
Okay, I'm gonna
he
quiz.
knew
You're gonna
what
pull
was
him on
happening.
here. You're gonna pull him on here. I'm gonna quiz him and be like, all right, man, what happened to Richard Allen today? What happened to his charges? Are you satisfied with today's hearing? That's a question. Are you satisfied with today's hearing? I set up a poll on my channel asking everybody if they were satisfied.
I am.
I am too. I am too. Zav Girl asked me that earlier. Was I satisfied? Was I happy that they were back? I'm happy that this case can move forward with no more stuff and it's not taking so long. I was really nervous that it was going to take a long time, right? And it's just, I don't know. I'm excited that we can finally get back on track and get back to the case. Okay, now here we go. They're going to have to stick with this Odinism theory, and they're going to run with that and see if they can convince a jury to see things in those crime scene photos that are not there. Wonder how well that's going to work as their defense strategy.
Andrea knows my husband. He would rather watch Curse of Oak Island, which he sleeps through half the time too. So,
oh, it's funny. All right, so I ended a poll on my channel. It hasn't updated yet. Let me see where it's at. Live chat.
Awakened by the Looking Glass says, I want to scream at the top of my lungs. I don't know, y'all. I know.
I don't know.
It's been that kind of day.
There it is. Are you satisfied with the Supreme Court's decision to keep the judge and reinstate the attorneys? I did a poll, and looks like 70% said yes and 29% said no.
There you go.
Yep. Wow. Are we going to get close to the 70? No. We're not going to get a speedy trial at this time. You know,
well, now the judge has to make room in her calendar for a trial.
Well, depending on, okay, so here's what's going to happen. They're going to have another hearing.
Yep.
And the hearing is going to be set probably sometime in the near future, within the month. Okay. And they're going to go to hearing in Richard Allen's case in Delphi again, or maybe they'll do it in Allen County. I'm not sure. But that's when they're going to formally go on the record in the case and say the Supreme Court has issued an order reinstating the former defense attorneys. Therefore, William Librado and Robert Scremen are withdrawn from the case on the court's own motion. And the court will talk to the prosecutor and the defense counsel, and they will come up with a scheduling date to reset his case. They're going to reset it, I guarantee it, and start it over, and he'll go to pretrial, final pretrial, blah, 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 which is going to give them probably, honestly, I think it's going to give them another three months. If they're shooting for 70 days, I'm seeing it 3 to 6 months.
Yep.
Yep. But I mean, geez, dude, this is okay. So today, what is the most shocking thing that you heard of today? Most shocking part of the day.
Decision.
That there was a decision so fast.
Yes.
Okay, what's the second most shocking?
The extra charges.
Those are my two top. I'm having the extra 2 charges. I'm not surprised that they reinstated him and kept her. I think the extra charges and the decision so quickly.
The fact that there's 4 extra charges.
4 extra charges.
Yeah.
This is nuts. So now I anticipate we're going to see more motions filed about that as well. And I think they'll predict it's going to be written on the Constitution of double jeopardy law.
Yeah, so in a way he won, and in a way he lost. So
in a way he got kicked in the nutsack.
It kind of evened itself out.
They did, dude. It's like
for Richard Allen. I mean,
he's out there going ha 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 ha, and dude walked up behind him and just went whoosh, right to the crotch with a kick.
Pretty much.
Yep, that's exactly. He's like, oh, you know. So I bet when he was watching that, if he's watching any court TV and they're talking about, oh, he's probably thinking, man, that Supreme Court hearing was good. 5 minutes later, charges filed against Richard. What? You know what I mean?
And it's
He might
not
have known those charges were filed
it's
already.
not going to be double jeopardy. I'm telling you, those are two separate murder charges, and they're all going to stick. They're keeping them all.
It's going to be interesting to see how that plays out. I think
Yeah.
but I think that's going to be the next argument on the defense.
Oh, probably.
Probably. That's what I think. I think they're going to argue that.
And then is the prosecution finally going to play the death penalty card?
Nope, they can't. They have to file intent to seek the death penalty, I think, first. Notice of intent.
I thought they did that a long time ago.
No, they didn't file a notice of intent to seek the death penalty. They have to file that to seek it. They got to say, we intend on filing for the death penalty. That way it's real. Everybody really gets that out there. Now, if they do file that now, that the case has been reset, it'll reset a lot of more other stuff too. It'll take a lot longer to get to trial because the defense team is going to have to really break down and start working harder because he could be killed, if they lose. So that's when they have to rethink things.
Yeah.
They want to play hardball with the prosecutor. He ain't playing. He is not playing, everybody. Nick McClellan is not playing with them.
No.
He straight laid it all out there today. They intend on.
Even Carly says she's like, that's probably coming.
Yep, that's what I think.
The death penalty part.
Especially since they want to play around so much.
Yep.
And cause all this drama and make all this, delay all this. What if this was a defense tactic? They're like, oh, we caught that prosecutor on his back heels. But the prosecutor was like, the defense was the one screaming, they haven't given us this. They haven't given us this. They haven't given us this.
But
So,
I told you, the defense waits till the last possible minute to give it.
Yeah. Well, the case is going to have to be reset. What do you mean? The case is going to have to be reset when they go back into court because they have the new defense attorneys are the ones that ask for the continuance. And that's when the judge granted. Yeah. So since that happened without these guys being on the case is going to have to be reset and reset for different hearings. So that's what it's going to happen. That's what I mean. It's going to be reset. It's what they call it. They call it reset the case. You start over, basically. You start off with different hearings. What are we doing from here? We're going here. Okay, then we're going to go to that hearing and say, are we still at that point where we're moving forward with jury trial, or is there some sort of negotiation process? What's happening? That's what happens. And during that time period, there's motions filed, depositions given, evidence submitted back and forth between the parties, and so forth. That's what I mean by reset.
Wow.
It's interesting, isn't it? So, how long do you think it's going to take for them to get back in court?
Not very long.
Not very long? How long do you think?
I would think within a month.
Within a month. I'm thinking so too. I'm thinking that Richard Allen's going to be back in the courtroom within a month. Is there anybody that wants to go and film it? If you're in Allen County or in Carroll County, we would greatly like to have that footage of you going there and filming that.
Yeah.
Okay. And thanks to my friend Devin for going to the courthouse and letting me know what was going on. And thank God for the news people that was standing there that happened to catch him coming in the courtroom. They only got one little shot of him, So that's pretty cool though. Thank you, Devin, for doing that, dude. For going there. We appreciate you, dude.
We appreciate
I don't know if you're watching still, probably not, but thank you. We appreciate that. That's a lot of work just to go there and let me know what's happening. Okay. Thanks,
He's like,
dude.
these people are crazy. They've been online for 10 hours.
Probably 10. We made it, everybody. 10 hours.
We made it to 10 hours.
We made it to 10 hours. I'm going to snap a photograph of that and send it to Zav Girl. I'm be like, we made it 10 hours, lady. Watch.
Wow.
I'm going to take a photograph. I'm going to be like 10 hours later. Here we are, ladies and gentlemen, still talking about Delphi.
Yeah.
All right, cool.
Oh,
So,
hang on, Marv. I got to
anything
say, March, check your texts.
okay. So tomorrow, oh yeah, we need to see if there's, oh yeah, that one thing. Hold on, I'm going to look it up. All right, so I'm looking up something right now to see if they have the final information posted online for the Indiana Supreme Court.
Oh, yeah.
Published order. Nope. So they've only got the one order. That's the order. It's there. So it's the same thing. So they haven't issued their brief yet. Wait, hold on. How long was yours? Okay. Are you clicking?
I am.
Okay. I'm like, what's that noise? A long day. It's been a long day. Man, if this isn't a day on YouTube, holy shit.
No.
I am ecstatic.
I can't spell briefing right.
Yeah, briefing. Just B-R-E-Fin.
It was Brufin.
Oh, yeah. I just typed in as like
Supreme Court Brufin.
Briefing. Yeah. The Supreme Court briefing, everybody.
Oh
This
my
was cool.
gosh.
So let me ask you a question. Do you like the layout that I did today?
I do.
Do you? I think it's pretty cool looking. Especially with like the new developments and stuff like that pops up on the screen. I don't know. I set up and made this last night. Carly's like, are you assuming you're in bed? I'm like, nope. I'm working on this thing for tomorrow. And it's like past midnight. And she's like, man, you better get some sleep, dude. And I'm like, I know. I need to get some sleep. But trust me, I got these things. I got to make these things. You know?
Yes.
So,
I got to say thank you to, what was your friend's name?
Devin.
To Ed Bounds for coming on and talking to us. To Andrea.
Zab Girl
for coming on. Jinx for sending us documents. Andrea for sending us documents. To the mods.
Zab Girl.
You know, Carly, Jinx.
Carly moderating.
Yep. Carly.
Yeah, and everybody that participates.
All of them for my channel. Thank you so much, Andrea, for modding on Facebook and YouTube. So
yeah, for modding on Facebook and YouTube. There you go. Case by Case, Amy. I want to thank her for that. Jennifer, Tabitha, Zav, Miracle Hearts, Zav Girl again. Sarah Lopez.
Absolutely.
Keeping eyes peeled. Misty. And Miracle Hearts. Thank you, everybody, for the super chats today. And if you've made PayPal or Cash Apps or anything like that, we appreciate that too. I don't have access to see it until we get off of here. Thank you very much for tuning in to us. And if you have any questions or comments, let us know. And I'm going to be taking shorts from this and trying to post it all day long. Or I'm going to run it through Opus Clip and let it do it itself.
Yeah.
Mm-hmm.
Join us tomorrow because tomorrow is going to be just as fun. We're going to do Flora.
Flora.
Do not miss that.
The Flora Fire.
Everybody. Flora Fires. Do not miss tomorrow. Yes, we're done.
Yeah, it's been a long day.
Been a long day.
It has been. It's been a long day, and the Supreme Court has ruled. They've reinstated the attorneys, Andrew Baldwin and Bradley Rozzi, and they've kept the judge on the case, and they have issued no speedy trial at this time. The judge can file to still find the attorneys grossly negligent after a hearing if they want. However, we don't know until they get back in court. So as it stands, everything goes back to the way it was prior to all this dilemma. And Mitch Westerman is set for trial on March 6th.
Yes.
So if you didn't watch earlier, go back, watch the live stream, watch our live reactions, see how everything goes on, and you guys will be totally in tune for this. Yeah, you guys will be totally in tune.
Legacy, I agree. All the information we learned and how quickly has actually worn me out.
It has. It has worn me out.
Yeah.
This wore me out big time. So let me go grab. Actually, you know what? Let me pull something up first before we leave. Okay.
I'll get back to you, Andrea.
On what?
Time tomorrow.
On what time? Oh, on what time we're gonna go live?
Yeah.
So we're going live on Flora.
Probably 7 my time, 8 Indiana time, but I gotta talk to some people before I confirm that.
Okay. I want to pull up. I think this video is what it is.
Yeah, if you want information, come to us. We'll give it to you. Goodness gracious.
Yeah. You know what? I found something I wanted to show you or show everybody.
Okay.
So let me see here. Do you remember? Let me go back. Right.
I remember what?
Do you remember this right here?
Uh-oh.
Here it is. I don't know why it's not showing this on here. Hold on.
Because you're still playing
What?
the other video. You're still
I know
playing
I'm playing the other. I know I'm playing the other video, but I can't. I forgot to share the screen. Here it is. There it
If
is.
that doesn't tell you we're done, I don't know what does.
Yeah, I know, dude. Here it is. You remember this? You won't be able to hear it. I don't think there's any sound to it at first.
We'll show it on the thing. Oh my goodness.
Are you showing it?
Oh my
Can you see
goodness.
it? Are you
Yes,
showing
I
it?
do. Yes.
Okay.
This is when you and I first met.
This is the second time we met.
Yeah. This is the day with the snake.
Yes, dude, the snake. Oh my gosh, I forgot about that.
Remember the little snake and I went to bend down and it hissed at me?
It's like, oh, a snake.
I took a stick and flung it in the woods.
Yeah, there was a
And
snake
then
there,
you
right
came
there by
along
that.
and I was telling you about it and you're like, I hate snakes.
Yeah.
Yeah.
Okay. So that sign that we're putting in there.
Yes.
That's the sign I used at the bottom of this thing. It's a sign you see
Yes.
a lot. Man, I made that. You know what I mean? Like for them for that. And
Oh.
it's cool to see it like on so many different. Oh, look, we can hear it now.
Yep.
We can hear it now. It's just cool to see that thing still out there that people use.
What? You are all muffled.
I'm muffled?
Oh yeah, now you're okay, but you were. Oh my God! Look,
Oh,
I
okay.
had
It's
long
because I was playing this
hair.
video. I know. That's why I was taking
long
people back to listen to this.
Go ahead.
Marvin. You can see all of me this time instead of just my eyes. Today we drove up from Wisconsin yesterday, and this morning we got out here about 12:30, and I came down and cleaned up the memorial and rearranged it a little bit. Took out the old flowers that were still in the sleeves so that it's not getting everything yucky. Just rearranged, and my plan is I want to get some brick pavers and make a box next to the sign and put some mulch down, and then be able to put all the memorial stuff in the box as a memory box. That way it looks a little bit better for the trail system and everything, rather than everything laid out here.
Remember that? This is such a
I
good day.
do. Oh my goodness.
Some lost footage, everybody. This is some of the memorial walks.
This is awesome. McDonald's free coupons. What's that?
I don't know what that was.
No, we never let anybody walk alone.
Right.
That's him. That's
There's
him.
Bob.
You know, he fits it. It's him. The red flag. It's him.
This is why we're here, everyone.
They may have just mentioned him because of Chadwell. Yeah, even though he's that's why even though he's a person of interest, but he was actually for another situation that was happening, and that person just said, "Well, hey, he's a guy to look at."
It's in that category.
Yeah. When I first saw him, I thought the same thing. He lined up. The photograph lined up.
That's why that photograph was
and then the part where sexual crime was trying to come in, and it's all fit. But then the more you start dealing into him and stuff, it's like, all right, this guy's losing ground fast.
Oh yeah.
And you don't want everybody's called this case. We want this guy.
Yeah. And that guy there, even though his face was posted up as a drawing,
right,
he was just a person of interest they were wanting to get a hold of.
Well, Anthony did a thing here a couple weeks ago about.
Yeah, so I don't know. I just wanted to pull that up and show you guys. You know the
I haven't
video.
seen that in a long time.
You haven't?
No, it's been a long
You know
time
what?
since I've seen that.
It has
Zev
been a
girl
real
says you're
long
about to break my record.
You know what?
Oh,
We are about to break that record.
what was
Right?
hers?
Hers, 10 hours, 31 minutes, and some seconds. What did she say? Hang on. Yeah. Hold on. She said it's 10 hours, 31 minutes, and 58 seconds. So 10 hours and 32 minutes would beat her, and she will pass the torch. It'll be like a ceremony. You know what? I'll beat that because this is gonna be so cool.
I gotta know.
She's gonna show up, dude, in like the king and queen, like the queen outfit, right?
Yeah.
And she's gonna walk up to this thing on a red carpet, and I'm gonna be standing there with this look like, right? And then she's gonna hand over the robe, and then I'm gonna get a king's crown, and I'll be King Greeno, king of live stream with Marv. We went beyond the evidence today.
We're losing it. I don't know if we can make it 16 more minutes.
How many more is it? 16? Oh, we can do it. 16 minutes. We got you, Zav. Come on, girl. Come on, live stream, Zav, and let's talk about the Supreme Court ruling. You know, the power of Zav. Come on. Come on here and let's talk. It is fun.
I'm dying.
I'm
rooting for you too, she says. Oh gosh.
Yeah, it is cool. It would be really neat. It's going to be really cool. I don't know. I just think it's really cool.
Yeah.
I'm excited. I'm really excited about all this. This has been a long day for me, for you, and for everybody that follows the Delphi community. But it's been a productive day. We've learned a lot about this case today.
We have.
A lot.
We really have.
I mean, I've learned a lot about it today. I learned a lot about Supreme Court today. I think that I love the way that happened today. I liked the way it went in there. There was no playing around. It was straight to the point. Everybody was very talkative. They were on their ball with the case law and the way they responded to the judges and the justices. And the justices were good in the way they presented themselves. It was very professional today.
And to have a decision within 2.5 hours. Wow. That's
and we expect written conclusions coming up later on explaining their reasoning for this. So
Right.
at some point they'll issue that. They may issue that tomorrow. They may take the day and be like, we're going to write this up and then we'll explain it all. So I think each justice will probably take the remainder of the today since we don't have an order already. They could issue one later tonight. They are known to do that in the nighttime. So I think at the latest, maybe tomorrow, we'll see an update on this case regarding the actual findings from them. So expect more information tomorrow after we do the flora, or if there's comes up during the day, it'll probably try to do it during the day. When are we going to do this live stream tomorrow?
All right, hang on.
Okay. So we're going to find out when we're going live tomorrow, ladies and gentlemen, as well. And while we do that, tomorrow is going to be the Flora Fire case. And if you guys haven't watched the Flora Fire video, I would suggest going there and watching it like sooner rather than later, because you need to be fully in the know about the case that we're talking about and what's going on with that. Marv has a live stream previously that discusses this case in particular and the happenings, the most recent happenings regarding the Flora Fire and the Flora 4 Foundation. So go check those videos out to be fully in the update. Okay. And I'm looking for what is it?
So we're going to do 8 o'clock Indiana time, 7 o'clock my time.
8 o'clock. Okay. 8 o'clock Eastern time, everybody. 8 o'clock p.m. Eastern time on both channels, right?
Yeah.
We'll be talking about Flora tomorrow.
And we've got special guests coming on, so.
Awesome. I'm excited for all this.
Yeah. You better get some rest now.
I don't need that. I got stuff to do.
Can you make us a thumbnail for tomorrow?
For Flora? Yeah, I'll make a thumbnail.
A live stream?
Oh, yeah, and another live stream and set it up. It's going to be rough. But you know what? I'm not doing anything tomorrow except Flora tomorrow night. And I don't have to make a video for it, so that's relieving. Today was a good day. I may end up going live in the daytime anyway and discussing just what I think after thinking about it for a night. You know?
Yeah.
And if there's anything that shows up during the day with the Supreme Court, then I'll definitely put that out there. And we can talk about all that. So where are we at? 10:18? Come on. Where's Zav at? Zav, come on here. 10:18. We're almost there, everybody. We are so close to.
Jinx says, thank you, Greeno.
You're welcome.
Marv, you're welcome.
Yep,
oh,
you are welcome.
Question. No, nothing's a dumb question. But what are the chances RA would get a plea deal and there's no trial?
Oof. I can tell you there's a 100% chance that the prosecution is going to offer him a plea deal. 100% chance that they'll offer it to him. 50% chance on whether he takes it or not. You? What do you think? What do you think?
I would hope that the prosecution would ask for the family's input before they offered a plea deal and have the family accept the plea deal before offering it.
Okay.
That is what I would like to see. And if the family does not agree with the plea deal, then it's not given.
Well, I mean, what kind of plea deal do you get for that? I mean, life in prison for each one, 45 years minimum on each one. I mean, serves 85% of that is what, 30-something years? Well, Richard Allen could live to be in his 80s.
It's not enough in my book.
Not enough. Not for 2 and not for what I saw.
No.
It needs to be 100.
D. Berlin, it's at 8 p.m. Not 8 a.m.
No, nope, absolutely not. There's no way. Ain't happening.
I gotta work tomorrow, yeah. Want to hear some Indiana Marv stories to pass the time? Don't you dare. Oh. I'll tell you a story about Marv in Indiana, okay? I always use the GPS to get where I need to go, right?
Okay.
Now, how many times have I left the place that I'm staying at and driven to the Tipton City Park? Quite a few. Do I ever take the same route? No, because the GPS always takes me on a different freaking route. So I still don't know how to go from the place I'm staying at to the Tipton City Park without the GPS.
Oh my gosh.
And it doesn't help even when Andrea's mom gives me directions because I still make wrong turns. That's my story, and I'm sticking to it. Oh.
Holy cow. Man, you know what? I have a good sense of direction. Once I figure out where I'm at, I can figure out, I think I'm pretty good at it. I think Michael Catt helped me with that, like learning in the woods and stuff.
Oh, yeah?
Yeah, I mean, because we'd always go out in the woods and stuff, and just like hike and check things out and explore and look for tunnels and animals and stuff like that. And it's like, he really had me out there. He is someone that I wish could have been here for all this. This is just amazing that it's come to this point with this whole case. You know what I mean? And like, that was my dude, best friend, YouTube partner forever. And like, if it wasn't for him, I wouldn't be in talking about this today. So really thanks to him, I'm here today. So, shout out to Michael Catt still. He rest in peace, dude.
I often wonder what him and Bruiser would say.
Bruiser would be freaking out right now. They would be freaking out, dude. Catt would have flipped a lid. I'm telling you, he would be pissed. He would be like, there's no way this Odinism, dude, he'd be up there with me. He'd be right in their face. I know it. He's just like me. He's like, whatever, dude, get out of here.
Yeah, I just often wonder what Catt and Bruiser would say on a days like today. How they would flip out just right along with us.
Yeah, geez, I know. We've lost so many, and Sean Harmon, we've lost so many people. I mean, and some of these people, they have bad reputations and things like that. But deep down inside, Sean Harmon, it was just a guy with some addiction issues and some mental health issues, but he was a good dude behind the scenes. I interviewed him for 3 hours one time on why he thought the Delphi suspect was his dad. He passed away last couple years ago, and Catt did, Bruiser did. If some of my fans have passed, one of my moderators, Bamarama, a few years ago, was a moderator for me for 3 years, and she died of cancer. And it's like, I didn't know what happened to her. And then finally someone from her family reached out to me because they saw her mouse pad was something that I made, one of my merch. And they reached out and they're like, oh, we remember she used to like to watch you. And they let me know that she had passed away. And I was like, man, I'm sorry for that. And, Penny, remember Penny? You remember Penny? Oh, you weren't at,
yes.
Oh, yes, from the March for Justice.
Yes.
She passed away too, her son. Yeah. That's so sad. So we've lost a lot of good people in all this.
We have.
But we've gained a lot of good relationships throughout all this, and we've lost some relationships in this, but we've gained a lot more, and a lot more good has come out of all of this than bad. And sadly, it's all because of 2 girls lost their lives.
Right.
But a lot of good has come from that, and they're setting case law now, precedents.
Yep.
This is history, all because of Abby and Libby. Yeah.
It's all part of their legacy. Look at all the C-SPAM stuff that's going on because of this case, and
unsolved murders
and convictions, and
and other investigations that it's led into. And potential leads for them, like the Stevenson case, the Jordan Sofer case, Iowa, you know what I mean? Thomas Bruce, like all those different cases, everything has come up because of this. So Abby and Libby, by tragically losing their lives in the manner that they did, have opened up a window for other victims to have some exposure, investigation, and being looked into by law enforcement. That makes me happy, man, because that's the whole basis of my channel. When we always say those shirts, be a voice for victims of unsolved crimes.
Yes.
This is how we do it. This is probably my highlight of the year right now. Delphi.
Oh,
This
absolutely.
today, January 18th is right now. I see this as the biggest stream of the year until he goes to trial, unless something crazy happens. This is regarding the Delphi case, is what I mean. But I think that there may be some other cases out there that come out, and take publicity away from Delphi for a while. Idaho seems to be one of those.
Oh, absolutely.
Yep. And I don't know when he's going to court, but I think that we might actually see Richard Allen in court before him.
Yeah, it's possible now. Yeah, absolutely.
Yeah, Koberger, whatever his name is. So after all that,
Carol, they have not determined a trial date. Well, they have one, but they're going to have to make a new one. So
correct. Yep. I can't hear you at the moment. Oh yeah, you just have to go back out and come back in. Let's talk about a July 4th party.
We won't talk about that.
Yeah.
Yes, and Rex Humerman, he got new charges too. So lots of big things happening.
There are a bunch of cases, and I want to go back and cover Jamie Valdez. Marv, you want to go to Arkansas?
Absolutely.
Yeah, you want to go to Arkansas?
I would love to.
I went to Arkansas with Caitlin Warner. I almost said her. I mean, I don't know if she wants to be called that or whatever. She's been on my channel as Autumn. So Autumn, Caitlin. Her and I went down there to Arkansas to search for Jamie Valdez, who was missing 12 weeks at the time. Remember, we uncovered some evidence and stuff, and then was able to ping his cell phone, but he's still missing, and his sisters are still seeking justice, and they're still in the chat.
She's she's part of Beyond the Evidence group.
Exactly.
She keeps in touch with me.
Yes, we need to cover that case again, and I need to make another video and get some more footage and stuff like that, and try to recover those old interviews. So
I'd like to go do a search.
Yeah, well, we did one, and they can do it again. We just got to get the police chief to agree. It's a small town called Boonville, Arkansas.
I'd like to go do a search.
Former sheriff there worked right alongside with us. He wasn't even the sheriff anymore. He's out there running around with me, Caitlin, and the families, and we're out there digging up clues ourselves, aside of the police department.
Yep.
Legally, like going out there and collecting evidence and submitting it to law enforcement. Tracking down leads and suspects, searching, found evidence. It's an interesting case, everybody. It's very interesting. Interviewed his wife. It's a case that needs exposure. Abby and Libby are not the only case that we cover on these channels. We respect Abby and Libby to the fullest, and we pray for justice for them and every victim, really.
Yep.
Every single victim deserves justice. Someone else sent me a letter.
Exactly.
Marv and I had an email, a pretty long email to decipher through from that individual who sent that. I'm not going to say that person's name, but yes, that is something that I was reading through, not last night, a couple days ago before I started on this Delphi project. I was just happened to go back and reread that again. A very interesting story where you walked past a crime happening and didn't realize it and try to recount the memories from that.
Yeah.
So that's a case that I'm going to be talking about in the future. Okay. And if you guys go check us out on TikTok as well, we're trying to figure out how to live stream to TikTok as well.
Yep.
Right. And stuff like that. And let us know where you guys typically follow us from. If it's YouTube, Facebook group, Twitter, whatever. And if you don't follow us on those, the links are in the description below.
You get betcha.
Yeah, we have 2-minute countdown. Okay. A 2-minute countdown. And what is that? What's going to happen in 2 minutes?
So 2023, I was so glad that the Natalie Holloway case got closed. What I would like to see in 2024 for older cases, John Benet Ramsey. We got to get that one closed.
Didn't that guy admit to it? Yeah, some guy admitted to it.
But they haven't arrested him.
Yeah, I mean, it could be a false confession, I guess, but why would he just admit to it? But then again, I've had people calling to admit to Delphi case to me. So yeah, I guess I can't say it. Nobody does that because people do that.
Yep.
Hold on. Let me pull this out and I'll be right back.
And of course, I would love for the Tabitha Shuck Raines case to get solved and figured out, somebody held responsible for it.
To get some justice. Tabitha. Yeah, I
Yeah.
know.
It's been over 21 years for her, and she needs justice too.
She does. And if you haven't followed those cases, Marv's got extensive episodes and even a whole page for that. So if you guys follow that and follow Mark, her stepdad, and her mother, who are advocates for her, Tabitha
Yep.
Tipton, Indiana, south of Kokomo, north of Indianapolis, north of Muncie, you guys will be, and Ashley Morris Mullis.
Yes, that's another one we gotta dive
Yeah.
into.
Yep. For Don, Don and her mom. They have just been.
We need to find out what happened. That woman was arrested.
Yeah, I know.
But I haven't heard anything else.
We need to look into that more. And there was closure up there in Michigan too for our old podcast friends.
Yep.
Yeah, I'm glad that they seen some closure in that case and
I
finally
am
got some
too.
convictions and it's all done. That makes me happy for them. I wish them the best on that. We did it, everybody. We made it for 10 hours and 33 minutes. We have beaten Zavgor. Hold on. I am going to
make sound. Do something cool.
Yeah, hit the party symbol, everybody.
Yay! Throw party.
We beat you. We are officially at 10 hours and 33 minutes and 14 seconds, Zav girl. I'm going to send her that. Or post it as a short.
There you go. Post it as a short.
Post it as a short. There it is. I'll post it as a short here after this, everybody. So, and then watch her be like, oh, wait a minute. I was wrong. It was actually 10 hours and 34 minutes. And I'll be like, no, dude. She could get me like that.
All right, everybody. Sending out all my love. Mwah! To everybody. It's been a wonderful day. Thank you. Thank you so much for joining us. Remember, justice matters in every case.
In every single case. And on that note, everybody, I'm Anthony Greeno here at True Crime Investigates. Thank you for tuning in to us today, all day, for the Delphi murders exclusive coverage on Mitch Westerman and the Supreme Court hearing. I appreciate y'all. Until next time, keep it Southern style, y'all. Bye.
Bye.